business of the House. I inform the House that I have not selected any of the amendments. To move the motion, I call Sir Oliver Letwin.
Thank you, Mr. Speaker. I'm very grateful to you and to the House authorities for the organisation that you have tentatively put in place for today. But, of course, that organisation will only be able to operate if the House approves this business of the House motion, and I rise to move that motion now. And I'd like just to begin by explaining in as plain English as I can the two paragraphs of which it consists, neither of which is in any way complicated, but both of which have been drafted very carefully in order to ensure that the business proceeds smoothly and in good order as we go through what will no doubt be a quite complicated and highly contentious set of discussions about the substantive motions that have been tabled and which you, Mr. Speaker, have not yet selected amongst, but which will no doubt fall to be announced as a series of selections after we've completed the discussion and votes on the business of the House motion. So paragraph 1 is an effort to order today's business in an orderly way, given that there may be a considerable number of substantive motions that are selected by the Speaker and that will fall, therefore, to be debated and at 7 o'clock, if the business of the House motion is accepted, be voted upon. And I draw the attention, therefore, of honourable members first to subparagraph I in paragraph 1 of the business of the House motion, which describes the method of voting. It is the intention that in order to avoid taking too long voting on the substantive motions, we should retire into the two lobbies. There will be a lobby, I lobby, devoted to those whose names begin A to K, and the no lobby devoted to those whose names begin L to Z. And there will be in those lobbies voting slips, I think of a different colour, but very similar in character to the deferred division slips which we've used today and are quite used to using, which will be in a bundle and which will relate to all of those motions within the order paper motions for today that have been selected by the Speaker for vote at the end of the day. Of course I will.
The right honourable gentleman for giving way. It's just a general point. I don't often follow tweets as being law and the way in which things will be, but I've just seen a tweet that has said that number 10 is going to indicate that it will vote against the business motion in the attempt of thwarting all the measures the right honourable gentleman wishes to secure at 7 o'clock this evening. Would he agree that would be a misuse of parliamentary time by the government, given the will of the House only yesterday or the day before?
Well, I don't know whether the honourable gentleman is reading a tweet that is, so to speak, a Trumpian tweet or an accurate tweet. I've followed the practice myself of not paying any attention to tweets of any kind at any time. But it may be that, as the honourable gentleman says, the government will decide to whip members on this side of the House against the business House motion. That is, of course, a perfectly legitimate thing for the government to do if it wishes to do it. It's slightly sad, given that those of us who've prepared the business House motion took great care to negotiate with the government a suitable way of including the statutory instrument which needs to be brought to alter exit day at the end of our proceedings, and that is provided for in an orderly way in the business House motion, and I had hoped that that degree of cooperation might induce the government to look kindly on this business House motion, but I'm perfectly aware that, as he is, that it was not the intention of the government to promote the indicative votes in the way in which this business House motion does, and therefore I understand that they may whip against it. I hope that not only the honourable gentleman, but also those of my honourable friends who voted for this process in the first place will again vote in a division, if there is one, to sustain the business of the House motion and to allow us to continue the process which we inaugurated by voting by a narrow but nevertheless significant majority for Amendment A, which stood in my name a couple of days ago. and I look forward to being in the same lobby as the honourable gentleman as we do that. Yes, of course I will.
The right honourable gentleman said it was a significant majority who voted in favour of his amendment. 329 votes to 302. That was 52% to 48%.
I have to say that I think the honourable gentleman's, my honourable friend's mathematics is perfect. And I observe that he has attached quite significant emphasis to the vote on the referendum result. And therefore, I hope he joins me in the view that the majority for Amendment A was indeed significant. And I'd like to point out to him and some of my other honourable friends who share his general views on these matters, which I entirely respect, that I, unlike he, have voted consistently and will continue to vote consistently for the implementation of that referendum result through the means of the Prime Minister's deal and through a meaningful vote number 3, 4, 5 and to infinity. I shall go on voting for the Prime Minister's deal in order to fulfil the referendum mandate, and I profoundly hope that he might change his mind and join me in the lobbies to do so when it's necessary. Yes.
For my right honourable friend to give way, thank you, Mr. Speaker. If there is movement towards MB3, meaningful vote 3, and there is some indication that there is, will he and his somewhat successful parliamentary insurgency work with the government to ensure that there is time, presumably early next week, if not this week, for a meaningful vote 3 to be back and presented to this House, either by way of a paving motion or directly? Thank you.
My honourable friend asks an entirely reasonable question to which there is an absolutely definitive answer. There has been no insurgency here. No, I will in a moment, but I must answer this point first. It's more productive to answer one point at a time.
Yeah.
I'm absolutely clear that this is not an insurgency at all. It is an adjustment of the standing orders for today, and if this is agreed for Monday, it does not affect tomorrow, nor does it affect Friday should the government choose to make Friday a sitting day, and either tomorrow or Friday, and I personally would entirely welcome this, the government may, of course, bring forward meaningful vote 3, for which I shall vote. I hope my honourable friends will vote for it, and I give him a further piece of good news, of which he will be easily capable of verifying, which is that should meaningful vote 3 pass on Thursday or Friday, there would be no further need for the whole of this process. This process has come about as a result of the increasing concern that many of us have had across the House of Commons that we were heading not towards an approval of the Prime Minister's deal, but, alas, towards a no-deal exit, which is something I pitted myself against for many months. And now, of course, I shall.
To the right honourable gentleman, and I'm very much enjoying the Letwin People's Parliament already. It's got much to commend itself, shall I say, to the right honourable gentleman. And I'm sure he finds it as astonishing as I do that the government are intending to vote against this business motion, because surely he'll agree with me that there was nothing to stop them bringing forward an amendment to his motion today, and there was nothing to stop them bringing an alternative business motion to the House today.
Indeed.
I promised myself throughout this process that I would be honest with the House, and I can't honestly say that I'm astonished that the government is voting against it. I have to say, although I regret it, I somewhat suspected it might be the case, as I suspect, in fact, he did. But I do share his view that it's a pity that actually the government didn't do what would have remedied what the government described as a constitutional oddity by endorsing Amendment A, and indeed at the right moment by putting themselves on Amendment A as signatories. They would have, of course, immediately under the parliamentary convention that you, Mr. Speaker, supervise, they would have arrived at the top of the order and superseded any mere backbenchers, and it would have become a government a government amendment, and all the ordinary order of the proceedings of the House would have been restored. That would have been the natural way to go. Alas, the government decided not to do that, and I understand they had reasons for it. May I just answer this, and then, of course, I'll come.
Turning to the subject my right honourable friend was on before, which is how we were going to be voting, can he say, or might the Chair be able to tell us, whether the voting papers will be available before we go into the lobby to avoid a great big crowd and the slowing down of the voting procedure?
Well, I'm sure that Mr. Speaker will want to say something about this at a later stage, but I believe that the House authorities, who've been may I just say, extraordinarily assiduous in this and have done way beyond their mere duty, will not only have provided for the relevant pieces of paper to be in the lobby at an early, or lobbies at an early stage, but also will have provided very large numbers of copies of the order paper, so that members will be able very quickly to refer from the voting slips to the actual amendments, so that nobody's in any confusion about what they are voting for or what they are voting against. Of course.
Right Honourable Member for giving way. The Speaker has ruled that no amendments will be taken, and obviously I wouldn't challenge the Speaker on that. But is not this today's business motion different from what was agreed last week? Because now you are actually, the Right Honourable Member is moving Monday as well, and the Amendment A in the name of my Honourable Member for Stoke has not been selected. The Speaker has not allowed these amendments. Surely now we are voting on something very different from what was agreed last week.
The Honourable Lady is absolutely right that paragraph 2, which I haven't, of course, because of taking interventions, yet had time to talk about, does indeed book a slot for Monday. And the reason that it books a slot for Monday is that I think there is quite a high chance that at the end of today's votes, despite the best endeavours of each of the promoters of each of the motions which it falls to be debated and voted upon, may not receive majority backing. And I said, if she will recall, during the, I don't know whether, maybe she wasn't present, but I said during the debate on Amendment A, very specifically, and it was a point echoed by many of her honourable friends in their remarks about Amendment A, that we all recognise that fact, that the first time round there would be very likely not to be a natural majority for one, I will in a moment, one proposition or another, and that therefore we should regard this as a process and not as a single point in time. And I did also specifically say that I therefore anticipated we would need a further day, and in many discussions and interviews, many of those of us who have proposed this Business of the House motion today and were supporting Amendment A have made that point. So there's no novelty to it. It is simply carrying through what we said would be the case. And now, of course, I give way.
To that point of intervention, would he not agree with me that the government, having spent over 1,000 days on getting to where we are now, it would not be unreasonable for the House to have more one day to try to resolve this matter?
I do rather agree with the Right Honourable gentleman about that. And I have to say, it isn't the main burden of what I want to say today, but I have to say I share what may be his regret, that actually about 2.5 years ago the government didn't take steps to create a cross-party consensus on this matter. The Irish Taoiseach did exactly that, and I think put himself in a much stronger position as a result. And I hope that when all of this is over, and as I hope we have arrived at some sensible way of dealing with the whole Brexit issue, that the nation as a whole will learn that lesson, and that we will realise that when we have great national undertakings, it actually makes sense to try to get a cross-party consensus about how to take them forward. I give way to the Honourable.
I thank the Honourable Member for giving way. Further to the point that was raised by my friend from Vauxhall, what assurances can we have that the business of the House motion that we will be asked to support on Monday will not also include another paragraph 2 that seeks to book a third day for indicative votes and then a subsequent motion? I believe the Honourable Member for Grantham and Stamford referred to it as daisy chaining in a briefing he had a conversation with. And if that is the Honourable Gentleman's case, can he be upfront about it? But could I also ask him, what does he think is going to change between today and Monday? Every member of this House has had an opportunity to lay a motion with their thoughts on the way forward. Every member of this House will have a chance to vote on an up-and-down straight vote, no knockout rounds. So will we not just repeat ourselves on Monday with the same potential options, the same votes, with the same arguments?
Well, I'm very delighted that the honourable gentleman, who's played an important part in these proceedings throughout, raises both of those points, because they're ones I wanted to come to anyway. Let me come to them in response to him rather than taking them later. In relation to the first question, whether there may be later stages beyond Monday, I don't believe that there needs to be any further round of voting after Monday on motions or propositions. I do believe, and I want to be very clear that I've said this to the honourable gentleman so that he can't later complain that there was any concealment at all, which is not part of our intention. I do believe that if a majority for a particular proposition does emerge on Monday, as I very much hope for reasons I'm about to come to that it will, and if the government doesn't immediately signal that it is willing to implement the majority view of the House of Commons at that point, and if the government has not by then, as I hope, though others may not, it will have achieved a vote in favour of MV3, then I think it would make sense for the House to move to the position of beginning to legislate to mandate the implementation of that majority. I think that would be a reasonable proceeding at that stage. It's only possible if we reach a majority view, of course. And now I come to the second part of his point, which is the question, why will Monday be any different from today? And I think the difference lies in two facts. First, this will be the first opportunity, and the right honourable gentleman who speaks for the Liberal Democrats made this point, after a very long time, when the House of Commons will actually, in an orderly way, have an opportunity to express the views in votes of members on specific propositions, and for us all to see how the lie of the land is. And I think when politicians do that, I will in a moment, when politicians do that, they very often discover that there is a basis for compromise and further informal offline discussion that can lead to the crystallisation of majorities. But in addition, it may be possible to structure the following Monday in a way that precipitates a majority, which it has not been the intention to do today. Today is purely indicative votes, and it's put today in a plain vanilla way, so everyone simply votes for all the things that they want to vote for and against all the things they want to vote against, and we will see what the numbers are. It's purely a first set of indications. I will now give way. May I give way to my honourable friend, because he made such a splendid case against me earlier.
Mr. Speaker, I was trying to compliment my honourable friend. I was just suggesting he should be sitting on those benches. He's making a very interesting and well thought out speech, as he always does. And he's being exceptionally honest with the House, saying that on Monday he will again be taking over the order paper. And that would then possibly lead to a legislative programme and a bill to implement whatever comes out as the most likely thing to succeed. Could he give the House an estimate of how many days he's going to have to take over between now and April the 12th, so that we can have a guide, and at least the government could have a guide when they might get some of their business done?
Well, I have to say that the coda in my honourable friend's remark was, I think, an amusement, in the sense that I don't discern a vast pile of other government business of the first order of importance currently being transacted in this House. I think the government is rightly focused, as we all are, on the question of Brexit. And we're approaching the 12th, as he and I both know, and as he mentioned. And he, of course, has a very different view of what would happen to our nation if on the 12th we left without a deal, and I respect that view. It is not my view. I don't believe it's the majority view of the House of Commons, as expressed in a series of votes. Those of us who are determined to follow that majority view, as conscientiously as he believes it's a good thing to leave without a deal, we believe conscientiously it is not a good thing to leave for our country without a deal, and therefore we want to prevent that eventuality. And the only way we can do that is by crystallising an alternative majority and trying to carry it forward, and that's what we will do. But there is an easy route to preventing that, which is for him and his like-minded colleagues, whose positions I understand, to compromise as many of the rest of us have compromised, and to vote for MV3. Were that to happen, none of this would be necessary. Yes, of course. Oh, I'm sorry. I haven't mentioned any more days than the days I've mentioned, because I don't think it were necessary to have any more days. Though, of course, in the House of Lords, if there were legislation, there would have to be a day or days to legislate in the House of Lords. Yes.
Thank you for giving. I thank my right honourable friend for giving way again. I apologise for asking. I'm trying to find out about this process, as I suspect are millions of people throughout the country. The reason I ask about MV3 for next week is because if the right honourable gentleman has taken the order paper on Monday, if, for example, based on the opinions of the House today and Monday, we legislate for a customs union on Tuesday or Wednesday, then MB3 becomes redundant. So are we assuming, is my right honourable friend assuming, that the only day for a third meaningful vote on the government's withdrawal deal is this Thursday or this Friday, or can he envisage a time next week where there may be space for an MB3 to come back, for example, before a customs union day of legislation on the Wednesday? Thank you.
Well, that again is a perfectly reasonable set of questions, but again has a definitive set of answers. First of all, in relation, this is not any making of any member of this House or of the government. In relation to MV3 on Thursday or Friday this week, that timetable has been set by the EU. In their legal decision, they've made it clear that the withdrawal agreement has to be agreed by this House by, I think it's 11 p.m. our time, but in any event, late at night on Friday, in order for the 12th not to be activated and to move us to May the 22nd. And that is, of course, what would be necessary in order for the government to pass through the Withdrawal Act implementation bill, which is in turn necessary in order for the government's meaningful vote to be meaningful. Without a Withdrawal Act implementation bill, it's a nothing, as both he and other honourable members on both sides of the House who study this very well understand. So the fact is that the Thursday-Friday schedule this week is set by the EU, not by any of us. There's nothing I or anybody else here can do about it. And it's very important, therefore, for those of us who want to make sure that we don't drop out without a deal on the 12th, to ensure that if my honourable friends haven't supported those of us who are going to be in the lobbies voting for MV3 by Friday night, then there is an alternative, and this is the only way we can do it. Of course I can.
Would my right honourable friend explain how, if the House voted for a negotiation with Europe for a particular outcome that the government either thought wasn't desirable or wasn't negotiable, who would do the negotiating? Because it's normal for only the government to be a recognised negotiator.
First of all, my right honourable friend is, I think, one of the two or three most distinguished and long-serving members of Parliament today, and has had a distinguished record in government, and he knows as well as I do that he's absolutely right, that only the government of the United Kingdom can negotiate with foreign powers. This is obviously true. But the truth is also that the government, like all the rest of us, is governed by the law. Just as much as any private individual, ministers are governed by the law. And it's a frequent occurrence that when ministers bring before the House of Commons a piece of legislation, that piece of legislation is amended in a way that ministers did not wish, and yet ministers then are compelled to implement the law that the House and the House of Lords have passed as it is written in the law. And that is a justiciable matter, and they're subject to judicial review if they don't do so. And as a matter of fact, we have a Prime Minister. I have on frequent occasions said that I don't think that the Prime Minister's strategy in the matter of Brexit has been ideally suited to the task. But the fact is, I've never met an honourable member of this House, or indeed any other living human being, who is more law-abiding than the Prime Minister. So I'm absolutely certain that she will, I'm absolutely certain that she will follow the law, not just in the letter, but in the spirit, where there are law, which flowed from a majority view of the House of Commons. Of course.
When the government normally has control of the order paper, if the House amended a piece of legislation in a way the government didn't like, it needn't bring the law into effect or go through the remaining proceedings to make it a law.
Well, my right honourable friend is, as one would expect, right, but actually the government often chooses not to do that. It often allows a piece of legislation which contains things it doesn't quite like to go forward because it has some greater objective. And the truth is, therefore, ministers often do, and he and I, as ministers, have both had this experience, find themselves implementing pieces of legislation with which they are not wholly in accord. And they know how to do that, and the civil service knows how to support them in doing that, and that is, of course, what would happen under those circumstances. Yeah, of course.
Would he not agree that it's actually a very novel proposition that the House would have to pass a law to affect the government's policy in this way? Can he think of any example in his experience, because mine's longer than his and I can't in mine, of the government pursuing a policy on such a vital national matter, knowing it did not have the support of the House of Commons in the way that it was going about it, and simply defying a majority that had voted for another approach.
As my right honourable friend is not just a former Chancellor and Lord Chancellor and almost everything else, but also the father of the House, he will certainly have more experience than most of the rest of us put together about this, and if he can't think of such a case, I'm certainly not going to be able to. And I don't know of such a case, and indeed, simply because of the possibility that people would raise this issue, I have done some research to try to find out whether there is any such case recorded by historians who have longer virtual memories, so to speak, than we have actual memories. And I have to say, I can't find one. And I think that suggests that there is a pretty strong precedent that if the House of Commons passes in a matter of extreme significance to the nation a resolution in favour of a clear view of how to proceed, it would be not unlawful, so far as I know, though that's a matter of the Attorney-General to rule on, obviously, and not for me, but not unlawful, but nevertheless very, very constitutionally unusual for the government not to accede to that resolution, to proceed in the way the House of Commons had requested it to do so under those circumstances. And I profoundly hope that if we reached Monday and we get to a majority view in favour of a particular proposition, that the government would say, as I think it ought to say, that it would then carry that forward. I'm merely protecting against the possibility that it takes the view that that is not a binding utterance by the House of Commons, and under those circumstances we do have methods through legislation of compelling, undoubtedly by law, an action which otherwise might not occur.
I'm grateful to my honourable friend. I mean, for example, he may recall the Maastricht Treaty, which caused a little difficulty on a cross-party basis in this House as well. Does he think if the government had been defeated by a motion on the Maastricht Treaty, disapproving of the treaty, that my right honourable friend and others who were then concerned about the treaty would have been content if the government had proceeded with its declared policy on the basis that it had stood on it at the election?
Well, the answer, obviously, to that question is no, I think, as he intends. He and I were on opposite sides, bizarrely, on that particular issue. I actually believe that the whole of this imbroglio is largely due to the fact that the wretched Maastricht Treaty was approved by this House in the first place. Had there not been qualified majority voting, the British people would probably never have come to disapprove of the European Union in the way they did, and we'd have been spared all this. But that is ancient history, and he and I have a long record of agreements and disagreements at different times. Tonight, this afternoon, we are agreed. Of course, thank you.
Full to my right honourable friend for giving way. In response to my right honourable and learned friend, the member for Rushcliffe, he said, for the government to ignore a motion of this House would be constitutionally very unusual. But it has to be said the process being gone through this afternoon is constitutionally deeply irregular.
Well, I'm particularly glad that my very distinguished honourable friend has participated in this part of our proceedings, because he hasn't, as it happens, though he's an assiduous attender at debates, obviously, he hasn't, as it happens, ever had the horror of having to listen to me on this subject before, because he hasn't been present when I've been speaking about it. And I've tried to say to those who were present on each occasion that the proposition he's just advanced is manifestly false. And the reason why it's manifestly false is this. The fact is that the order paper of the House of Commons, this is the most ancient principle of our Constitution, as a matter of fact, the order paper of the House of Commons is governed by the standing orders of the House of Commons, and the standing orders of the House of Commons are the property of the House of Commons, of nobody else, not of the executive, but of the House of Commons. And the courts recognise that in the principle that they apply, the principle of comity. They never interfere in the proceedings of our House, and that goes back not to the 1906 moment when the government, as in my view, improperly instituted the Standing Order 14 in its current form, but way back into the origins of, I will in a moment, way back into the origins of Parliament, where Parliament from the very beginning sought to establish its right, through you, Mr. Speaker, and otherwise, to control its own proceedings. And that's a very proper thing for Parliament to do, and we have been driven to doing this in an extreme emergency, as some of us see it. I know he has taken a rather different view, but in our view, this is an extreme emergency. We've driven to take it. We're doing it in a perfectly proper way through the amendment of standing orders, which it lies open to this House to make. And now, of course, I give way.
I can't entirely agree with this constitutional proposition the right honourable gentleman, my right honourable friend, is putting forward. He will recall that in the Tudor House of Commons it was Privy Councillors who guided the business within the House. It is of the greatest antiquity that the business of the House is guided by those representing the sovereign in Parliament, and that principle is being eroded by today's proceedings.
Well, I little imagined that we would find ourselves debating the sequence of our constitutional history, but because my honourable friend is genuinely learned in the matter, and this may be my only opportunity ever to have this debate with him in the House of Commons before, thank goodness, I leave it. I want to explain to him that the succeeding history of our country was virtually focused on a debate about that very matter. It was because the House of Commons refused to be dominated by Privy Councillors that all the things that happened in the later 16th and 17th centuries happened. Exactly. And I am on the side of those in this House that I actually thought on the whole he was on the side of, who wished to assert over against the executive that in the end, ultimately, sovereignty lies here and not in Whitehall. Of course I can.
I'm entirely at one with the right honourable gentleman in what he said, but I have some sympathy with the point being made. But surely what we should recognise is that the reason that the House has been driven to these unusual proceedings today is because the government has failed to do its job.
Well, the right honourable lady, we have a stellar constellation here. There's another very distinguished member of the House who's held almost every post imaginable, tempts me into doing what I shall not do, which is to observe that actually it is the failure of cross-party consensus on this actually had two sides, and it would have been better actually if both sides had worked together, and that didn't happen. And it's because that didn't happen that we were at the mercy of the votes of some of my honourable friends, and that's why we are where we are. But I think she would agree with me that actually what matters now is none of that history. It's the fact that we are where we are, and we need to find a solution, and that's what this is all about. Yes, of course, I give way.
Grateful to the right honourable gentleman for giving way, and I want to bring him back to the business motion. Today, his proposal is that we should have indicative votes, and dependent on where a consensus appears to emerge, the House will have the opportunity to consider these matters again on Monday, and there will be a further business motion for Monday setting out in more detail than paragraph 2 the way that we will proceed then. I just wonder if he could undertake, as he did before, to share with the House the business motion before the deadline for putting in motions and amendments, so that all honourable members will be able to make the most of the opportunity next Monday.
The honourable lady raises a very serious and important point, and I think we should make that commitment because people do need the opportunity to see what rules of play would obtain on the Monday, and the opportunity to put down amendments to that and to consider in the light of that how to proceed. I believe that if we're talking about Thursday, because there isn't a sitting Friday, and at the moment there isn't, I believe that we are curtailed at 5:30 approximately after the adjournment debate, and therefore I think we should make a commitment that we will lay the business of the House motion for Monday tomorrow, Thursday, assuming that there is no sitting Friday, by 3:30. Tomorrow, so there are 2 hours for people to look at that and to put down amendments if they see fit. And incidentally, I agree with her, and it was part of the burden of what I was saying to my right honourable friend, the Father of the House, that there is ample scope for thinking now and in the succeeding hours, including during tomorrow morning, about possible methods of voting on Monday to encourage or even to ensure some further convergence to get to a majority in favour of some alternative. I give way, of course.
the right honourable friend. Of course, when he argues, when colleagues argue there is no precedence for this kind of event, there will in future be precedents for this kind of event, and that's the way in which parliamentary rules have grown up over many centuries. But will my honourable friend address the point that we will not yet know, and will not know for another hour and 6 minutes, exactly what motions we're going to be voting on? And we're expected to be voting on those at 7 o'clock. Will he ensure in future that actually the House gets a proper choice rather than the choice which is put by the Chair?
Well, I'm grateful to my right honourable friend for his observation about precedents. As a former Chief Whip, he very well knows how these things happen. And it is indeed the case that our Constitution has evolved through a series of adjustments, and there will be a precedent here. I hope, incidentally, because I'm not actually a revolutionary, that it will not be taken as a precedent for these things to happen every day of the week. I profoundly hope that our successors in this House will not for many decades face an emergency of the kind we are currently facing. This is not a way of proceeding that I think any of us would like our country to face in the future. But to come to his point about the motions, first of all, I am much more confident than his question suggests that you, Mr. Speaker, will select a full range of motions that represent a full range of views, and so there will be ample opportunity for people genuinely and openly to be supporting the positions that they wish to support and objecting to the positions they object to. And I think that we shall see that when Mr. Speaker makes his selection, because I know that his intention has been, as has mine and I think the House's as a whole, to try to use this as a genuine opportunity for people to come together on the basis of looking at a full range of options and having every sensible choice available to them. Yes, of course.
Is the right honourable member surprised, find it incredible actually, that the government apparently doesn't have an opinion on the motions that we're going to debate later on? Apparently the Cabinet is going to abstain. There's going to be a free vote for his colleagues. And yet they do have an opinion about denying this House the opportunity to have that debate on the indicative votes later on, because they're going to vote against the motion that he's proposing.
Well, I'm in the very odd position that, as it happens, I know, roughly speaking, what it is that the official machine has been saying about the whole of these proceedings. And I know that it has been raising very serious concerns about the whole idea of Parliament acting in this kind of way. And in fact, I've even had it reported to me that one very, very senior official described the situation as one in which it was necessary for Whitehall to save Parliament from itself. Not in a formal meeting, but outside one. Now, I understand that because, as a minister in Cabinet for 6 years, I saw the way in which, in trying to govern the country appropriately, Whitehall necessarily takes the view that the House of Parliament, the Houses of Parliament altogether, are quite an encumbrance. And it tries to govern the country in a way that will, so to speak, tolerate and obey the democratic necessities of a legislature that sometimes is annoying, but so far as possible, it governs the process. And it is very difficult for the official mind to absorb the fact that actually, ultimately, that isn't how our Constitution works. Ultimately, how our Constitution works is that governments depend on confidence in the House of Commons. The House of Commons is the sovereign body, or at any rate, the Houses of Parliament, the Crown in Parliament, is the sovereign body. And actually, this is a very important point we're making here about how this country is actually ultimately governed. And in that sense, I share my right honourable friend's point that this is a precedent. It's a precedent for Whitehall to recognise that in an emergency, the House of Commons is capable of controlling its own business in such a way as to find a solution that the vast majesties of Whitehall and government have not been able to provide us with. If they were able to provide us with this solution, if my honourable friends were willing to vote for the proposition which the government has conscientiously negotiated over a very long time, and in fact, in my view, rather admirably succeeded in negotiating, we wouldn't be having this discussion. So it's because Whitehall has failed, not due to the inadequacies of any individual, but due to the basic difficulty of the situation, that the Commons is taking these steps. And I think we're right to do so under those circumstances. I will, and then I'll come here.
I'm very good, Mr. Friend. You're being very generous. And surely on that point, honourable friends are concerned about losing control of the order paper
isn't therefore the answer that if the Leader of the House confirms we'll have a meaningful vote on Thursday or Friday, that when they go into the voting lobbies, they have one motto in mind: vote deal, take back control?
That is a neat way of expressing my honourable friend's view, with which, as it happens, I agree.
I'm very grateful to my honourable friend, and I'm listening very carefully to what he has said. And I think the thrust of it is that if meaningful vote 3 were to be approved, then none of this would be necessary to go forward. Will he therefore reiterate his call on all sides of this argument to support the withdrawal agreement? It may not be perfect for either side, but it is the best thing we have on offer, and now is the time to get behind it.
Well, as he knows, that is my view and has been my view throughout, which is why I voted for it throughout and will continue to do so. Yes, of course.
Grateful to the right honourable gentleman for giving way. To come back to the business motion, in particular, paragraph 1I, I just wonder whether the right honourable gentleman could elucidate what he feels success would be for an amendment that we're voting on this afternoon, because there is an aye and nay in the vote. So what will success look like for an individual amendment, or is it a cumulative image created from all of the votes for all of the amendments that Mr. Speaker no doubt will choose in due course?
I'm delighted that the honourable gentleman brings me back to the business of the House motion, because it is traditional in these circumstances for people who are speaking to say that they'd like to make some progress, and I certainly haven't made very much yet. My view is that this is not about the number of votes precisely cast for one motion or another, or indeed against one motion or another. It's about whether, when we look at the results as a whole, and when we act in the way that I think politicians across the parties acting in the national interest can act, which is to seek a consensus, we get enough data to enable us to have sensible conversations about where we can go next. That's what I think would constitute a success here. And I don't know any way to do that other than to have the kind of process we're going through, and that's why I suggested that we should go through it, and so did others. Yes, of course.
Will he recall that the last time we went through something remotely like this was 2009 in relation to Jack Straw's well-meaning but ultimately doomed attempt to get a sense of where we should be going with House of Lords reform? And I fear that today's proceedings will end up very much in the same place.
Well, but my honourable friend needs to attend to the point that those of us who are proposing this have exactly recognised that precedent. What went wrong on that occasion, I think, above all, was that it was a single point in time, and it did not produce a single answer, and therefore it was declared a failure. We are not seeking a single point in time here. We're seeking a process. We're using the first stage of that process as an act of discovery. We're then having a number of days in which politicians can talk to one another and try to achieve a consensus. That can be reflected in a further vote or set of votes. And that's a very different process. I think had that process been applied in the case of the House of Lords, we might by now actually have had a sensibly restructured House of Lords, which, alas, we don't. But that is another piece of history that I'm sure I mustn't deal with. Of course.
Very grateful to the right honourable gentleman for giving way, and he's making a very powerful case for giving the chance to the House today to express its views. Further to the point the Chair of the Northern Ireland Select Committee just raised, the truth is we don't know what this will produce. It's called indicative votes for a reason, because it's intended to give an indication to what the House thinks. But isn't the most powerful point that is not an argument, the uncertainty is not an argument for not trying, bearing in mind that we are potentially, 16 days away from leaving with no agreement if the Prime Minister's deal does not pass, and if the EU were, heaven forbid, to refuse us a further extension, and we should really get on with it.
I just completely agree with every word of that. I think that is exactly the point that the right honourable gentleman makes, is exactly the reason why we are proceeding in this way. And I just want to take this opportunity, incidentally, to pay tribute to him and to his right honourable friends with whom we've been cooperating on this. Actually, it's been a pleasure. And the reason it's been a pleasure is because we share a fundamental concern with the interests of our country to have a way forward that is orderly and that does not leave us with a disaster by mistake. We may differ on many things, but on that we are entirely joined, and that is the very purpose of this exercise. Mr. Speaker, although I haven't myself said very much of what I was going to say. I think I have now gone on much too long, and it has been in response to quite a lot of interventions. I discern there aren't any more around, so I think it falls to me to resume my seat.
Question is the business of the House motion as on the order paper. I call the Leader of the House, Andrea Leadsom.
Mr. Speaker, I rise briefly to respond on behalf of the Government. Firstly, I'm grateful to my right honourable friend, the member for West Dorset, who has sought to ensure that the Government's business for today, a very important statutory instrument that regularises the legal position vis-à-vis our exit day from the European Union, is able to be addressed. Mr. Speaker, the Government is disappointed that the amendment in the name of my right honourable friend for West Dorset and others was agreed by the House on Monday. A clear commitment had been made by the Government to provide time for the House to find a majority for a way forward. I take my role as Leader of the House very seriously. I have always been very clear that the Government will listen carefully to Parliament. But today's motion is an extremely concerning precedent for our democracy. I won't take any interventions because this is a backbench day in the name of my right honourable friend. For many years, the convention has been that it is for the Government, as elected by the people, and with the confidence of this House, to set out the business. It is for Parliament to scrutinise, to amend, to reject and to approve. What today does is effectively turn that precedent on its head. Those who are not in government are deciding the business. And there are inevitable...
Order. I apologise for the Leader's House. Point of order, Mr Nicholas Bowles.
Mr Speaker, the right honourable lady, my honourable friend, just acclaimed that the people elect the government. Is it not the case that the people elect members of Parliament who, by majority, decide whether they can form and support and have confidence in a government?
The gentleman is constitutionally correct. He's made his own point in his own way with his customary fluency, but the Leader of the House now has the floor again. The Leader of the House.
Thank you, Mr. Speaker. What today does is effectively turn that precedent on its head. Those who are not in government are deciding the business, and there are inevitable ramifications to that. I work constantly to represent Parliament's voice in government, and today I am genuinely concerned that the decisions we are being obliged to make could result in Parliament being extremely frustrated. It is highly likely that we could be in a position where the preferences of the House simply cannot be achieved. Whatever the House decides needs to be both deliverable and negotiable. And very specifically, the European Union has been clear in all circumstances that changing the withdrawal agreement is simply not an option. This government wants to deliver on the referendum of 2016 in a way that maintains a deep and special partnership with the European Union. Urgent action is needed. Businesses and people cannot be left in limbo any longer. There are two sides to this negotiation, so I repeat that what the House decides needs to be deliverable, it needs to be negotiable, and it also needs to deliver on the referendum. I won't. The Council conclusions agreed last week set out that the withdrawal agreement in all circumstances must be adopted by the United Kingdom. So I would urge colleagues to accept that approving the withdrawal agreement, which is complex and which covers wide-ranging areas from citizens' rights to farming, from overseas territories to security and financial services, has to be the first step. The EU have said that the withdrawal agreement will not be changed, and Parliament needs to accept that before we can look to the future partnership, which is what much of today's debate will focus on. Notwithstanding that no amendments have been selected, in particular, I do hope that should the debate today proceed in accordance with the business of the House motion, it will allow for all motions to be fully considered, rather than just a select few. This would enable Parliament to establish what it does want, rather than what the selection would permit. Mr. Speaker, the Government has consistently said that we do not support the approach the House has taken to remove government control of the order paper, no matter the circumstances. For that reason, we will oppose today's business of the House motion. While it is now up to Parliament to set out next steps in respect of today's business, the Government will continue to call for realism in the debate ahead. Any options considered must be deliverable in negotiations with the European Union. Thank you.
Thank you. The Shadow Leader of the House, Valerie Vaz.
Thank you, Mr. Speaker. And can I thank the honourable member for West Dorset for the business of the House motion. And I hear what the Leader of the House has said. Mr. Speaker, we are living in unprecedented times, and that is why this business of the House motion has been moved by the honourable member. Mr. Speaker, it saddens me to look around on the benches opposite at some of the most wonderful and fantastic ministers who've left government, and they've done so because they are frustrated and they do not see a way forward. Mr. Speaker, we are on this side are going to support the motion. We know these are unusual circumstances. The House has ruled and the House has decided that they want to proceed in this way. All the honourable members that I've seen and I've spoken to today have decided, and they are honourable members who've been working for a long, long time, honourable members like a former Attorney General, chairs of select committees, the honourable member for West Dorset, who's written manifestos for the government, who's played a vital role, a former vice chair of the Tory party, excellent people. They all agree that something has to be done. Mr. Speaker, it is you that have to control the businesses of the House. We're not talking about personalities. We're talking about the office of the Speaker.
I'm grateful to the Shadow Leader of the House for giving way. The Leader of the House claimed at the dispatch box that she speaks for this House in government. How can we possibly take her at face value when she wouldn't take a single intervention, when the House has made clear that the business today was to be decided by the House, and when she talks about, I mean, this is where it becomes jaw-droppingly hypocritical, I think. Yeah. She says, on one hand, sorry, Mr. Speaker,
I'm sure the honourable gentleman wouldn't make a personal charge which impugn the integrity of the leader. Members can make a wider political charge, but not a personal charge. West Reading.
Mr. Speaker, out of respect for you and the rules of the House, I will certainly withdraw the word hypocritical. But I would just say to my honourable friend that it was pretty jaw-dropping to hear the Leader of the House on one hand claim that it's Mr. Speaker's responsibility to select every amendment, when she herself believes that we shouldn't vote on a single amendment today, and when she herself will not be casting a vote one way or another on a single amendment. Isn't this just a complete farce?
Can I thank the honourable member for his intervention and say this, that honourable members have mentioned that the House is listening, the Prime Minister is listening. The Prime Minister, Mr. Speaker, has met with honourable members but has not listened. The fact is we are in unusual times. This is a hung Parliament, and the government is only governing on a supply and confidence agreement, nothing else. Yes, I will.
Shadow Leader. For the Shadow Leader for giving way. I'm sure she'll give way to the Father of the House as well, unlike, sadly, the Leader of the House. Did she share my concern at the assertion that the withdrawal agreement cannot be renegotiated? And yet we were told in no uncertain terms by the government that the so-called Malthouse agreement, which fundamentally changed the withdrawal agreement, was something to be commended and worked on, and I think actually public money was spent on advancing it.
Can I thank the honourable lady for her intervention? And, Mr. Speaker, when we speak about the withdrawal agreement and whether it can be amended or not, I have sitting beside me the Shadow Secretary of State for exiting the Union, and he has been in discussions with the European Union. We have been in a union with the European Union for over 40 years, and we know that they would be open to any discussions, as they have had with my honourable friend. They will be open to discussions if that's what is decided. Mr. Speaker, we cannot ignore what our constituents, what people have said to us last weekend, how they took time out of all different generations to tell Parliament exactly what's going on.
She will recall that the Prime Minister tried to dissuade the House from taking control of the business by saying that if we didn't, the government would allow time for indicative votes to be taken. But we were never given any details, any clear commitment, or any undertaking that any notice would have been taken of those motions. Now, today we have this alleged constitutional crisis that the House is setting the business. If the government had tabled a motion, an amendment, setting out its own clear proposals for taking the views of the House and discovering what the favourite option was to proceeding, then this whole argument about the process could have been avoided as an irrelevant, and we could have resumed the serious business of making sure that a majority in this House is in support of the government policy being pursued.
Mr. Speaker, I can't follow that other than to say that I've always admired the honourable member, even before I was in this place, I'm totally in awe of him. But I absolutely agree with what he says. Yeah.
Well done. Well done. I thank the Shadow Leader for giving way. I will support the motion today, as I did to get us here on Monday, to great sadness, because we are living in extraordinary times and because this House of Commons is at an impasse. And we, as the House of Commons, have to solve this, and it's the last roll of the dice for us to be able to do that. Otherwise, all other options, however unpalatable, are on the table. But would she not agree that, given that out there the view of this House right now is not at its highest point, shall we say, this is an opportunity for this House of Commons to surprise, in a good way, the British public?
Can I thank the honourable member and for his work as an extraordinary minister? He's been absolutely fantastic, and I know I've seen him over the weeks how difficult that decision to resign was, and actually thank him for being such a good minister. But I do agree with him. And I'm coming to you in a minute. I think the key thing, Mr. Speaker, is that members of this House have tried to speak to the Prime Minister to try to say exactly what this House wants and what this House has decided on. Mr. Speaker, I just say this. If we just relied on precedent, then I don't think you or I would be standing here as members of Parliament. I think we'd have had to have wealth, we'd have had to have property, and for women we might have had to have something else, if I can not be too rude. Yes, I will.
I thank the honourable member for giving way, especially on the point of precedent and what we do. Would she agree with me that actually, even though we've got an unwritten constitution in this country, at times of national emergency, constitutional invention is what has got us through, whether it's the national government during the two world wars and the full-blown coalition to solve the financial crisis in 2010. And actually what was needed in this particular situation, given that the government doesn't have a majority and it is not clear what the majority is for any of the Brexit options, what was needed right from the start was that kind of constitutional invention, and the lack of it has not really helped with the passage of the government withdrawal bill. And that we should actually be thanking the member for West Dorset for doing this. We would rather not be here, but we are here, and invention is what is needed at this time.
Can I thank them? I was going to say another excellent minister, and I was sorry to see him leave his position. He has been absolutely fantastic, and I do agree with him. I think this point about precedent is really important, Mr. Speaker. Nothing is in aspic no rules or procedures. I've been, as my working life as a lawyer, I've seen the civil procedure rules turned over, and we move forward. We don't look back. Even Erskine May, with the greatest respect to my honourable friend, even Erskine May is outdated. Yes, I will. Yes.
I'm grateful to the Shadow Leader of the House for giving way. Further to the discussion about whether or not this is or is not a constitutional outrage and the points of order for my honourable friends earlier, would she agree with me that this House has always, since the Civil War, controlled its own time? And the only reason that the business of the House is normally controlled by the government is with the consent of the majority that it carries with the confidence of the members who support it. What the House is doing today is asserting that its primacy is to control the business of this House, as it always has been and always will be.
Can I thank the honourable member? And I have to say, the House today is only responding to what the House agreed on Monday. Let's face it, Mr. Speaker, we would not have had the meaningful vote if the House hadn't agreed to this. If we hadn't put through that motion, we had to struggle to get it. And let me just talk about percentages, of the meaningful vote. So the first meaningful vote was won by a percentage of 68% to 32%, and the second by 62% to 38%. I'll give way to the honourable.
Thank you, Mr. Speaker. Can I ask the Shadow Leader of the House, returning to the business that we're looking at now, there clearly has been a change in the Labour Party's position, because up to today we've always thought that if the Labour Party didn't support the government's position and they didn't think the House supported the government, they'd move a motion of no confidence in the government, which is the normal way to proceed, not to have an alternative government established. So can I take from this that we, in fact, will no longer have motions of no confidence from the Labour Party?
Thank you, Mr. Speaker. And I think the correct term, I'm sure you will correct my honourable friend, is that we are Her Majesty's opposition, and we are responsible Her Majesty's opposition, and we want to try and find a way through, which is what all honourable members from all sides are trying to do. I give way.
Precisely on that point, as we have already heard this afternoon, there are quite profound constitutional implications of what is happening before us today. And I think that the House will have to, at some point in the not-too-distant future, actually have some mechanism to consider the profound constitutional implications. But that shouldn't take away the fact that we are concerned about an immediate crisis which is before us now. And in the interest of pragmatic democracy, it is essential, I would argue, that we do find a way forward, but bear in mind we have to, at some point in the not-too-distant future, return to these big issues.
I can't add anything more to that, my honourable friend's excellent intervention. Oh, yes, I'll give you.
I thank the Shadow Leader of the House for giving way, and I will be supporting this motion. And I want to also put on record my thanks to the Right Honourable Member for West Dorset and Leeds Central and others, and I'm proud to have worked with them on how we try and move forward in this House. And, perhaps she will agree with me, when I first drafted one of the original meaningful votes amendments in December 2017, it was precisely because of my concern at that time that should a deal not be agreed by this House, that this House would need some sort of process or roadmap by which we would then have some chance of moving forward in an orderly fashion. And indeed, the position that we're in today is precisely because of a profound lack of leadership from the Prime Minister, not involving the House early enough and building a consensus on how we move forward. So does she agree with me that rather than disappointment that was expressed by the Leader of the House, that I'm surprised that we didn't hear some profound regret, in fact, that the Prime Minister and the Government had not engaged the House considerably earlier on the negotiating objectives, listening to the House on how we should move forward, and instead continuing to furrow a track that had clearly shown it was going to lead to the same place, which was defeat every single time.
Thank you. I agree with everything that my honourable friend has said, and this is... Yeah. Please. Yes? No.
Would my honourable friend agree that we're only at this situation because of a government that's unable to govern and a Prime Minister who's unable to listen to the House, who's been defeated resoundingly twice? And would my honourable friend not only pay tribute to the 30 brave members of the Conservative Party who voted to enable this debate to take place, all under pressure from their Conservative associations, but in particular the 3 ministers who sacrificed their careers on a point of principle to allow us to have these options today?
Yes, and I agree. And those people on all sides who've taken this very bold stance have actually suffered abuse. They've been threatened with deselection by their parties, and that's absolutely the wrong way to deal with it, Mr. Speaker. This is an absolute... Yep.
Just before the honourable gentleman intervenes, which of course he should have the opportunity to do, Sir Angus Brendan Whitney.
Thank you. Given there are 16 motions to be dealt with this afternoon, and if a member was to get up now and ask that the question be now put, how might the Chair react to that question so that we could increase the time that we have for the motion?
There's no need to put a closure. It's a time-limited debate, and the time limit will be well known to the honourable gentleman. So if he can just contain his impatience, and there will be salvation at hand in due course.
Further to that point of order, Mr. Speaker.
Oh, very well. And further to that point of order, Mr. Charles Walker.
I don't want to try your patience, Mr. Speaker, and I apologise. But, Mr. Speaker, given that colleagues will be entirely unfamiliar with the voting process that is going to happen this evening, I think it would have been useful if the Procedure Committee at least could have had a dummy copy of what was going to be used, so we could have been reassured that actually that this was going to be something that the House could get to grips with.
Right. Well, I'm grateful to the honourable gentleman for his point of order, and he is not merely a distinguished ornament of the Procedure Committee, he is its illustrious chair, a fact well known to all members of the House, but which ought to have wider public recognition. What I say to the honourable gentleman is that that was not a matter for me. However, insofar as there is any concern about the process will be explained at the material time by me from the chair, I hope in a way that will inform and assist all members of the House. Now, I think the shadow leader, will she just confirm she's giving way to the...
I am giving way.
Mr. Richard Haddington.
Thank you, and I'd like to thank the shadow leader for accepting my intervention and for your patience, Mr. Speaker. Although before the points of order, it was mentioned by the honourable lady that, or I think actually by the previous intervention, that people like myself, Mr. Speaker, who had disobeyed a whip and resigned our position, may have had undue pressure from the whips or from our Conservative associations. I actually haven't experienced that myself, but I'd like to make the point that there have been commentators and indeed members of this House who said that by doing the act of following the amendment and supporting this the business motion today, that this is a dangerous revolution, a constitutional position of terrible magnitude that could have the future of the country at stake. But I cannot accept that for 1, 2 or 3 days, reversing the order paper, that one of my constituents is going to criticise me for one day it says private business before business of the government. So I'd like to refute that, and I'd like to ask the shadow leader what her views on that subject are.
Valerie Vaz.
So what I would say is that this is unusual times. Nobody asked for a Prime Minister to resign when he did after the vote, but nevertheless the Prime Minister did, and a new one had to be found. The fact is, we are in difficult times. We are in unusual times, absolutely unusual. But what this House doesn't expect is for a Prime Minister to have a view on one of the biggest issues of the day that's not going to affect the majority of honourable members here, but our children and our grandchildren and future generations. Let's face it, Europe kept the peace in Europe. There were some terrible things that happened, and I keep saying this every time. The reason why we've got the Human Rights Act is every single one of those was breached during the last war. And that's why we need to stop it. What we've moved on from Europe is that sort of forum to a forum where we are trading with our biggest and nearest partners, and that's why we have a union of more people who want to join. And I think for the sake of future generations, we need to think very carefully about what we do today. It is the will of the House. The House has decided there was a vacuum, Mr. Speaker, and the House filled that vacuum. Honourable members from all sides constructively wanted to move forward on what was happening, and that's why we are in this position today.
I'm very grateful to my honourable friend for giving way. Does she share my puzzlement, if I could put it like that, at the remarks of the Leader of the House, who I think gave the impression that this had been somehow sprung upon the government when it was only too willing to make provision for indicative votes itself? Can I draw my honourable friend's attention to the recommendation of the Brexit Select Committee published on the 16th of January, after the first time the government deal was defeated by 230 votes, in which we said, it is vital that the House of Commons is now given the opportunity to identify an option that might secure a majority. We recommend that this is done by holding a series of indicative votes on the options we have set out above as soon as possible. Would my honourable friend agree with me that here we are on the 27th of March, and that is going some when it comes to as soon as possible, and the government could perfectly easily have acted earlier?
Absolutely. I thank my honourable friend and my right honourable friend, and do pay tribute to the work that he has done on a cross-party basis to bring this issue forward. But it is, as I say, Mr. Speaker, unprecedented times, which is why the House is in this position. And we are pleased that the honourable member for West Dorset has had the courage, along with other honourable members across the House, to put through this motion, and put us in a position where, Mr. Speaker, I have to say, we have to learn from a certain social media platform that we think there may be a vote on Thursday or maybe a vote on Friday. Now, is this the way to conduct responsible government? We would say on this side, no. No one from the government has had the courtesy to come here. I don't know if they've informed you, Mr. Speaker, but they certainly haven't informed us about what's going to happen with business on Thursday and Friday. And yet people outside do know. I give way.
I'm very grateful to my honourable friend for giving way, and to associate the comments with regard to the right honourable gentleman from West Dorset. She makes a very, very powerful point about what the future generations are going to look back at this time as. And they're going to judge us by what happens in events like we have seen today here in this House. And actually, it is important to remember that the House was pushed and pushed and pushed before it decided to take these almost unique steps. And to do so, they do so with trepidation, but at a time where something must happen to remove the logjam of a dysfunctional government. I would like to draw the Shadow Leader's attention to the same question that I asked the Right Honourable Member for West Dorset with regard to what would look like success today for the votes this afternoon. And the Right Honourable Member made a very good point that really today is about seeing a large picture about where the opinion of this House lies. And just the Shadow Leader of the House, my apologies, agree with that this is about finding that overall picture, and steps necessarily on Monday may draw that down to a closer point, and that's why I'll support the business motion.
Mr. Speaker, yes, I thank the honourable friend for that. And, Mr. Speaker, we are trying to help the government, which is why we need to support these indicative votes today. We're trying to help the government find out exactly what honourable members want and don't want. But, Mr. Speaker, I just want to say finally that we on this side support the motion. We want to find a way forward, and therefore we on this side will support the motion in the name of my honourable friend, the member for West Dorset.
Thank you. Mr. Jacob Rees-Mogg.
Thank you, Mr. Speaker. I will oppose this motion because I think it is constitutionally ill thought through. That our country indeed does not have a codified constitution,
but it works on conventions, and those conventions are precious to those in government and those not in government. For at some point the tables may be turned, and the Labour Party may find that they have a minority government and then cannot keep the business of the House as they would expect. And why does the government need to have this primacy within the business of the House? Because, as my right honourable friend, the member for West Dorset, says, it is absolutely right that the standing orders are the property of this House, and they are not challengeable outside this House. But our governmental system works through the Queen in Parliament, and the Queen in this sense is represented by the executive. And there is a separation between the executive and the legislature, which we all know about. And that separation requires that the proposition of events comes from the government, and that the amendment, review and redress in relation to events comes from this House. Of course I give way.
Brian. But one of the conventions that has lasted for a very long time is that the parliamentary session lasts for a year unless there's a general election that intervenes and makes it more sensible for it to be 15 months or something like that. And in a parliamentary session, as he knows, the standing orders provide that there shall be so many days set aside for opposition days. But that has been completely broken in this session, which has gone on for nearly 2 years. We haven't had an opposition day since November, the longest in living memory.
Grateful to the honourable gentleman for his point, because I agree that it is important to observe the conventions, because the conventions protect the interests of everybody. And if the honourable gentleman is calling for a prorogation so that we may reset and have opposition days, I would not be opposed to that. I think it may well be time for prorogation. But of course I'll give way to the honourable lady.
I thank the honourable gentleman for giving way. Another one of the conventions that has been broken is that the government should actually vote in opposition days and take notice of motions that are passed in opposition days. And again, that has been widely disregarded by this government, which is now refusing to take part in opposition day votes and completely ignoring anything but motions which demand to be put into effect. Surely, does he agree with me that this is yet another example of one of those established conventions that I always thought, when I came into this place, would be properly observed by the government, which has been discarded?
I'm grateful to the right honourable lady for her intervention. I think the issue there is that opposition days have become much more precise and have used the humble address procedure to ensure that they are taken notice of, and that is using a correct constitutional approach and is actually better than mere motions of generally otiose opinions. But did my right honourable friend want to...
Well, I was going to call on my honourable friend's constitutional expertise to tell me whether it's an established convention or a novel convention for a government minister to propose a motion at the dispatch box and then to vote against it. Isn't it the case that in a hung parliament we tend to invent new conventions to cope with our novel situation?
I'm sorry to say that my right honourable friend is wrong on that. There is a very strong history of ministers proposing motions to aid the House. It was certainly done by Jack Straw when the last Labour government was in office. It was done by the government headed by David Cameron when you reach the end of proceedings and the only ability to propose a motion is with a minister. Ministers often propose it to facilitate the House coming to a judgment. So no, that is actually quite a commonplace thing, as Mr. Speaker will know. I won't give way to everybody because there are only 22.5 minutes to go and the spokesman for the SNP will want to speak. So I must be conscious of the rights of minority parties. Another important convention within this House. But I want to come... I won't even to my honourable friend. I want to come to the nub of this issue and why taking control of the business away from the government is a bad precedent. And the reason for that is because the House is not actually willing to come to the logical conclusion that today's proceedings is heading towards. The government controls business as long as and only if this House of Commons has confidence in the government. And my honourable friends, not the opposition, who are perfectly reasonable in this regard, my honourable friends should think very carefully about what they're doing. Because what they are in fact saying is that they do not have confidence in Her Majesty's government, and if that is what they think, they should vote accordingly, because our great constitutional convention is that these decisions, if they cannot be decided by this House and the government that is legitimately installed, go back to the electorate. And the reason my honourable and right honourable friends are not willing to take that conclusion... are not willing to take that conclusion is that they are going against the electorate's will as expressed in our greatest ever referendum. I will give way to my honourable friend.
Thank you, Mr. Speaker, and I thank my honourable friend, and I always learn from him. But I think on this, I must disagree. I am quite capable of distinguishing between my general confidence in the government and its measures and its cabinet and its Prime Minister and their specific conduct on this particular issue. And furthermore, I would point out to him that in that great referendum, which he refers to, which voted to leave the European Union, I have been consistently voting with the government in which I have confidence, with the Prime Minister in which I have confidence, to give effect to that decision, and he has been voting against.
My honourable friend, my honourable friend,
Mr. Mogg. Let's hear from Mr. Mogg.
My honourable friend makes a characteristically Wickhamist point, highly intelligent, but fundamentally wrong. The issue, and I must confess I've sometimes thought my right honourable friend for West Dorset was more a Wickhamist than of my own school, but never mind, we will leave that to one side. The expression of confidence in the government is through its control of business, not on any individual item of business, and that is why confidence and control of business come together. And this has been taken away in the past, and my right honourable friend for West Dorset referred to the assertion of parliamentary authority in the Civil War. Well, we know how that ended. That ended with Pride's Purge. It ended with people being prevented from voting. The government, the executive and the legislature are clean different things. That separation of powers is essential. The conventions of our Constitution are essential, and it is important that we observe them properly, because the sovereignty of Parliament at the end is not the sovereignty of us, however brilliant we may be. It is not the sovereignty of the mace. It is the sovereignty of the British people. They have told us what to do. We must do it.
Pete Wishart.
And as always, it is an absolute pleasure to follow the honourable gentleman. And if an example of his taking back control when the parliamentary party is a spat between him and the honourable member for West Dorset on Tudor history, I say we can't get enough of this. But I like this innovation, Mr. Speaker. Well, the DEFRA secretary from a sedentary position invites me to consider the Stuarts, and if we were to go down that particular route and define a period in history where the Scots had precedence in terms of how this country was governed, then you couldn't give a better example than that. I'm sure the honourable gentleman from North East Somerset would agree with that fully. But I like this. I think this is a good innovation. It's a creative way to be looking at how we do our business. As an example, at last, of this House taking back control. And what surprises me more than anything else is that those who called the loudest and biggest clarion calls for this place to take back control are those that have the biggest problem with the House actually doing that very thing. And it's really strange to see the honourable gentlemen, and I see them all in their places getting ready in order to try and make sure that this is defeated and it's once again returned to the hands of the executive. Now, I'm familiar with the honourable gentleman's speech, and I've heard it before when he makes the right of the authority of the executive over the legislature. And in terms of the constitution of this place, he is absolutely right. But where we are is in totally uncharted territory, where in a hung Parliament we've got to look for these constitutional novelties.
And this is something that should be congratulated. The way that this has been engineered and designed by the Right Honourable Member for North East Dorset is almost elegant in the way that its purpose has been defined. We have this opportunity to do this. It's an opportunity the government could have given us, and they chose not to do that. And so to complain about the fact that it's been up to the House in order to do this is something I think is very, very churlish. And talking about churlish, I have to say to the Leader of the House, I found her speech both petulant and irritable in her response to this. I thought she was totally ungracious about the way that this House has decided to do its business. It's what the House has decided. And the fact that this government is now going to vote against this business motion, I find almost astonishing. They had an opportunity to lay an amendment, and why they chose not to do that, I cannot understand. I will give way, of course.
I thank my honourable friend for giving way. He says that it's great that the House is doing this now, but should this not have been done about 2 years ago, after the Prime Minister said she would consult across the House and consult across the UK to agree a plan before going Europe, and she did exactly the opposite?
My honourable friend is entirely, utterly right. Of course that's the case. This government had the opportunity to reach out, to try and decide and try and determine what this House wanted in terms of how it was wanting to progress this whole issue of Brexit. It chose not to do that. And it spent the last 2 years talking to itself, trying to persuade recalcitrant backbenchers to back a deal that they no longer favour, talking in the DUP at great expense in order to ensure that they can secure their support. It's 2 wasted years, and it's absolutely right, therefore, that this House does take back control and presents this motion in front of us today. Yes, of course, you're
I do understand the concerns that some colleagues have raised today about the precedent, and as the member for North East Somerset said, what would happen if the tables were turned. But does my honourable friend agree with me that to that extent the genie is out of the bottle? And that is not a reason not to pursue with the course of action today and vote for this business motion.
Sitting on the SNP benches, the tables being turned doesn't really concern us when it comes to us being in the opportunity to having this done to us, given that that's very unlikely to ever occur. But the honourable gentleman was right in one respect, is that this has been a parliament that has changed the way that we've done our business. I remember the last change to standing orders, and I'm sure I'm right in this, and the honourable gentleman will correct me, was when we introduced English votes for English laws. That's the last time that standing orders of this House was changed, much to the detriment of Scottish members of Parliament, who all of a sudden found themselves as a different class of member to this House than other members across the House. So the standing orders are within the gift of Parliament, and if Parliament decides to change them, that will be a matter for us, and we will decide that and determine that in a motion presented to this House.
I thank the honourable member for giving way, and indeed the discussion that has gone on about precedent is one that we, in due course, may look back on this time and say, could we have done anything differently? But isn't it true that at this moment and on this issue that is of such national importance, where the divisions and also the unity go across party boundaries, and where we are dealing with an unprecedented way in which the country has also been kept out of this debate over the last 2 or 3 years, is now calling out for Parliament to find a way forward? And isn't it true that it is really government that ceded control on Monday when they still had an opportunity to bring forward a pathway and a process by which the voice of this House could be heard?
And the honourable lady is absolutely right and totally correct in her sequence of events. It was Monday night when this was determined and decided. And she's right in another respect, and I'm sure, like me, she's been having lots and lots of new constituents getting in touch with her, totally aghast about what we're doing in this House, the fact that this House is making such a mess of all of this. And they're looking at us today, where we take control of this House, to see if we could do a better job, and to say to the honourable lady, we can't do a worse job than this government has done. That is for absolutely sure. Now, the right honourable member for North West Dorset isn't just a putative Prime Minister, he's almost like a one-man government. And I was really enjoying his contribution until we got to about the 20th, 25th minute of it. And I would just suggest that if we're going to progress this and do this and develop this as an idea, we do it a bit differently, and maybe with a little bit more style and panache that we've seen from the government. So I hope that is the case. I give it to honourable friend.
I thank honourable friend for giving me. I'm surprised there hasn't been more objections
objection, actually, to the other innovation that's taking place, which is that we're going to cast our votes using bits of paper. Now, some of them might want to use vellum and quill and ink and so on, but of course, if Mr. Speaker were to choose all of the amendments, that could potentially be about 4 hours of voting. So perhaps the real innovation that comes from today is a modernisation of our voting systems as well.
That is one fantastic precedent that the Right Honourable Member for North West Dorset has already put in place. We're getting towards electronic voting. For the first time in my 18 years in this House, we will actually be able to vote in a sensible, constructive manner, not waste hours and hours in division lobbies, wasting our time when nothing could further be done. Exactly. Now, I can see you looking at me, Mr. Speaker, as if an encouragement to maybe conclude my remarks, but I will with this. I am almost certain, and I listen very carefully to the Leader of the House on morning radio, as I always do, and listen very keenly and attentively. I got the impression that this government are not in the least bit interested in what this House passes today in terms of this indicative vote. I've got no reason to believe for 1 minute that they are going to totally reject contemptuously and now traditionally what this House decides. I'll give way for the last time to the
Honourable Gentleman for giving way, and coming back to his honourable friend's point, my honourable friend's point, what I find is incredible, and I've reflected on this over the last 2 or 3 years. Before the Prime Minister activated Article 50, you would have thought logic would have told her to get all the interested parties together to find a way forward. Now, 2 years down the road, the government still doesn't have a plan B. This is incredible, to say the least.
I describe the government's approach to Brexit as chaotic and clueless, and there's nothing which will ever distract me from that particular principle when it comes to the way that they're prosecuting this Brexit, which has just been such an utter disaster. I will give it for the honourable gentleman. I'd like to.
Does he understand that if, by some stroke of luck, this House were to come to a conclusion tonight or on Monday of a way forward, which was totally contrary to the manifesto which the government had stood on, that no government would wish to negotiate a deal which was contrary to the programme which it had stood on in the first place?
Right there after I don't think the Right Honourable Gentleman is really keeping up about what's happening today in this innovation about the House determining the process and deciding. And that should be done without any due concern to what's been said and done before. This is our chance, for goodness sake. This is our moment to make sure that we make a decisive outcome which should be respected by this government. And I really hope that Leader House reconsiders her approach to these indicative votes. And I encourage the Right Honourable Member for North West Dorset to continue in his approach to come to a solution which can clearly demonstrate the will of the House when it comes to this. And at that point, the government must therefore accept it. I feel, Mr. Speaker, that this is a good day for Parliament. This is a good day for this House. We can't make a worse job of it than this government has already done. I hope that the government listen very carefully to what has been said here today, and we will support this motion this afternoon.
Jonathan Ginogly.
Thank you, Mr. Speaker. As I see it, the government has 2 clear tracks in relation to its position. The first is that this business of the House process is somehow unconstitutional, and the second is that it's somehow, even if it is constitutional, hijacking the agenda. I mean, taking the first element, from a historical precedent perspective, I would suggest that the government here is simply wrong. Early in the last century, it would have been absolutely normal and acceptable procedure for legislators to bring forward bills. And indeed, if you look at the United States now, legislators will constantly stand up and introduce bills in both houses of Congress. And the reason they do that, by the way, is because they got it from us, is the first point that I'd make. Moving forward to today, I would say there's also clear constitutional precedent for Parliament to set the agenda. They're called private members' bills days. Then we have backbench business days. These are essentially backbench initiatives to take over the agenda, if you like. If we can allow it for such business, how much more should we be prepared to allow it when the House is deadlocked and the government is not setting out Plan B on the most important issue facing this country since the Second World War? As to the second element, which is that we're somehow hijacking the agenda, I would say this. I would refute that absolutely. nothing is stopping the government using all except these 2 sitting days to set out its own agenda and to put forward its own proposals. To claim that taking 2 days is somehow hijacking the agenda is simply a very weak excuse in my book. What this represents is a parallel process aimed at breaking the deadlock that exists, and I sincerely congratulate all honourable members that have been involved in today's, setting today's business and promoting and somehow trying to find that way forward. I give way to my honourable friend.
I'm grateful to my honourable friend for giving way on that point. I think, although it may be a few years before the House thanks him, the honourable member for Dorset West is doing this House democracy, this government, although I don't think they see it yet, and Brexit a favour by helping us reach a resolution. Would he agree with me that there are 3 dangerous canards in the House this afternoon? 1, that this is a dangerous precedent. The House has always controlled its own time. 2, that this is a Remainer conspiracy. All of us signing this are supporting the government's bill and want to get it through. And 3, that we're tying the government's hands. These are merely indicative votes to give the front bench some help to see where there might be a census for a plan B if, heaven forbid, we need it.
Well, my honourable friend is mind-reading me, because I was firstly going to congratulate my right honourable friend for West Dorset on the remarkable achievement that he's got to getting us here today. And I would also like to say how I too supported the government on both material votes. And if the government bring it back, I will support them again. But what I will not do is stand back and watch our country fall off a cliff into the abyss.
West Streeting.
Thank you, Mr. Speaker. There is one reason, and one reason alone, why we're here debating this business of the House motion, and that's the vacuum created by the government through their total lack of leadership over this process. There was a very simple way to see the proposal put forward by the Right Honourable Member for West Dorset defeated, and that was when the government, given the opportunity again and again and again to set out their own path, their own plan for indicative votes, they rejected it at every single point. I'll give way.
I'd like to thank the honourable member for giving way. It's just I find the rewriting of history rather bizarre, because on Monday I asked the government spokesman whether or not the government would give their own pathway towards indicative votes this week. And he said yes. And that is the basis on which I said it would be better to have the indicative votes led with the government, and that's why I think that's the best way forward. But quickly, if I could, if we are to have the voice of this House, does he agree with me that it would be good if we got to vote on all the options that have been suggested today and not just some of them?
I'm grateful for that intervention. The selection is a matter for the Chair, as she knows. But just to be clear, she's right to say that the government said they would lay out their own path, but when asked by member after member on what day, for how long, on what basis, there wasn't a single response. And this is the heart of the problem with the government, making it up as they go along. The government's got to decide which charge it's laying at the feet of the House, because either this is a Remainer Parliament trying to overturn the will of the people, as the Prime Minister's claimed, I think, again and again, particularly with her incendiary statement last week. Or, I think more accurately, this is a Parliament in which the vast majority of members who voted Remain also voted to trigger Article 50, as I did, with the trust and understanding that we would have a government that would competently manage negotiations, that would reach out across the House and try and build consensus amongst members of Parliament and, most importantly, the electorate. I'll certainly call it.
I'm grateful to my honourable friend for giving me, because the nub of this issue is that this entire Parliament has lost trust in the government, which is why we don't trust them when they say they will bring back motions for debate. And isn't the crux of this that if the government wanted to prevent any kind of historical precedent of this Parliament taking control of the order paper, all they had to do on Monday night was simply accept the amendment from the honourable gentleman?
I wholeheartedly agree, and with the limited time I have left, I just want to say something about the trust that the public have in us as members of Parliament and in this House of Commons. It is difficult, particularly when the country voted one way and Some of us, myself included, voted a different way. It has been a difficult process of trying to navigate our way through something which is completely unprecedented in the history of our country, trying to remove ourselves from the most sophisticated political and economic alliance the world has ever seen. You know, it took 7 years to organise a 2-week sporting event in the London Olympics. Not necessarily surprising. It's taken more than 2 years to try and negotiate our way out of the European Union. But what I think is completely unforgivable is the way the government have botched the negotiations at every turn, have failed to try and achieve consensus. And when amendments have been brought forward at every single stage, whether on the single market, on the customs union, on different negotiating priorities, different principles, at every single point the Prime Minister has said, it's my way or the highway. And that is why we are in the bind we are in now. And, you know, all of us, whatever our particular views on the last referendum, now have a responsibility to try and break the deadlock. That's what the Right Honourable Member for West Dorset is trying to achieve, to test the will of the House, to see if there is some way of achieving consensus and trying to find a way through this damaging and unprecedented period of our history. So that's the responsibility resting on our shoulders now. All of us, when we go through the division lobby imminently, I think, have a responsibility to show to our country that this Parliament is taking control of the process, that we are determined as Members of Parliament to act in the interests of our constituencies and our countries at every point, that whether we voted Leave or Remain or whichever options we choose to vote for, we're doing it for one reason and one reason alone, and that's the furtherance of our national interests, defending the jobs, the livelihoods, the hopes and the prospects of the people that send us here. I think, whatever our differences, I think this House is full of people with honour and integrity. And we have the opportunity in the coming days and weeks to show that to be true.
Order. Under the resolution of the House of the 25th of March 2019, I must now put the question necessary to bring proceedings to a conclusion. The question is as on the order paper. As many as are of that opinion say aye. Aye. Of the contrary, no. Aye. Division! Clear the lobby. Order. The question is as on the order paper. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Chris Elmore and Jeff Smith. Tellers for the noes, Mike Freer and Joe Churchill. Up the doors! the Sergeant please investigate the delay in the no lobby? I'm grateful. Order! Order!
The ayes to the right, 331. The noes to the left, 287.
Thank you. Order. The ayes to the right, 331. The noes to the left, 287. So the ayes have it. The ayes have it. Unlocked. Order. We now come to the motions relating to the United Kingdom's withdrawal from and future relationship with the European Union. I inform the House that I have selected the following motions for decision by recorded vote. Motion B, in the name of Mr. John Barron. Motion D, in the name of Mr. Nicholas Bowles. Motion H, in the name of Mr. George Eustace. Motion J, in the name of Mr. Kenneth Clark. Motion K, in the name of the Leader of the Opposition. Motion L, in the name of Joanna Cherry. Motion M, in the name of Dame Margaret Beckett. And motion O, in the name of Mr. Marcus Fish. I shall ere long call John Barron to open the debate and to move. The honourable gentleman doesn't need to be unduly concerned. And he will do so by moving his motion, motion B, colleagues, please, with which it will be convenient to debate all other selected motions on the order paper. Debate may continue until 7 p.m. The first signatory of each of these motions, colleagues, has until 4 p.m. to inform me that they do not wish a recorded vote to take place on their motion. Shortly after 4 p.m, I will confirm, on the strength of the intelligence I've received, my selection of motions. At that point, colleagues, voting forms will be printed. They will be available from the vote office and in the division lobbies from approximately 6:30 p.m. An announcement will be made on the annunciator when they are available. The forms will look very similar to deferred division forms, except that they will be green and they will list the title and letter of the selected motions. The text of the motions is in the order paper. Moreover, I hope it will be judged to be for the convenience of the House, and it has been requested of me, that large numbers of copies of the order paper will be available in the division lobbies. The voting period is expected to start shortly after 7 p.m. and will last for half an hour. During that time, I will suspend the House. The annunciator will display the end time of the voting period. Members with surnames from A to K should hand their forms in the I lobby at the relevant desk for their surname, and members with surnames from L to Z should hand in their forms in the no lobby at the relevant desk. As with deferred divisions, members may not vote aye and no to the same motion. If
in the cabinet.
I shall not respond to that disorderly heckle. However, if that were to happen, what I have just counselled should not, the vote would not be counted. As with deferred divisions, members may not hand in forms on behalf of other members. Each member must hand in his or her own form. Members with proxy votes in operation will need to get their nominated proxy to hand in their form. A short note is being made available in the vote office confirming these arrangements. I will announce the results in the chamber as soon as they're ready, which will certainly not be before the conclusion of proceedings on the statutory instrument relating to exit day. The results of the votes will be published in the same way as deferred divisions on the Commons Votes website and app, and in Hansard showing how each honourable member voted on each motion. Colleagues, last Monday, the 18th of March, I made a statement to the House explaining the standard which would have to be reached for me to allow another so-called meaningful vote under the statutory framework provided in the EU Withdrawal Act 2018. I cited page 397 of Erskine May and concluded that a proposition which is the same, or substantially the same, may not be brought forward again during the same parliamentary session. This Monday, the 25th of March, in the course of answering questions following her statement, the Prime Minister accepted this constraint, saying that, and I quote, "I am very clear about the strictures that Mr. Speaker gave when he made his statement last week, and were we to bring forward a further motion to this House, we would of course ensure that it met the requirements he made." I understand that the Government may be thinking of bringing meaningful vote 3 before the House either tomorrow or even on Friday, if the House opts to sit that day. Therefore, in order that there should be no misunderstanding, I wish to make clear that I do expect the Government to meet the test of change. They should not seek to circumvent my ruling by means of tabling either a notwithstanding motion or a paving motion. The table office has been instructed that no such motions will be accepted. I very much look forward, colleagues, to today's debate and votes which give the House the chance to start the process of positively indicating what it wants. To move the first motion, I call the honourable gentleman, the member for Basildon and Billericay, Mr. John Barron.
Mr. Speaker, can I thank you for choosing this particular motion? And I refer honourable and right honourable members to motion B.
Order. Sorry, I should be most grateful if... No, I've already called the honourable gentleman. He started to speak, and in any case, I'm on my feet, so the honourable gentleman shouldn't rise to his feet when I'm on mine. And somebody as concerned with procedure as the honourable gentleman might usefully become acquainted with that important procedural fact. I was just going to appeal to colleagues and I think the intervention has helped me to do so, to leave the chamber quickly and quietly so that we can proceed with the debate and each contributor enjoys the respectful attention of the House which he or she deserves. Mr. John Barron.
Yeah. Thank you, Mr. Speaker. And I look to move motion B, submitted in my name and other Right Honourable and members of this House. And that is, the motion reads, so that the House is absolutely clear, that this House agrees that the UK shall leave the EU on the 12th of April 2019 without a deal. May I suggest to the House that actually, as we stand at this point in time, this is in law the default position of triggering Article 50. We all knew, those that were here who did vote for it in February 2017, that what we were voting for. It simply said that we would leave the EU on the 29th of March with or without a deal. And we passed that by 384 votes in February. And what I would suggest, I will do in a second, I'm going to make some progress first. What I would suggest now is that whilst Article 50 can be extended, I voted against the extension, but it can be extended, we should still, as a House, reflect on that vote and recognise that whilst most of us in this place want a good deal, many of us have taken the view that the deal on offer from the Prime Minister is not a good deal, and therefore the legal default position is that we leave on no deal stroke WTO terms. I will indeed.
I thank my honourable friend for giving way. Can I ask a clarifying question about the meaning of this amendment? Does the honourable member mean to say by this amendment that even if a deal is reached and agreed before the 12th of April, we should nonetheless still seek to leave without a deal? Can I just get that clarified?
My honourable friend is right to seek clarification. No, my preference, as I've already stated, is that we leave with a deal. And if we do leave with a deal, with the backstop duly amended so that we could not, as a country, be caught indefinitely in that backstop, that would be my preference, and then this would no longer apply. Which is why the date is set there, because as the honourable member will well know, that's the date given by the EU if there is no deal. If there's no agreement. But can I remind members also that whilst most of us in this place prefer a good deal to no deal is still preferable to a bad deal. And we are left in this position now, given that it looks as though the Prime Minister's deal, unless there's a major shift in this place, is not going to pass. I don't think it will come back, but even if it does, I don't think it will pass. The default position is we're leaving on WTO terms. And I'd just like to remind the House, Mr. Speaker, that actually, despite all the predictions of doom and gloom, we trade profitably on WTO terms with the majority of the world's GDP outside the EU. And we have been assured on several occasions, I will in a second, we have been assured on several occasions by ministers, and indeed by the Prime Minister, that we are prepared for a no-deal exit. I will give way to the Honourable Lady.
Thank you, Mr. Speaker. I'm most grateful to the Honourable Gentleman for allowing me to intervene with him. Let me just take a moment to remind the House, and particularly the Honourable Member, that Northern Ireland has not had an executive, has not had a government since January of 2017. We have no ministers in Northern Ireland. The head of the Northern Ireland Civil Service has warned as recently as the beginning of this month of and his words were, the grave consequences for Northern Ireland if we were to leave without a deal. Does the Honourable Gentleman have any respect at all for the head of the civil service in Northern Ireland, or indeed for the people of Northern Ireland?
The gentleman responds, it might be helpful to the House if I explain that no fewer than 47 members are seeking to contribute in the debate from the back benches, with very constrained timetable, plus 3 front benches. So speeches of more than about 5 minutes are going to render it impossible for everybody else. Now, the honourable gentleman didn't know that when I called him, although he could have reckoned with the likelihood of substantial demand. So economy is of the essence. Mr. John Barron.
I will take this one intervention, if I may, as it was asked, Mr. Speaker, and then I will move on. I have a great respect for the people of Northern Ireland. Having served there in the 1980s and got the medals to prove it, I do take into account what the people of Northern Ireland, as part of our union, have to say. But at the same time, we are part of a United Kingdom, and I would suggest to the Honourable Lady that there are predictions on both sides of this discussion as to possible outcomes. And we just saw the Taoiseach now suggest that you did not need a hard border to solve what's become known as the Northern Ireland backstop problem. So I would suggest there are differences of opinion, and we should need to recognise that in this debate. Mr. Speaker, I will take note of your stricture, and I'll just make very quick haste in my remaining comments. We have been assured by ministers time and time and time again, both in committee and in this place, that we are indeed prepared for no deal. We have spent billions on no deal. 4.2 billion is the figure that seems to be current currency. And I would suggest that when the Prime Minister answers very directly a question that I posed to the Prime Minister at the dispatch box on the 12th of February, and it was a very simple question, are we going to be prepared? She answered in 3 words, indeed we are. Now I have to take at face value, I won't, thank you very much, I have to take at face value those reassurances by ministers that we are indeed prepared for no deal. But can I also, Mr. Speaker, come on to what seems to be a prevalent argument in this place, that no deal would lead to disaster? Not just in this place, but outside this place as well. And what I would respectfully point out to these people is that these are often the very same people who predicted doom and gloom in 2016 should we vote to leave. In fact, some of the predictions were so dire that they were beyond credibility. I mean, we had predictions that we'd have 500,000 people extra unemployed by December 2016 if we voted to leave. Some estimates put it up to 700,000 people extra unemployed. We had predictions of self-made recessions. We had even predictions, in some cases, of conflict on the continent of Europe. They were all proved wrong. So much so that the Bank of England, for the first time in its history, to my knowledge, had to publicly apologise for getting it so badly wrong. And what's happened since then? We've had record low unemployment, record high manufacturing output, record investment. And those decisions, during the course of the last 2 or 3 years, have been in the full knowledge that we could be leaving the EU on no-deal stroke WTO terms. And what I would gently remind members is that investment is about comparative advantage. It's about such factors as what is your level of corporation tax rates compared to other countries? How flexible are your labour markets? What about your top universities? What about your financial expertise? In aggregate, in total, they actually are of greater influence when it comes to investment than 3 to 5 to 7% WTO tariffs. And I would ask the House just to reflect on that, because there are too many wild predictions flying around this place when really the argument or the discussion should be based on economic reality. And I would go one stage further. By introducing a fair and controlled immigration policy, wages will rise faster in this country than if that immigration policy was not in place. And that is something that Lord Rose, as the House will remember, who was leader of the Remain campaign leading up to the referendum, actually said in front of a Treasury committee. So I would suggest to the world that suggest to the House that scare stories that, somehow we're all heading for doom and gloom, that goods will no longer transverse customs unions, trading blocs around the world, they already do that, is very wide of the mark. Let's base this discussion, let's base this vote tonight on economic reality, and much as a few on the opposite benches, particularly the SNP, don't like to admit it, actually we're doing rather well economically. And as I've said, those decisions have been based on the possibility of us very much leaving on no-deal terms. So I would appeal, Mr. Speaker, given your guidance as to timings, I will bring my comments to a close. What I would suggest is this, though. I appeal to the House for rational consideration with regards no deal. I know there's a lot of scare stories out there, but this is a repeat. This is a repeat of 2016. Those scare stories were wrong then. They're wrong now. Let's have a note of optimism about the future of this country, a note of optimism about the capability of this country. Let's back this country. And if we can't get a good deal, then let's actually get back to economic reality and realise that we already trade profitably with the majority of the world's GDP outside the EU on WTO terms. There is no reason we can't trade with the EU on such terms, and I urge or recommend the House to support motion B.
Hear, hear. The question is as on the order paper in respect of the honourable gentleman's motion, and we now proceed, because the honourable gentleman has in a timely way completed his oration, to the next contributor to the debate. Sorry? Yes, and I'm proposing what might be called an indicative time limit, and an indicative time limit of 5 minutes. Mr. Stephen Kinnock.
Thank you, Mr. Speaker, and thank you for the great work of the Right Honourable Member for West Dorset, who's making today's proceedings possible. I rise today to speak in support of Amendment D, in my name and the name of the Honourable Member for Grantham and other Honourable Members. Mr. Speaker, this really is 5 minutes to midnight for this Parliament, for this Government and for our country. We desperately need to find a way out of this mess. Our country has spent 2 years tied up in knots by the Prime Minister's incompatible red lines, which offered such a narrow interpretation of the referendum result. A 52-48 vote was certainly not an instruction for a disastrous no-deal or a hard Canada-style, job-destroying Brexit. It was an instruction to move house, but to stay in the same neighbourhood. The EFTA-EEA model offers just that possibility. It respects the referendum result without wrecking the British economy. Not convinced? Well, it's worth remembering what Nigel Farage told a Question Time audience in 2016. I hear people say, he said, wouldn't it be terrible if we were like Norway or Switzerland? Really? They are rich, they're happy, and they're self-governing countries. Or the member for North Shropshire, a passionate Brexiteer, in 2015 told us only a madman would leave the market. Or the member for Uxbridge and South Ruislip, who's also been supportive of the single market in the past. The point I'm making here is that in 2016, Euroscepticism meant something that it apparently no longer means today. Today, Euroscepticism means setting off. I'm sorry, the Speaker said we've got very little time, so I'm afraid I won't be able to take any. Today, Euroscepticism seems to mean setting off into the Brexit fantasy forest of unicorns and rainbows. Yet in 2016, Euroscepticism meant simply being opposed to political integration whilst cheerleading for the single market. And that, in a nutshell, is what Common Market 2.0 is all about. What does it require? Well, first, it only requires a renegotiation of the short political declaration on the future relationship, which the EU has consistently told us it is open to amending. The reason that Labour politicians such as myself have rejected the Prime Minister's deal is because of that political declaration, not because of the withdrawal agreement. That is because the political declaration offers no long-term guarantee on workers' rights and does nothing for the services sector, which is 80% of our economy. It is membership of the single market that delivers for workers' rights and for the services sector. That point was made explicitly by Francis O'Grady of the Trade Union Congress just this morning, and by the Society of Motor Manufacturers and Traders this morning also, who were absolutely clear They didn't mince their words. A customs union alone will not deliver on workers' rights or on frictionless trade at our borders. Trade unions and business voices came together to make abundantly clear that we need single market membership. Under Common Market 2.0, we would maintain full participation in the single market through our membership of the European Economic Area by joining the EEA's only non-EU pillar, the European Free Trade Association. We would add to this a comprehensive customs arrangement with the EU, at least until alternative arrangements to secure frictionless trade on the Irish border can be agreed via other means, for instance, new technology. The EU has indicated that this bespoke combination is available for the UK, given the need to preserve the Good Friday Agreement. A major strength of Common Market 2.0 is that it's by far the fastest viable route to Brexit. We could be in the EFTA pillar by the summer and in a customs arrangement well before December 2020, removing almost all the risks of the unpopular backstop ever coming into play, unpopular with some members across the other side of this House particularly. Mr. Speaker, there are very clear benefits to Common Market 2.0, not least that it delivers on what the majority of the British public actually want from Brexit. On the doorstep in my Aberavon constituency and the doorsteps of my other colleagues, I hear the same message time and again from our voters, particularly older voters. We voted for a common market. We didn't vote for all the political stuff. Common Market 2.0 continues our close economic relationship, but we would leave the EU's political institutions, leave the jurisdiction of the ECJ, leave the common agricultural and fisheries policy, and leave the EU's drive towards ever closer political union. We would see a marked improvement in our position on the freedom of movement through the safeguard measures written into Article 112 of the EEA Agreement. These safeguards would give the UK a qualified but unilateral treaty-based right to suspend... Mr. Speaker has said, I'm sorry, that we haven't got time for your interventions. Would give a qualified but unilateral treaty-based right to suspend freedom of movement.
The honourable member did name me, and I think it's convention that a member name can answer back. He used a quote on a television programme.
No, it is customary... sorry, it's just that the Honourable Gentleman can't make his point via a point of order. It is customary but not obligatory. And it's not for me to say that people can or can't intervene, and I'm not seeking to do so. I'm just reminding the House of the time constraints under which we operate. Mr Stephen Kinnock.
Thank you, Mr Speaker. These safeguards would give the UK a qualified but unilateral treaty-based right to suspend freedom of movement if that country believes it is suffering serious societal or economic difficulties. These measures, in essence, reflect what David Cameron tried, but failed miserably to negotiate with the EU before the 2016 referendum. It would end the seemingly limitless nature of EU migration that does concern many voters. It is often said that the UK would become a rule-taker, but that is a ludicrously simplistic view. Under the terms of Common Market 2.0, the UK would leave the jurisdiction of the ECJ and would therefore end the principle of direct effect. This is because the EFTA Court that the UK would join respects national sovereignty in a way that the ECJ doesn't, and new laws have to be approved by each nation and their national parliament. It is also worth noting that we'd have 1 in 4 EFTA Court judges rather than the 1 in 28 EU judges, and that only 1/3 of EU law applies to the EEA anyway. We would restore policy-making power in vast areas including agriculture, fisheries, foreign and justice, security affairs, justice and home affairs, and taxation. While it is true that the EFTA states do take on most single market rules, it is worth remembering that they enjoy the option to delay, adapt, or derogate from any single market law or directive. Any decision to incorporate law must be unanimous. So, in effect, this gives not a vote in the EU process, because of course we're leaving the institutions, but it does give a veto at the national level. Norway and Iceland have derogated from EU law on more than 400 occasions. The Norwegian Prime Minister has also made clear that her country is ready to facilitate us joining the EEA via the EFTA pillar. Michel Barnier has always said that a so-called Norway Plus deal would work, and that the only reason it hadn't been considered was due to the Prime Minister's red lines. Mr. Speaker, Our Common Market 2.0 motion brings together Leavers and Remainers, and 3 different parties in terms of those who have signed in support of our amendment. This breadth of support, I believe, is extraordinary and unique. I'm not sure that any other option has that, and certainly not revoking, nor a no-deal Brexit, nor for a confirmatory vote in terms of that spread of Remain and Leave opinion. We do need to find a way not just of uniting this House, Mr. Speaker, in a solution that will get us out of this constitutional and political crisis in which we find ourselves, but which can also begin to reunite our deeply divided country. It is time for British politics to rediscover the lost art of compromise. It is time for the House to support the motion that we are putting forward today, and I genuinely hope that members from all sides will join me in the division lobbies to do so.
Thank you, Mr. Nicholas Bowles.
Thank you, Mr. Speaker, and I want to join my honourable friend for Aberabon in proposing motion D. And I too want to make the case for compromise, not as something cowardly, but as something courageous. In a divided country and a divided parliament, finding and sustaining a compromise that most people can support is a noble endeavour. After years of paralysing conflict, we have a moral duty to open our minds this afternoon and reach for a compromise that will allow us to put the interminable Brexit row behind us. The great strength of the Common Market 2.0 proposal, relative to all other Brexit compromises, is that it offers something important and valuable to everyone and every party in this House. For honourable and right honourable members in the Labour Party, it offers that strong position in the single market which, as Francis Grady has confirmed, is vital for workers' rights. For honourable and right honourable members in the SNP, Common Market 2.0 preserves the principle of free movement of labour, which they tell me is essential to Scotland's future economic prosperity and social cohesion. But for those in other parts of the UK worried about the possibility of another massive influx of European migrants like the one we experienced after Poland and Hungary joined the EU in 2004, it offers an emergency brake which could be deployed as a temporary safeguard in the regions affected. For my honourable and right honourable friends on these benches, Common Market 2.0 offers the prospect of being able to benefit from the free trade agreements struck by the European Free Trade Association, or to do our own trade deals once alternative arrangements to maintain no hard border on the island of Ireland have been agreed with the EU. I'm happy to give way.
I thank my honourable friend for allowing me. My rule today is to only support things that are realistic and deliverable, and I think what he is presenting and what I have read of what he's presenting ticks both those boxes. But can he confirm that Common Market 2.0 would not require Northern Ireland to accept different rules than the rest of the UK, which has been the stumbling block that has just held us in this purgatory for so long?
I'm very grateful to my honourable friend who did a heroic thing earlier this week, and I salute him for that. And I'm grateful to him because he literally leads me to my next point. For our allies in the DUP, Common Market 2.0 removes any threat to the Union because it keeps every part of the United Kingdom inside the single market and a comprehensive customs arrangement that delivers frictionless trade. For honourable and right honourable friends representing Scottish constituencies and coastal communities around the UK, Common Market 2.0 guarantees our exit from EU's common fisheries policy and our rebirth as an independent coastal state.
Would my right honourable friend give way?
Of course I'll give way.
I thank my right honourable friend for giving way. Would he confirm that the Common Market 2.0 proposals would entail continuing to follow single market rules with no say? The Bank of England have advised against that. Unlimited free movement would continue with only a limited and temporary possibility of restricting that. And according to the House of Commons Library, financial contributions would continue at around about half the current level.
Mr. Speaker, I'm happy to confirm some of what my honourable friend said, but not the first point about not having a say over the rules. There is an absolutely crucial process for EEA members called the EEA Joint Committee. All new rules passed under single market legislation are referred to that committee, and members of the EEA have a right of reservation, which means that the postal directive, for instance, is still never been implemented by Norway because they don't like it and they just say no. That right would extend to us if we were to join. I give way to my honourable friend.
Speech. And does he agree with me? Even under WTO rules, every single UK exporter into the EU will still have to comply with all EU rules and regulations. There is no way that once you leave the EU, you can somehow remain a rule maker within the EU.
That is right. It's absolutely correct, and it is also correct that almost every single producer in this country is hardly going to have one set of rules just for their UK sales and another set of rules for their European sales. They'll have one standard set of rules, and they will probably be following the European ones. I give way to my right honourable friend and then my honourable friend.
I'm very grateful to my honourable friend who's making a very good case to add to that of the honourable gentleman who opened. Will he emphasise also that actually more than two-thirds of the entire directives that currently apply to us as EU members would cease to apply because we'd only be in the single market and not in the rest of the institutions?
Right, Mr. Speaker. In Common Market 2.0, in the EEA and EFTA, only single market legislation is relevant to us. All of the rest we are free of. And it's very important to understand that even by 2011, Norway and Iceland between them had not implemented 300 legislative acts under single market legislation. They simply said no to those acts of legislation. I give way to my honourable friend. Apparently, Mr. Speaker, I've answered his point, which gives me more pleasure than you can believe possible. For all of us in this House, Mr. Speaker, who care deeply about the security of our fellow citizens, but perhaps in particular for the Right Honourable Member and my good friend, the Right Honourable Member for Pontefract and Castleford, Common Market 2.0 offers unfettered access to the databases and information sharing programmes of the EU. That is only available to countries that are members of the EU or of EFTA. I give way.
Honourable gentleman for giving way. Could he just clarify whether under Common Market 2.0 there will be a temporary or a permanent customs union?
So my honourable friend, as ever, puts her finger on the nerve, shall we say. There are different views in this House about our commitment to a future customs arrangement. On this side, we would like to have a customs arrangement that guarantees friction in this trade until there are those alternative arrangements that the EU has approved, which might set us free to be able to strike our own trade deals. And the honourable lady shouts unicorn from her seat. Well, it's not exactly what the EU have said. They just said they're not ready yet, and they don't know when they will be ready. On the other side of the House, honourable members want to have a permanent customs union. The beauty of our motion today is that it allows us all to vote for it, because the truth is we don't need to make that choice now. Those alternative arrangements won't be ready for several years, and at the next election, those parties opposite can argue for a permanent customs union, and we can argue for free trade or the EFTA free trade agreements, and we can agree to pursue our different visions of the future. I will give way one last time to the honourable lady.
Friend for giving way, and he's making a very powerful case for this being the least damaging form of Brexit. The trouble is that it will end up pleasing no one, neither the Remainers who voted to remain, and a very significant number of those of his colleagues who voted to leave. Yeah. So wouldn't it be best, if it doesn't have the consent of this House, to at least check it has the consent of the people? Would he agree to link it to a public vote so that we can check that it really is the will of the people?
Mr. Speaker, the honourable lady makes a powerful argument, and as she has consistently done. But the funny thing is about this position is what's happened in Norway. Now, this was meant to be temporary for Norway. They went into this thing on their way into the EU. And the Norwegian elite, all of them, both sides of Parliament, all the business elite, everybody else, they all want to get into the EU. But the Norwegian people consistently say, no, thank you very much. We're quite happy where we are. 65 to 70% of the Norwegian people say, do you know what? This halfway house is absolutely perfect for us. And my prediction is that is what the British people would conclude too. So, Mr. Speaker, to wind up, each of us today is a leader. The Prime Minister has one vote. The Leader of the Opposition has one vote. So does every other honourable and right honourable member. In years to come, the question that our children and grandchildren will ask us is this. In that historic week when Parliament took charge of the nation's destiny, what did you do? Did you stand up and lead? Did you step forward to help reunite our country? Or did you hang back in your party trench, waiting to be told what to do and where to go? I have already made my choice at the cost of my future career in this House. It is now time for others to choose. To all honourable and right honourable members, I say this. If you choose Common Market 2.0 this evening, the history books will record it as the moment that our country turned a corner. And the part you played will be something of which you will be forever proud.
Thank you. Sir Keir Starmer.
Thank you, Mr. Speaker. Can I welcome this debate? It's a historic day for this Parliament and for the power of MPs. And in that spirit, I'm going to keep my remarks very short, Mr. Speaker, because this is a day for backbenchers and for those putting forward their case for particular propositions. And I know there are, I think, 47 members who want to speak. So let me go straight to this. Mr. Speaker, Labour's approach today is that we will support amendments that are consistent with the two credible options that we've set out on a number of occasions. Firstly, a close economic partnership based on a customs union and close single market alignment, and a public vote to prevent no deal or a damaging Brexit. And we will oppose those amendments that either offer no route forward or set out an approach that's inconsistent with our policy. And in that spirit, I can confirm that we will be whipping tonight to support Amendment K in my name and in the name of the Leader of the Opposition, Amendment J, the Customs Union Amendment tabled by the Father of the House, Amendment M in the name of the Right Honourable Member for Derby South, tabled, of course, after much consultation and support from the honourable members from Hove and from Sedgefield, and I'll come on to Amendment D in just one moment. Let me start with Amendment K. This mirrors the 5 pillars of the plan that we've set out on many occasions, both in this House and in the letter to the Leader of the Opposition to the Prime Minister in February. I'm going to just make some progress because I have spent a lot of time at this dispatch box and I've been able to make my case. Others, I think, want to make their case today, and I want to give them the opportunity to do so. Mr. Speaker, Amendment K mirrors the plan we've set out. It was in the letter from the Leader of the Opposition to the Prime Minister in February. I remind the House that the pillars are a comprehensive and permanent customs union with the EU, close alignment with the single market, dynamic alignment on rights and protections, accompanied by much stronger commitments on agencies and security. We've never pretended this would be easy or painless to negotiate. It involves compromise and negotiation, but we do believe that it could be negotiated, and it would form the basis of a deal that protects jobs, rights and the economy. Mr. Speaker, Amendment J on the customs union. Labour's support for a customs union is well known. I want to be clear, a customs union on its own is not enough. A customs union does protect manufacturing, supply chain, and is relevant to the protection of the border in Northern Ireland, but it has to be part of a wider package, hence our Amendment K, which sets out the package we believe is needed. But the amendment is worded to specify that a customs union is a minimum part of any deal, and we will support it on that basis. I'll just make some progress and then I will. Turning to Amendment M. We will support this amendment tonight because at this stage it's now clear that any Brexit deal agreed in this Parliament needs further democratic approval. That is what this amendment would do. It would put a lock around any deal that this Prime Minister forces through at the 11th hour, or any revised deal that comes about at this very late stage. It would ensure that any Tory Brexit deal is subject to a referendum lock, and it's consistent with commitments I and the Leader of the Opposition have made from this dispatch box in recent weeks. Mr. Speaker, in relation to Amendment D, the Common Market and the Norway Amendment, I will in just one moment. I want to be clear. We do have concerns about this proposal, and it hasn't been our preferred option. And we have concerns about the commitment to a permanent and comprehensive customs union, though I listened carefully to the words that were just exchanged in the House. But we do recognise that this would deliver a close economic relationship with the EU. It would help protect jobs, rights and the economy. It is credible and it is deliverable. So we believe this amendment should remain an option and continue in the process, and we will therefore be recommending that Labour members vote for it tonight. Mr. Speaker, this is an extremely important and welcome debate. It's frankly 2 years overdue. This is the debate the Prime Minister should have started 2 years ago at the beginning of the process, but we are where we are, and Parliament finally has the chance to shape the way out of the Prime Minister's mess. Thank you, Mr. Speaker.
Thank you. Mr. Kenneth Clark.
Mr. Speaker, may I first of all join in with those who have congratulated my Right Honourable friend for Dorset West by giving us this opportunity. At last, I think, we're already seeing as we go along the House is moving into a mood where it is going to be possible to end the catastrophic shambles of the last 6 months. We are beginning to talk about actually being able to take decisions founded on some sort of cross-party consensus and some search for a majority that can be sustained through the difficult and long negotiations that were required to reach agreement on our final relations with the European Union. And it's up to this House, it seems to me, to respond to that properly and deal with this procedure with a willingness to compromise with each other and move towards some eventual binding, I think, recommendation to the government about the way in which things should be conducted in future, and I shall certainly approach it in that way myself. My right honourable friends also help the government, actually, although they're bitterly resistant to what he's done, raising absurd constitutional arguments which are complete fiction and which they could have remedied easily if they'd put down their own proposals for having indicative votes, which they told us they were going to 2 days ago. So this sort of hair-splitting thing about the government should table business motions and not backbenchers is a completely piffling irrelevance. But actually, my right honourable friend from Dorset West has helped them considerably, because I've never seen the right-wing members of the European Research Group more apparently panicked by the way in which the House as a whole is moving. They're demonstrably in a minority. Their dreams of a no-deal departure are fading, despite the frequent meetings with the Prime Minister and their gliding into Chequers at the weekend. They're beginning to peel off now one by one, having first of all rebuffed it. So I congratulate those ministers who resigned in order to get this pressure going and bring us nearer to reality, and those who put this process together. But turning briefly to the substance of how I'm going to vote. As I say, I will vote not for my first preference, I will when it occurs, but actually for that which I can live with. Because I think, unfortunately, we are doomed, in my opinion, to leave the European Union within the next 2 or 3 years. My duty now is to exercise probably my own judgment, but my judgment of what is the national interest that will minimise the damaging consequences and perhaps save some of the better features for future generations. I have said before, I think, that the obvious compromise, it seems to me, is to, unfortunately, give up the political European Union and leave the political institutions and remain in the common market, as the public still call it, the customs union and the single market, thereby ensuring no problems at borders, no problems for business, the smooth running of trade and so on, And I do think it's that particular compromise. I can't give way, I'm sorry, but I would like to. I've been collaborating with the honourable member, but I must take notice of time. I think it's actually important, not only because at least it would actually economically continue to get the advantages of being in the biggest and most prosperous international free trade area in the world, but also will begin to reconcile the 52% with the 48%. It's a compromise on which I think most sensible members of the public, however passionate their views remain or leave, could actually see the sense of our moving together. It used to be the main Eurosceptic demand 20 years ago, leave the European Union, but I don't want to leave the common market. Just why don't we just stay in the common market? And I think if we solve that, we begin to repair the dreadful political mood in the country. I will vote for revoke whenever it appears on an amendment, because that's my personal preference. That's self-indulgence. I will support. If we get a majority, I'd be delighted. No, I won't give way to my fellow collaborator on revoking, but I will support common market too, and anything that resembles it. So I won't dwell on that further. I've already dealt with that. My amendment J. Now, as I already indicated, it's not my first preference. The two I've already named are my first preference. It's tabled to maximise support in order to get the widest body of support in this House that we can get, so we can move on Monday towards the eventual situation which will enable us really to take control and put the government, actually, although they don't accept it, in a much stronger position than they are today in dealing with future negotiations. But the customs union only does actually a permanent customs union. I would point out to the lady who intervened, is advocated by Amendment J, because it's a permanent customs union we have in mind. It actually does at least keep the minimum to enable us to establish frictionless trade and an open border in Ireland. On top, you will need certainly some understanding or moves on regulatory convergence as well, but that doesn't need to be dealt with at this stage. It would put, if we went through to the next stage, the really important negotiations, it would put some more clarity on what exactly the shape of those negotiations are going to be if it starts on the premise that we're going to be permanently in a customs union. And I think every other EU member state will actually ready to accede to that, and will actually improve the climate in the negotiations from the way forward. And it's, as I say, it's designed to appeal, I must say so, particularly to members of the Labour Party who are demanding it, but also to my more cautious right honourable and honourable friends in the Conservative Party, because those who have hang-ups about rule-making and or use medieval language about vassal states and all the rest of it, well, that's the single market. This Amendment J does not actually include that. Customs union does ensure a reasonably frictionless relationship, the possibility of completely open trade in future, and leaves all those other things to be decided in the negotiations. And I'm not giving way. So that is the basis on which I put forward Amendment J, and I commend it to the House. I say the fact you may prefer another amendment. I shall vote for several. I think we should all vote for as many of these proposals, these motions, as we can. And then we'll see which is the strongest. But we will not be dismissed by the more fervent members of the government saying, well, they've all been defeated, and none of them got an individual majority. And on Monday, we can move forward to how we sift them out. It will, above all, I hope for the Labour Party, pave the way for allowing the withdrawal agreement through, because the main argument is not the contents of the withdrawal agreement. That's not the arguments they've been putting forward. It's the blind Brexit argument which so worries them. Well, even Amendment J, if we can't get a stronger one, it isn't a blind Brexit anymore. The Labour Party could at least abstain. We could then get the withdrawal agreement. Then we can move on to what really matters, which is the serious long-term negotiations on the big issues, which we've got to handle much better than we do now. My last word, if we fail, if we're faced in fortnight's time with no deal, I think the feeling in this House is so strong against that that we must all vote to revoke at that stage. I think a lot of the public would think we've got ourselves into such a mess, it might have been sensible anyway to stop now, sort out what we are doing, and perhaps start again if the House is still enthusiastic to read. But that, I hope we can avoid that conclusion by actually demonstrating that Parliament is capable of orderly debate, reasonable conclusions, and contributing to the better governance of this country as part of this process, including, I hope, my Amendment J.
Order. Just before I call the next speaker, I can inform the House that no lead sponsors have informed me, and I indicated that they needed to do so by 4 p.m, that they do not wish a recorded vote to take place on their motion. So I can confirm the motions on which members will be able to vote are as previously announced, namely motions B for Barron, D in the name of Nick Bowles, H in the name of George Eustace, J in the name of Mr Kenneth Clarke, K in the name of the Opposition, L in the name of Joanna Cherry, M in the name of Margaret Beckett, and O in the name of Mr Marcus Fish. Joanna Cherry.
Thank you, Mr Speaker. I rise with the endorsement of the Father of the House for my motion L, which I'm about to move, and I'm very grateful to him for that. And also for my honourable friend, the member for Nail Nyar, who has prosecuted this issue of revocation with such vigour in the House over the last few months. And I'm very glad, Mr Speaker, that my motion has cross-party support from all parties in this House, the official backing of the SNP, the Liberal Democrats, Plaid Cymru, the Independent Group, and I know many, many Labour members have said to me that they intend to support this motion, and I very much hope that Labour will reconsider their decision not to whip on it. I give way to my honourable friend.
And surely anybody who has said in this House no to no deal has to then support her motion L, because that gives mechanism to no deal, which would be a revocation.
Absolutely, and if there's one thing that we can achieve this afternoon, if we support this motion, is we can categorically rule out a no deal. Because what this motion is a revocation backstop, if you like. Because the motion stipulates that if we get to within 2 days of exit day with no agreed deal, and Parliament does not positively approve no deal, then the Government must revoke the Article 50 notice, and we will stay in the EU. But it's important to understand that revocation doesn't mean that we could never notify our intention to leave again. That is incorrect. If you read the decision of the Grand Chamber in the Court of Justice in the European Union, which, in the case which I and others brought, that's what it says. I will in a moment, but if I could just make this clear. This motion, Mr Speaker, has been carefully drafted by myself and a team of lawyers to give the Government a clear and unequivocal instruction, and it's the only way to make the Prime Minister hold to her promise which she gave this House on Monday when she said, and I quote, "Unless this House agrees to it, no deal will not happen." This motion achieves that unless this House agrees to it, no deal, it will not happen. And it's the culmination of cross-party work which commenced with a group of Scottish parliamentarians, including myself, another SNP parliamentarian, 2 Scottish Greens and 2 Scottish Labour MEPs, and the English QC Joe Mon, who's helped me draft the motion, when we fought the British Government all the way to the Court of Justice to establish that the United Kingdom, if it got into the kind of mess that we're now in, would have the right to unilaterally revoke Article 50. And it's important that the instruction is clear and unequivocal, because if Parliament gives the Government a clear and unequivocal instruction, then if the Government fails to follow that clear and unequivocal instruction, because it's clear and unequivocal, we would have a range of political and legal remedies to make sure that they did what the democratic rule of this House, what the democratic vote of this House was to do. And I give way to the honourable gentleman.
Thank the honourable member for giving way. I just wanted to give her the opportunity maybe to correct
something which she may have not meant to say when she talked about this amendment having all party support. It doesn't have the support of the DUP, because of course we believe that when the referendum result came out, that the people of the United Kingdom had said what they wished, and we do not want to revoke that decision or change.
The honourable gentleman will forgive me if I sometimes forget that the DUP are not part of the government. But I'm very happy. To say that I can live without the support of the Democratic Unionist Party. This is a cross-party motion, except for the DUP, and it continues the cross-party working which got the judgment for the Court of Justice. And what today is about is cross-party working to try and get us out of the mess that we're in. Now, I'm going to make some progress because I'm very conscious of the time strictures. This is actually... Conservative members of this House should support this motion because it's making good on the promise that their Prime Minister, and she still is the Prime Minister the last time I looked, the promise that their Prime Minister made to the Commons earlier this week when she said, unless this House agrees to it, no deal will not happen. Labour MPs should support this because it fits with their manifesto. They said in their manifesto, Labour recognises that leaving the EU with no deal is the worst possible deal for Britain and it would do damage to our economy and trade. We will reject no deal as a viable option. And so this motion is the only means today for Labour to fulfil that manifesto promise. And I know that the Labour Party have repeatedly asked the government to rule out no deal, so I really entreat them to support this motion today as the means of doing that. I give way to the Right Honourable and Learned Gentleman, who is a co-sponsor of the motion.
I'm grateful to the Honourable Learned Lady. Does she agree with me that the point about this amendment is that it is there in extremis? It is not there to summarily revoke Article 50, but only to do it in the event of circumstances where there is no alternative and no ability, in fact, to get an extension that might, for example, deliver a referendum or some other conclusion.
That is exactly so, and I'm very grateful to the Right Honourable and Learned Gentleman for spelling that out so clearly and for lending his support to this motion. Fellow honourable members can support this motion even if they're supporting other motions tonight. So it should be acceptable to supporters of the current draft withdrawal agreement. For some reason that's not on the order paper today, but we might see it later in the week. But if an honourable member wished to support the Prime Minister's deal, an honourable member could also support my motion because it's a fail-safe. If an honourable member wished to support Norway Plus, an honourable member could also support my motion because it's a fail-safe. And very importantly, for those of us who wish to support a people's vote, we can also support this because it's a fail-safe. And it doesn't even preclude a general election, because the way the motion is worded is to make it kick in on the penultimate day before exit day, which is, of course, at the moment a moving target. So it leaves the door open to a general election, which I know some of us would quite like to see, particularly the SNP in Scotland, as we're riding so high in the opinion polls. But today, Mr Speaker, is about cross-party working, and today is also about democracy, because the decision we are taking is of generational importance for the United Kingdom, the decision between revoke and no deal. And it ought to be the representatives of the people of the United Kingdom in this House that decide between revoke and no deal, not the Prime Minister of a minority government. And I give way to my other co-sponsor.
She mentioned earlier the spirit of cross-party working, and as somebody who signed her amendment and she asked about the Labour whipping arrangements, I can assure her that the Labour whip is not to oppose her amendment. It's simply a recommendation to abstain, and I'm sure that a number of my colleagues will be supporting it.
I'm very grateful to the Right Honourable Gentleman for clarifying that and also for his support. But I'm puzzled as to why Labour members would be instructed to abstain on this, as it is the only means for them of fulfilling their manifesto promise. But I leave that to Labour members who I'm sure, like me, will have been receiving the same amount of lobbying,
6 million. Sorry if I wasn't clear. It's not an instruction. It's a recommendation. It's entirely different when it comes to whipping. 6 million people.
I'm grateful to him for clarifying that, and I'm feeling more and more encouraged that many more Labour MPs are going to support this. So I'm not going to take up any more time, and simply to thank all members who have signed and supported my motion.
Extremely grateful to the honourable and learned lady. I call the Secretary of State exiting the European Union, Secretary Stephen Barclay.
Thank you, Mr. Speaker. As the Leader of the House set out earlier, the options that the House considers this evening should be deliverable, and it's clear a number of the options, the amendments before the House, fall short of that test. But as the Shadow Secretary of State, the Honourable and learned H and O, as just two examples. But as the Shadow Secretary of State said, there are 47 backbenchers, and he and I do have quite a few opportunities to debate these issues, so I will, like him, try and keep comments short this afternoon. But before doing so, can I just say, reaffirm that it remains the Government's priority to secure approval of the withdrawal agreement this week, to allow us to leave the EU in an orderly fashion, noting, of course, Mr. Speaker, your earlier comments. It is only by doing this that we can be guaranteed to leave the EU on the 22nd of May and not face a cliff edge in 2 weeks' time. In order to maximise our ability to secure that approval, the Government will, later today, table a motion for the House to sit this Friday. This will be taken as the last order of business tomorrow, and my right honourable friend, the Leader of the House, will confirm business for Friday in her business statement tomorrow morning. While I appreciate it may cause some inconvenience, I hope all members would agree that it is better to have it and to not need it than to need it and not have it. Turning, Mr. Speaker, to the specific amendments before the House, and starting with my honourable friend, the member for Basildon and Billericay, and Amendment B in his name, which seeks to leave on the basis of no deal. He'll be aware that the House has already voted on this issue on Wednesday the 13th of March in terms of its view on leaving on a no-deal basis, and it remains the Government's priorities, as indeed was set out by the official Leave campaign, to have a deal and a trading relationship with the Government. I'll just take one intervention. I'm mindful of the Speaker's stare, so I'll do that and then I'll press on.
If it is the Government's position to ensure that the country does not leave without a deal, and there's no way for the Prime Minister's deal to get through given the Speaker's intervention, why won't the Government allow my honourable and learned lady's motion to carry as a revoke backstop, so to ensure and guarantee that there can be no deal?
Well, I'll come on to the honourable and learned lady's amendment to revoke in due course, but just to take them in order in which the Speaker selected them. So, turning to Amendment L, it remains, which deals with the penultimate sitting day to revoke, which was his honourable and learned friend's Amendment L, to which he refers, which is to revoke on the penultimate sitting day after a vote of no deal. It remains, as he knows, the Government's position not to revoke, and that has long been a matter of policy. Turning to Amendments D and H in the name of the D is in the name of the member for Grantham and Stamford, very good friend, and I know he comes with the spirit of trying to seek a solution for the House. But I think the fact that the labelling of his suggestion has had so many different terms, whether that is it was Norway for now, then it was Norway, then Canada, then EEA plus, Norway plus, and various iterations, I think draws attention to the point that the member for Croydon South made, which is that there are a number of issues with the proposal that he puts forward. And can I just take issue with two very specific points of his amendment? At 1B, my honourable friend refers to the continuing status as a party to the European Economic Area Agreement. Can I just gently say that is factually incorrect? The United Kingdom is only a member of the EA through its membership of the EU, and therefore when we leave, he shakes his head, but that is the clear position of Her Majesty's Government. I will give one, given that it's him, one further point.
I'll be very brief. And my right honourable friend is right to say that this is a legally disputed question, and there are indeed lawyers who agree with him. But I can also cite Sir Alan Dashwood QC, who's the leading silk on EU law, and George Peretz QC, who's the leading silk on EFTA law, who both disagree with him.
So, well, as he will know, having been a respected minister himself, I am stating the clear position of the government law officers on this issue, and this issue has been looked at. And it does actually go to the meat of Amendment H as well, because in line 5 of Amendment H it says that we need to, quote, give notice to leave, which is not the case. Also, just to take on a second item of his amendment, which is item 1E, where he says that freedom of movement can be restricted to those, quotes, genuinely seeking work or with sufficient resources. Again, that is just incorrect. There is an existing position as a member of the EU 28 where control can be put in place. The reason that hasn't is to do with the way that the UK operates in terms of not having registration, not having an ID system, not having an insurance health system. And so there are reasons why that control is not used. So it is, with respect, a fig leaf to try and disguise the fact that his solution does require the continuation of freedom of movement. Well, I've said I won't. I'm conscious of 47 speakers, so I will just press on this occasion. I'm sure we will have a further debate before too many days where we will get to comment. Turning quickly to Amendment J, in the name of the Father of the House, my concern with that amendment is that it will open up a role for the courts, given that it will be for the courts to adjudicate the comprehensive UK-wide customs union and whether that has been met in terms of meeting our negotiating mandate. Amendment O, which is often referred to by some of my honourable right honourable friends as Malthouse, in this case Malthouse Plan B, where we just pay for an implementation period. Well, the position of the EU is very clear on that, is that they would regard it as the UK reneging on an agreed fair settlement, and it is something that they have repeatedly said they are unwilling to accept. In terms of the flaws on Amendment K of the Leader of the Opposition, we have been around these houses so many times, we don't particularly need to dwell on the flaws of that amendment. Amendment at A3, where it talks about dynamic alignment, we've already given a commitment to temporarily dynamically align in terms of implementing the EU workers' rights. And again, it doesn't address the fact that the opposition appear to accept the withdrawal agreement but seem reluctant to say so. So, in conclusion, Mr. Speaker, what we see from the amendments before the House is a range of suboptimal solutions which either don't deliver on the referendum result or do so in a way that doesn't deliver the benefits of the Prime Minister's deal. And that is why the Prime Minister's deal remains the best way of meeting the biggest vote in our history, delivering on that referendum result and doing so in a way that is best for protecting business and citizen rights.
Dame Margaret Beckett.
Thank you, Mr. Speaker. Negotiations succeed when no one gets everything they want, but everyone gets something they want. And I hope that's the spirit in which we can approach today's procedures. This consultative process is too little and too late, but it's a lot better than carrying on as we were. Yeah. And we all owe a debt of gratitude to honourable members and right honourable members on both sides of the House who've striven to find proposals that could command wider support, so that finally some alternative ideas are before the House, and I very much hope some common ground can be identified. But there's one vital thing all these variant proposals have in common. Not one of them reflects what the British people were told were the prospects before them when they cast their votes in 2016. Nor, indeed, I would argue, does the Prime Minister's package, although it's not on the order paper. These differences from what was said to be on offer are substantial. And one element which, to my mind, is absolutely key, figures in each and every one of the proposed alternatives, and that's the matter of sovereignty. Key because all of these proposals, including the Prime Minister's, mean that we would follow EU rules and regulations without having any real say in their content. In 1975, during the first referendum on our links with Europe, I campaigned against continuing those links, mainly because of the diminution of sovereignty that they implied. But at least then, we weren't forfeiting sovereignty, we were sharing it. Today's proposals mean we stand to lose our voice, our vote and our veto. Successive British governments have used voice, vote and occasionally veto to considerable effect. We already have special deals all over the place. We don't have to be in the euro. We don't have to be members of the borderless Schengen area. And we've helped to shape agreements within the EU and as an EU member across the world. Recently, school students across the world went onto the streets to campaign against the threat to life on this planet, including the threat to the continued existence of the human race. Within the EU, the UK has played a substantial role over the years under successive governments in pursuing these issues, and it was experiencing the influence that we could and did wield internationally in this sphere that finally and wholeheartedly convinced me of the value of our EU membership. The Prime Minister's deal, like the various alternatives, to my mind, one and all surrender that shared sovereignty. They do make us rule takers without being, as we have been, influential rule makers. It's clear that many who voted leave have accepted the possible economic damage of which they've been warned as a price they're prepared to pay for the return of sovereignty, and I honour them for that stance. But sovereignty is not returning. In fact, we're sacrificing sovereignty for the sake of saying that we are no longer members of the EU. I recognise that such a deal may be all that's on offer, but to me it's inconceivable that its acceptance should be solely a matter for members of this House. I genuinely have no idea what view the British people might take of these various compromises, and certainly many, including in this House, vehemently oppose their even being asked. And ever since the day of the second referendum result in 2016, a deluge, not just of warnings but of threats, has come from those who take this view, forecasting unrest, civil disorder, greater division, and a dramatic further reduction in the public's trust in politics. But I invite colleagues who determinedly resist a confirmatory vote to look starkly at the full implications of what they're saying. They are willing, some are determined, to vote to terminate our membership of the European Union, even if this may now be against the wishes of the majority of the British people. Consider the possible consequences for trust in politics or for social peace if this House forces an outcome on the people of this country that they no longer desire. That really would be the undemocratic establishment stitch-up of all time. We've all heard people say that the deals now available are worse than the one that we now have as EU members, and some still say, nevertheless, that they still wish to leave. My mother would have called that cutting off your nose to spite your face. But if that is still the view of the majority, then so be it. So be it. But how in all conscience can we alone in this House force through such a decision on their behalf without allowing them any say as to whether that is still their view? I'm sorry, I don't have time. As with the Good Friday Agreement, whatever emerges from these complex negotiations, the outcome should go back to the people for confirmation. The people started this process. They set a desired goal. It's proved far more difficult and tortuous than predicted, but we will now have, soon, a potential outcome. It's the people who should choose if, on the terms now on offer, they still wish to proceed. Theirs should be the final decision on this, which is the first stage only of our withdrawal from the EU. With a clear conscience, I can look my constituents in the eye and tell them that that is the outcome that this House has secured. The European Union needs reform. Britain could play a key role in shaping it, or we can just walk away and live with the consequences. But it's the British people who should now decide what comes next.
George Eustace.
Thank you, Mr. Speaker, and I rise in support of motion H in my name, which involves leaving the European Union but rejoining the European Free Trade Association and relying on our existing rights under the treaty establishing the EEA. It differs from the Common Market 2.0 proposal in a couple of important areas. Firstly, it does not envisage the need for a customs union, and secondly, it does not necessarily require the existing withdrawal agreement that the Prime Minister has been putting to this House. Mr. Speaker, I had a pretty good innings as Agriculture Minister. Indeed, 3 months ago, after a reshuffle in Luxembourg, I became, for a short time, the longest-serving Agriculture Minister in Europe. And in my 5.5 years, I attended the Agri-Fish Council on a monthly basis. I discussed all sorts of obscure and technical issues, and I saw 10 EU presidencies come and go, each coming in with their list of priorities, each going out lamenting the fact that very little had been achieved. In fact, I remember on one occasion the Italian minister, before they were commencing their presidency, casting aside the notes his officials had given him and simply saying, "We will talk about the usual stuff and probably not get much done." The three observations that my experience has given me that I'd like to highlight, because they underpin the approach I've suggested, are, first of all, we must recognise that the European Union moves at glacial pace. It is not agile. It makes tiny incremental changes and takes years to do so. I remember arguing for 3 or 4 years about something as simple as changes to organic food labelling. Secondly, the European Union does not really follow national democracies. It sees what happens in national democracy as a national issue and a national problem. The European institutions live by their treaties and the letter of the word in those treaties. And finally, decades of EU membership has engendered a particular type of culture among our negotiators and our civil service, and I have huge admiration for our civil service, but undoubtedly a qualified majority voting system is all about trying to get something rather than be willing to walk away from the table. And that is why, in both the negotiation that David Cameron had and the current negotiation, officials will often come back and claim that things are not negotiable. Therefore, the simple proposition behind motion H is that rather than wade through the treacle and try to negotiate a bespoke deal from scratch, knowing the nature of European institutions, why not instead use existing treaty rights as our starting point and allow things to evolve from that point? Now, the UK is a signatory to the treaty establishing the European Economic Area in 1994, and it is in that role since the EU had no legal personality at that point. And at times, and the Secretary of State repeated it today, the government has adopted a political line to take that claims that our EEA membership automatically falls away when we leave the European Union. This claim is wrong in law. A year ago, I was in Oslo, and our ambassador to Norway was on standby at that time, ordered by the Foreign Office to deliver a letter giving notice under Article 127 of the EEA Treaty, in the event they chose not to. Secondly, During a judicial review hearing in 2017, Sir James Eadie QC, the counsel, representing the government no less, made exactly the reverse claim. He made the claim that we had not taken a decision to leave the EEA and that it is not true. In his submission to court, he claims it is not true that our membership of the EEA automatically falls away. So, Mr. Speaker, it is either the case that the government have been repeatedly wrong at the dispatch box, advised, I'm sure, by government law officers, or it is the case that the government did not give a true account of its understanding of the law to a court. My understanding, having talked about this to several lawyers who understand these things, is that we are indeed a signatory to the EEA and that our rights and obligations remain intact. It is simply the case that to make those rights and obligations operable, we either have to be in the EU pillar of that agreement as we are now, or we have to switch to the EFTA pillar. Under international law, both the European Union and the EFTA states are under an obligation to make treaties work and to work with any consequential changes that might be required to a treaty to ensure that it is operable. An application to join EFTA cannot be unreasonably refused, and indeed, in my discussions with both Iceland and Norway, they have made clear that they would not stand in the way of such an option. This option is sometimes described, Mr. Speaker, as the Norway option, but it's an option that has a very British pedigree. Members in this House 60 years ago, in 1959, were debating the establishment of the European Free Trade Association. It was this House, when there was a cross-party consensus that the political and democratic costs of joining the then EEC were too great, that forged ahead to build an alliance of countries, including Norway, but also Portugal, Austria, Sweden and others, to form the European Free Trade Association. It was an idea that was supported by both Harold Macmillan and Harold Wilson. Would it really be such a bad thing to return to that model, given that we were the godfathers of the European Free Trade Association? Mr. Speaker, in conclusion, the benefits of this approach are that we can get things done quickly. We can join the EFTA surveillance system within 3 months and full EFTA membership within 6 months. We would have a ready-made free trade agreement. We would be outside the customs union and have an independent trade policy, but we would have control of our fishing grounds again. We would have an independent agriculture policy. We would become an independent country again.
Yeah. Hilary Benn.
Thank you very much indeed, Mr. Speaker. Isn't there something really quite liberating about the debate that we are having here this afternoon? Because the normal atmosphere, the normal structure, one side or the other, propositions, has all disappeared as the House of Commons has taken control of this really important discussion about how we're going to take our country forward. And the other thing that is striking, that every single member who's spoken in support of a proposition has not sought to rubbish the other propositions. They've put their case in an effort to win support from across the House. And if that isn't confirmation of the wisdom of the House having, I don't like the phrase taken control, because I think it's the House doing its job to allow us to do that, then I don't know what is. I want to just make 2 points. The first is to say that I will be voting for the Customs Union motion moved by the Father of the House, because everyone in this chamber knows it is an essential building block of making any progress to achieve actually the 2 objectives the Prime Minister herself set, keeping an open border and at the same time keeping friction-free trade, moving to oil the wheels of our industry. I will also vote for the Common Market 2.0 proposal, although, like many others, I note on the one hand, on the other, when it comes to a customs union, a customs arrangement, and it is a compromise proposal, but I will support it. I will also vote for the confirmatory referendum. Now, I just simply want to say I thought we heard an absolutely outstanding speech from my right honourable friend, the member for Derby South. And I'll be voting for it as someone who, for a long time, has not argued for a people's vote. But I want to just explain why I have come to the conclusion that a confirmatory referendum is the only way forward. It is, in essence, because things have changed. And the proposition that was put before the British people in the form of the Prime Minister's deal, the proposition that was made by the Leave campaign during the referendum, that one did not have to choose in some way between our sovereignty on the one hand and the economic health of the country on the other, has been proved to be false. It has proved to be false, and I think I'm not going to give way, and I hope the honourable member will forgive me because there's so many people who want to speak. But I think the anger that we have seen expressed by some members towards the Prime Minister's deal is in part revealing of the fact that the truth is there is a choice to be made. And the suggestion that somehow we could have all of the things that we wanted without any of the things that we did not has proved not to be the case. And therefore, if things have changed, should we not ask the people? And the second and final point I want to make is this. Is the government changed its mind originally on whether the House would have a meaningful vote. The government did at one point say there'd be an enormous row about the structure of the negotiations, and then changed its mind and accepted the way in which the European Union wanted to conduct them. The government has come back once already and may well this week come back again in an attempt to persuade us to change our mind about the withdrawal agreement and the political declaration. The first holder of the post of Secretary of State for exiting the European Union has changed his mind about supporting the deal. There are reports that the honourable member for North East Somerset may be in the process of changing his mind. The Prime Minister changed her mind about the fact that we were definitely, 108 times she said it, we're going to leave on the 29th of March 2019, and we're not. Why is it, Mr. Speaker, that the only people in this debate who apparently are not allowed to be asked whether they have or have not changed their mind is the British people? How can that be democratic? And if members agree with that argument, that it isn't democratic, then I hope very much that they will vote for Amendment M tonight.
Mr. Marcus Fish.
Thank you, Mr. Speaker. It's a pleasure to follow my honourable friend, but let's actually remember the people in all of this. They voted 2 years ago to leave the European Union, and then they voted in an election on where we stood on a manifesto saying that we would leave the European Union and its two main pillars, the single market and the customs union. Those are integral to what the European Union is. And they want to see their instruction carried out now. So I, to be honest, think it's quite shameful to be calling for a second referendum before the first one has even been implemented. The reality is that the single market and customs union, if we went down that road, and most of the motions that are there today, not at this point, most of the motions that are there today are to do with trying to implement those anyway, even as we leave, in contravention of that manifesto and the referendum result. But they effectively give away our trade policy, and they effectively give away our control of our regulation in our own country. And both of those things are very, very valuable to our economy and to our future as a nation and to our children. And it's worth just pointing out, because I don't think many people quite understand, with respect, what a customs union, rather than being in the customs union of the European Union, actually entails. Many people think that this allows frictionless trade, but that isn't correct. What it does mean is that we would have to implement a system of movement certificates
There would be export declarations associated with those. It doesn't take away the need for border formalities and for recording of goods moving across borders. I'm not going to give way because I know a lot of people want to get in. But the other point is that we would not be in control of various aspects of it. So we wouldn't be in control of the conditions, those conditions of the formalities at the border. We wouldn't be in control of the money collected by tariffs. For example, if goods were coming to our market but via Rotterdam, the tariffs on those imports, effectively to us, would be collected and kept in the European Union. So it doesn't control our money, and it doesn't give us control of the access to our trading partners to our market, and it doesn't also give us control of our traders access to our trading partners' markets. So it really is inconceivable to me that we should even be considering a permanent customs union as a feature of leaving the EU in any recognisable description. And so that, I think, is one reason why people outside this place are quite confused by some of the suggestions that the House has been coming up with. The other thing to understand is that many of the single market proposals and the customs union proposals that are on the table tonight, they don't obviate the need for a backstop in the withdrawal agreement. And so the problems of the withdrawal agreement, which some on my side have been highlighting, and others, those problems would remain anyway. So the problems of being hostage to fortune within the further negotiation of how those customs union arrangements might work, or how the single market arrangements might work to, for example, give exemptions on fishing, as we heard earlier, and other matters, those would still be up for negotiation, where we were in a relatively weak position in that negotiation. So the hostages, for example, of defence manufacturing, which would be prejudiced by the backstop should we end up having to go into it. The same for agriculture, the restrictions on state aid for our agriculture while the EU is allowed to subsidise its agriculture. Those still remain. The issue of Northern Ireland, what happens to Northern Ireland should we not be able to agree, still remains. So I don't really see these things as particular solutions. So, and it's also possible, and to come to the circumstances of my motion, point of order.
Honourable Gentleman's pardon. Point of order, Mr T.B. Perkins.
Speaker, the Honourable Gentleman's been on his feet for 5 minutes. He hasn't yet had an opportunity to tell us why we should be voting for his motion. Can we encourage him to actually tell us about Amendment O, rather than what's wrong with all the others?
Yes, and it would be, indeed, it would be best if he would expedite the process in light of the number of colleagues who wish to contribute. Mr Marcus Fish.
Thank you, Mr Speaker. That's exactly what I was getting on to. So this motion O is about, and I move it, it's about what happens in the circumstances that we can't agree a withdrawal agreement for one reason or another. There are a host of circumstances where that might occur. The European Union might not want to do it. They might not want to extend. There are all sorts of different permutations that could have an impact there. And I don't think that we are, as a House, going to revoke Article 50, because that really would be a finger in the eye to the public. So we have to have a Plan B. And this sets out the Plan B arrangement, so a contingency arrangement, which is in essence a 2-year stopgap arrangement to facilitate trade and allow space for our longer-term negotiation to take place. So it consists of effectively having a trade preference with no tariffs, no quantitative restrictions. It involves having mutual recognition of standards and conformity assessment, and it involves having a customs arrangement, but which consists of advanced trade facilitation measures. And we are prepared to pay money for that, and indeed to agree potentially other measures that are within the withdrawal agreement, given that the EU will no doubt want to try to agree some of those things, like on GIs that we've agreed. So this is a practical approach, and it's a compromise which was discussed in the Malthouse process, of what we do as a backup if we can't get anything else done. So it is, in fact, a very fair settlement. It does involve money, contrary to what the Secretary of State said. We know that EU business wants to trade with us. We know now that the EU and Ireland have no intention of putting up a hard border, and I have no doubt that they have our alternative arrangements that we proposed, and that's how they would want to implement it. So that's how we're going to do this. This is simple to agree. It doesn't prejudice what the future relationship is with the EU, so we can keep talking about that, and it's pro-trade and pro-business with the EU as well as the rest of the world. It honours the referendum and our manifesto, and I commend it to the House.
Thank you. Mr Ian Blackford.
Thank you, Mr Speaker. I'm most grateful. Can I apologise to honourable and right honourable members? Given the time constraints, I'll not extend the usual courtesy of taking interventions. Mr Speaker, I'm particularly pleased to be participating in this debate because today we can start to bring an end to the chaos. Parliament has taken back control because this Tory government, this Prime Minister, is out of control. Mr Speaker, Scotland did not ask for this crisis. Nobody asked for this chaos. And, of course, Scotland voted to remain in the European Union. We voted overwhelmingly to protect our economy and the freedoms and the values that the European Union give to the people of Scotland. Scotland is a European country. Historically, we have been a European country. Economically, socially, culturally, we benefit from our membership. Today, the SNP laid a motion to ensure that Scotland's voice is heard, because Scotland's wishes have been completely ignored during the Brexit process. This is in stark contrast to the European Union that seeks consensus and fosters collaboration through its institutions and throughout the community. A partnership of equals, in stark contrast to this place where there is no equality of respect for the devolved institutions. The lack of appreciation of how the UK should work post-devolution will, Mr Speaker, haunt this place. Increasingly, those living in Scotland will reflect on the way that we are treated in this union, the United Kingdom. It is most certainly not the partnership of equals that the Prime Minister had promised us. It is one where we are told quite simply that our votes don't count, where we can be stripped of our European citizenship, and for what? Where we will pay a price, economically, socially and culturally. The facts are clear. Brexit will rob Scotland of jobs. It will rob our economy of talented workers, our public sector's needs. It will steal opportunities to travel and learn from our EU partners and for future generations. It will divide relationships, families and friendships. Mr Speaker, there is no such thing as a good Brexit, and it must be stopped. We must act to protect the interests of our citizens, of our communities and of our nations. Today it is the opportunity, perhaps the only opportunity. Mr Speaker, today in the European Parliament, my friend and colleague Alan Smith MEP asked Europe to keep a light on for Scotland, to show us the way home. I want the EU to keep a light on for Scotland. For members of Parliament, we must decide, can we follow that light, or is the United Kingdom heading into the darkness? Scotland will not follow the UK into that darkness if the UK fails to change course. We can and we will follow the light to allow Scotland to become an independent country in the European Union. Mr Speaker, I want to make it clear that tonight the Scottish National Party will vote for our preferred options on the order paper. We will vote for a second EU referendum. And we will vote for motions to revoke Article 50, as revocation may be our only option to get out of this mess. These options must remain on the table. The Scottish Parliament votes today to endorse revoke in the event of a no deal. We expect that to be backed on a cross-party basis, and friends and colleagues, let me say, that includes the Labour Party. Revoke must be an option. Therefore, I ask that members also support motion L, tabled in the name of my honourable and learned friend for Edinburgh South. However, let me speak specifically to some of the other motions before us today. We on these benches would firstly like to seek some clarity from the main opposition in terms of their motion. For Scotland, freedom of movement without any caveats is essential, not just in principle, but for the sake of the prosperity of our nation. Can the Labour frontbench confirm to members of this House that their motion today protects and continues the policy of freedom of movement in full? Turning to the motion in the name of the member for Grantham and Stamford, let me be very clear. We on these benches do not and will not endorse the Prime Minister's withdrawal agreement. The agreement bill requires the consent of the Scottish Parliament, and the UK Government have already broken that process. The people of Scotland voted to remain, and as I noted in my earlier remarks on the amendment in the name of the Leader of the Opposition, for the SNP, freedom of movement is essential. Our nation's future, our public services, depend on it. We must have total confidence that in any way that the Norway Plus proposal, freedom of movement as we currently benefit from, will be continued, and that we will have access to the single market and the customs union in full. We also have a further question regarding his proposal for customs arrangement and the prospect of alternative arrangements to ensure frictionless trade. Now, I hear the member's assurance on the point of freedom of movement, and we will not oppose his motion this evening. It will certainly be very difficult for us to support it, however, particularly while Remain is the option that we demand. So, Mr Speaker, let me make it clear. The SNP wants to find a way forward. Our preferred option is to remain in the European Union. That is what Scotland voted for. And as long as that is an option, we will vote for it. But we have always said that if it proves not to be possible, we will seek compromise to protect Scotland's interests. We set out previously what compromise is for us. And remember that would be compromise from a position where the country we represent did not vote for Brexit and our national parliament is opposed to Brexit. That compromise, endorsed by the Scottish Parliament, is Scotland's place in Europe, published way back in December 2016, ignored by the UK Government, and proposing full membership of the European single market and the customs union. But that position is not encapsulated yet in any of the proposals brought forward tonight. Our compromise requires full acceptance of freedom of movement. It requires respect for the position of the Scottish Parliament and for devolution as a whole. We put that compromise time and time again for over 2 years, but it's continually been ignored. Whilst in principle we know that some honourable members agree with us, we must be clear there is more work to be done for those on the Labour and the Tory benches to get to a position that we could accept, if we cannot put this matter back to the people or choose to remain in the EU. However, when I look at the order paper, I can see that there is space to compromise. There is a better way out of this mess. On Saturday, over 1 million people marched to ask that they get the chance to vote on their future within the European Union. Mr Speaker, I was proud to stand with them and alongside our First Minister. People across from all parts of the United Kingdom now know the price that will be paid for Brexit, economic disaster, and they want another say. Members across this House may feel some discomfort, some unease about a second EU referendum. But I say to all of you, what is more respectful to the electorate when this place has repeatedly failed than giving them back control? There is nothing to fear. The Prime Minister does not have support for her deal. This House has not found a solution. So let us do the right thing and end the stalemate by letting the people decide. I urge members to join with the SNP to compromise at this critical hour and to vote for a motion to hold a second EU referendum. Mr Speaker, in conclusion, the UK Government is flogging a dead horse, running down the clock, hoping that the squeeze of time will bring support for the Prime Minister's devastating deal. We can end this today. We can take back control and stop the Prime Minister. We can show leadership and maturity. The people want it. Let's do the right thing. Find a consensus to protect the interests of all our citizens. Yeah.
Thank you. Order. A 5-minute limit on backbench speeches must now apply with immediate effect. Nicky Morgan.
Thank you very much indeed, Mr. Speaker, for calling me speak in this important, groundbreaking and unprecedented debate. I was pleased to be one of the 30 MPs on this side of the House who helped to secure this debate to happen. I am sorry, in a way, that it is happening, but the fact that it is happening shows that, unfortunately, so far, the government strategy of getting a withdrawal agreement through this House has not succeeded. But to be clear, I will vote for that withdrawal agreement if and when it is represented to the House, because I think it is the best way for us to leave the EU in an orderly fashion as soon as that is practicable. Mr. Speaker, I would have risen to speak to Amendment N, standing in my name and the name of other honourable and right honourable members, but obviously it has not been called today. But a word at the top of that amendment has been used several times. It's been used by the member for Aberavon. It was being used by the SNP leader who has just spoken, although I wasn't entirely sure that what he asked people to do fulfilled its strictures, and that word is compromise. And that is a word that is absolutely and an action that is needed to be practised by members on all sides of this House if today, and potentially Monday, is going to have an effect. Because the point is that honourable and right honourable members should be voting for what they could countenance today, not what is their preferred option. If we stay in our silos and our trenches, as I've spoken about before, we will, as a House, not find a way through this, and unfortunately we will fulfil what the Prime Minister said last week, which is that this House cannot find a way through. And I think we will not have done our job as parliamentary representatives if that is the case. I'm sorry that the honourable member for Grantham and Stamford is not in his place, because in Common Market 2.0, which is a proposal I will support tonight, he talks about customs union and customs arrangements. And one of the advantages that have been involved in the Malthouse Compromise talks is that there are alternative arrangements that can be secured to avoid a hard border on the island of Ireland. Because what we want to avoid on that border is no physical infrastructure and no customs formalities at the border. And it is possible, with 5 key changes, which there isn't time to talk about today, but there might be in future debates, and I'm very happy to talk to any honourable or right honourable members about those key changes. It would be possible to negotiate those changes. Now, the Leader of the House talked about any solution being deliverable and negotiable. And having alternative arrangements to avoid the need to be in a customs union is both deliverable and it is negotiable, because we know the EU have already conceded the principle of them. In the documents tabled by the government on the 11th of March, before the last meaningful vote, the EU have clearly said that such negotiations on those arrangements should commence immediately. Now, Mr. Speaker, I heard earlier on your strictures to the government about the test that has to be met in order for the withdrawal agreement to be brought back to this House. You want to see significant change. Well, one way of achieving such significant change would be to allow the UK and the EU time to negotiate those alternative arrangements and put them into the withdrawal agreement so that the backstop is superseded. And actually, looking at the names who had signed Amendment N, you can see that there are members of this House who are ready to sign up to that as a principle. My previous life as a solicitor negotiating M&A deals, I spent many less than happy hour locked into meeting rooms with fellow lawyers and with clients where, frankly, we just didn't leave until the deal had been done. And that is what needs to happen now in order to get this backstop replaced and the alternative arrangements secured, if that is what members of this House wanted to do. My personal vote tonight will be I will vote for any option that gives a negotiated settlement that leads to an orderly exit from the EU. The question for this House, which may arise after Monday, which I have to see, is what the government's response to that is and how any government is going to implement what this House has chosen potentially to identify as a way forward. There may well be difficult decisions for the government to make, but also for this House about the form of the government that takes that forward. Will we need even greater cross-party working to arrive at a solution and a government that can negotiate the outcome with the EU? Although today is an important step forward, it really is only the start of the process of arriving at compromise, and I entirely agree with the chairman of the Brexit Select Committee who said, really, we should have started this process 2 years ago, and I think the country, this Parliament and the Government will be in a much happier place.
Thank you.
Yes.
Yvette Cooper.
Yeah. Mr. Speaker, I think this is proving to be an extremely thoughtful and considered debate. It is the debate that we should have been having 2 years ago. But I think there's been an appetite on all sides of the House and from all different perspectives to have over 2 years ago. And I think there was also a spirit right across the House from those who voted leave and those who voted remain to come together and to find a way to make the process work. It's why so many MPs on all sides of the House, I think, voted for Article 50, but also put forward proposals through select committees, through different debates, and wanted the chance to put forward amendments as well. It's why I called for a cross-party commission to oversee the negotiations from the very beginning. Only sadly that didn't happen, and the Prime Minister didn't want to do things that way, and that, I think, is why we are in this terrible mess now, and why, frankly, our constituents are tearing their hair out. Whether they voted leave or remain, people are feeling deeply frustrated and let down. And just as our constituents do come together, employers and trade unions, neighbours and friends, people in different parts of communities, and they come together to compromise and to sort things out, and that is the responsibility on us now. And it is why, in the indicative votes, that has been such an important proposal. I think we will all of us have to compromise. We will all of us have to vote for things that we don't necessarily think we agree with every single bit of the motion or every single bit of the idea, but we think there is the basis to find some form of compromise. When the CBI, who represent 190,000 businesses, British businesses, and the TUC, representing 5.6 million British workers, have come together to describe this as a national emergency, there is a responsibility on us to act. And they spoke together with other members of a national industrial coalition in Parliament this morning in a meeting called by the member for Meriden and the member for Birmingham Erdington, and said a plan B must be found, one that protects workers, the economy and open Irish border, commands a parliamentary majority and is negotiable with the EU. It's why I have put my name to the Customs Union amendment today, because I think it's something I called for from the beginning, but is also something I think can be the basis of finding consensus and building agreement. Local businesses in our area, our big manufacturers from Burberry and Haribo, local retailers and distributors like Asda and Teva, small businesses, traders, farmers, florists, retailers have all warned they need a deal which avoids border delays, tariffs or extra customs bureaucracy. And it's why we heard from the motor manufacturers, the National Farmers Union, the aerospace sector in the meeting this morning, all again calling for a customs union. It's why it's been at the heart of the Labour motion as well, and the Labour alternative Brexit approach, and also why the TUC were arguing the importance of the Common Market 2.0 approach, and it sets out to, I think we have seen in these options and in other points made by members across the House, that there are a range of options that we should consider that mean we can continue to oppose the chaos of no deal that would be deeply damaging for all of our constituents. And I keep very much in mind the words of a friend of mine who I was talking to in Pontefract last week, who is waiting for cancer treatment, waiting for radiotherapy, but does not know if that treatment will be delayed because no deal could put at risk the supply of the short-life isotopes that are needed for radiotherapy. And in his interest, and in the interest of patients across all of our constituencies, as well as those who could be hit by higher food, fuel and utilities prices in the event of a chaotic no deal, we have to continue to argue against that. I take a different approach to that put forward in motion L, because I think that we in those circumstances should be arguing for more time to try and get resolution, to agree more time with the European Union to frankly sort things out. But whatever the outcome today and on Monday,
We're going to have to do two things between us that the government's fundamentally failed to do. To get clarity on what Brexit means, but also to build consensus, because this is constitutional change that we are talking about, and without consensus, nothing lasts. On Scottish and Welsh devolution, consensus was built and they last. On the Lisbon and Maastricht Treaty, consensus wasn't built, and actually they haven't endured. The support for them has not endured. So I say the same is true, I think. Unless clear consensus can be built, the public consent or public vote will be needed through a general election or referendum, otherwise it will not last. It's in all of our interests to build consensus, to come together, to do what we should have done 2 years ago.
Thank you. Mr Andrew Percy.
Mr Speaker, I plan to be quite uncompromising in my opposition to Amendments M and L, and then, without a hint of hypocrisy, argue for compromise in terms of where we end up. Now, we've heard a lot in this debate recently about marches. The only march I am interested in is the march of my constituents in that referendum in 2016 to vote, as they were asked by this Parliament a final time on our membership of the European Union or not. We were not told that we were promised, rather, by both sides in that campaign that the decision of the people would be implemented. That was what the Remain side and the Leave side said. And the Remain side spent the whole of that campaign telling voters how terribly complex leaving the European Union was going to be, how really difficult it was. And yet voters still went out, many of them for the first time in my constituency. I had people stopping me on election day saying to me, how do I vote? Where do I go? How do I do this? Because I want to express my opinion on this question that Parliament has told me is mine to make and will be implemented. And now to go back to those people, just because some people in here don't like it, or rather more because we've actually messed it up amongst ourselves, this whole process of leaving, to then turn around and say, well, we've made such a terrible mess of it, we're going to go back on all of those promises, is completely unacceptable. And I am appalled at the way in which my voters, many of my voters, 70% of them who went out and voted Leave, have been belittled and besmirched since they took the decision they were asked to make. Their age has been an issue in a democracy. Age, an issue as to how valuable your vote is. Their educational standards have been an issue. Whether they've had a degree or not has apparently it places some value on your vote. They have been told that they live in the wrong part of the country, that they have views that they do not have, but people have told them why it is they took the democratic decision they had every right to take, and that they were promised by this House and by both sides would be implemented. So I say I'm not going to give way, because I do want to stick to the 5-minute timetable. So it would be appalling, Mr Speaker, to go back in a second referendum. And how would I say to a constituent who said to me the other day when he contacted me, they said, why is it in this matter of the European Union, Remain only has to win once, but Leave has to win twice for our decision to be implemented? So yes, it's complicated, yes, it's difficult. Some people in this place may even have deliberately made it more complicated than it need to have been, so they could be proven right. Certainly there has been incompetence that has made this more difficult than it should have been, and I will not say where that incompetence has necessarily come from. But it would be appalling, Mr Speaker, to go back to constituents. I think what it would unleash as well would also be pretty dangerous, because I am saddened by how certain elements in the extremes of the political sphere have tried to take hold of this issue for their own particular disgusting brand of politics, which I want nothing to do with. And there is no doubt those people would play a bigger role in a second referendum. It would divide the country in a way. For what purpose as well? To then perhaps, if you look at the current polling, maybe reverse the result in the other direction. And I just think this is a very dangerous thing that this House should avoid at all costs. I'm not going to have time to really say a great deal about the idea of revocation. I know this has been put forward by the SNP. I do wonder what their response would have been had we had a successful Scottish referendum and then this House had decided it knew better and decided to revoke that referendum. Now to the compromise, Mr Speaker, because I have been, since I came to this place, my views on Europe haven't changed. I've seen some of my colleagues move into further positions which I cannot get my head around, but we need to bring this to a conclusion. And we need to bring it to a conclusion through a process of compromise. There is a lot in the Prime Minister's deal I do not like, but I have voted for it and will continue to vote for it. And I've put my name to the amendments for Common Market 2.0 and for EFTA. I have concerns around the issues with free movement, because some of my constituents clearly have very strong views on that. But this is a way in which we can come together. We can say and accept the result of that referendum, which was people saying very definitely they do not like the political institutions of the European Union. There is a way through this. So I do think this House should look very closely at the propositions in terms of Common Market 2.0 and EFTA. And I will be supporting, though, I'll be voting for every leave option this evening, Mr. Speaker, because I just want to get this damn thing over with and resolved in line with what my constituents voted for in 2016. And my final comment, Mr. Speaker, is this, which is that I hope, Mr. Speaker, we will, and I have been a big supporter of yours in the Chair, I hope we will have the opportunity to again vote on the Prime Minister's deal. I do think this is an important way of trying to bring this to a close.
Thank you. Alison McGovern.
Thank you, Mr. Speaker, and I don't agree with much of what the honourable member just said, apart from when he said that it should be a priority to get this damn thing over. Yes. And I think he made a fair point there. Today has been a difficult day, but we are all here with the best of intentions to seek to represent the interests of our constituents and to do right, Mr. Speaker, by our consciences. And I want to support all members who are speaking in this debate and all who will participate in this process, because they are trying to express what they feel to be best for our country, and we must pay due respect to everybody in this debate. Absolutely. However, that said, Mr. Speaker, I do think that this process, innovative though it may be, does represent failure. The fact that we are here is a failure of any party to win the general election that was called in 2017, with a clear mandate from the British public as to what Brexit would mean. And it's a failure of the response to that general election being a cross-party agreement about what Brexit would mean that we could all stand by and support. What we are in the business of here is trying to put options before the government and demonstrating support for those options and asking them to think again about how they form a coalition of support for the future course in this House. Which brings me, Mr. Speaker, to motion D on the EEA Customs Union. Now, last June, I voted for an EEA-type Brexit. I rebelled against my party's whip to do so, and I remain glad of that, because if we are to Brexit, I think that is probably the most tolerable form. However, I have a couple of concerns with motion D. Firstly, I think we heard from the member for Grantham and Stamford about this issue of whether the customs union would be permanent or whether it would be in pursuit of alternative arrangements, which I'm sorry to disagree with my colleague, the chair of the Treasury Select Committee. She and I agree on very great number of things, Mr. Speaker, but I just don't agree that alternative arrangements exist, and therefore it's not enough for me. But also, Mr. Speaker, I worry about, since I won't give way because I don't want to try Mr. Speaker's patience, though I wish the honourable members well today in the process that he has created. But for those who voted leave too, Mr. Speaker, I worry now that a policy compromise is not where they're at. I don't think that EEA idea that many of us pursued and voted for previously is really what people think will be Brexit. And that's partly because of the tone of this debate, but it's also because of the fact that those who voted leave don't really accept it as Brexit, and I worry about our ability to sell it to them. But I do wish it well, because it's an option that I think could have been once a compromise. Which leads me to the following conclusion, Mr. Speaker. Do we need a policy compromise, or do we need a process compromise? And I have concluded that it is not a policy compromise that will bring people together, but a process. I think the only thing left is to find a reasonable tolerable, acceptable form of Brexit and ask for it to be ratified by the British public if they wish to. Those of us who remain confident in the value of our European Union citizenship will campaign for the status quo, and those who wish to campaign for Brexit can do so. But I think the only way to deal with this mess is to find that tolerable form of Brexit and ask the British public if that was what they meant by leaving the European Union. And as I said, Mr. Speaker, those of us who still believe in the idea of a European Union that would lift all, include all, and create peace in our continent will campaign for that principle.
Yeah. Thank you. Greg Hands.
Thank you, Mr. Speaker. It's always a pleasure to follow the member for Wirral South. I am going to speak on perhaps the narrow but extremely important topic of the customs union, and specifically against amendments J in the name of my right honourable friend the member Rushcliffe and K in the name of the leader of the opposition. And this is against what I believe to be the seriously defective proposal of a customs union with the European Union whilst not having a seat at the table. Now, I have to say, Mr. Speaker, I've given this question a great deal of consideration over the last almost 3 years, particularly my 2 years spent at the Department for International Trade in charge of trade policy. And a customs union has its superficial temptations. It obviously keeps trade close, although worth pointing out not necessarily frictionless. You need the single market as well for that. It avoids having to agree to free movement, and it may not need financial contributions, and clearly is likely to provide short-term relief for industrial supply chains. But, Mr. Speaker, it would be a historic mistake to do this. Customs unions have been successful in history, but essentially for countries going in the opposite direction, for countries coming together into a political union. If you look at the history of the Zollverein in Germany in the 19th century, that was all part of the process of German unification. If you look at the partial customs union in the name of the European Coal and Steel Community in 1947 or 49, I forget which was a partial customs union as a precursor to the EEC and the Treaty of Rome. But, Mr. Speaker, we are heading in the opposite direction. This is the wrong compromise, and a customs union would give short-term relief at the cost of long-term pain and a democratic deficit which would grow and grow over the years. I've written articles about this, notably today, Mr. Speaker, in Times Red Box. But our trade policy, Mr. Speaker, would end up being set by others. And that is the historic mistake. I'm going to give 4 or 5 very quick examples of where it has a really serious impact on this country. For example, on tariff policy. Tariff policy would be set by the European Union to protect their products from others coming in and would not be set in the interest of the UK, which would likely to be different. For example, the current trade dispute between the United States and the European Union, there are punitive tariffs on bourbon coming into this country. Let us say there is a future trade dispute between the EU and the US involving Scotch whisky. Obviously isn't produced in the European Union, and there will be no incentive for the European Union in that customs union to seek to defend Scotch whisky. The second area would be on trade agreements. We've talked before about the Turkey trap, that essentially when the EU enters into a trade agreement with a third country, that if the UK were in a customs union, we would have to offer access to our markets, but we would not get the reciprocal access to that country in return. That is going to be a massive democratic deficit. Secondly, this is what amazes me, Mr. Speaker, that is the official Labour policy to do this. I remember well the disputes around TTIP. The biggest objections to TTIP came actually from the Labour side. Right. And now we have a situation where trade policy will be determined by others without even a UK seat at the table. Now, if they thought at the time that TTIP would lead to US private healthcare companies gaining access to the NHS, and we had a seat at the table, what will it be like when we don't have a seat at the table? But that is the official Labour policy. On trade remedies, Mr. Speaker, I'm amazed that the member for Stoke had his name on one of these amendments. Absolutely incredible. Trade remedies would now be conducted by the European Union, not by this country. They are currently conducted by the European Union. We have a seat at Trade Council. I was that seat for a long time. And the UK participates in trade remedies to defend our products. There is no guarantee. In fact, it's highly unlikely the EU would do the same, particularly if it's a product not produced in the EU. When it comes to doing a WTO-compliant study of the product, you can guarantee, Mr. Speaker, that the studies which would take priority would be to defend the interests of EU members, not to defend the interests of non-members of the European Union. So I find it amazing, Mr. Speaker. And finally, on trade preferences for access to the developing world, I find it staggering that the Labour Party is proposing ceding control over trade preferences to Brussels without the UK having a seat at the table. That would be unacceptable to my constituents and I believe theirs as well.
Thank you. Kate Hoey.
Mr. Speaker, it's a pleasure to follow the honourable member, who was a brilliant trade minister and who, of course, resigned on a matter of principle, which, of course, we should all remember here, our principles. Can I just say that there's an air of almost self-satisfaction and self-congratulation in the House today, as if somehow this is wonderful. Isn't it wonderful? I think the right honourable member earlier said it. This was wonderful freedom. I feel very, very actually sad about today. I think we should not be in this position. And, you know, you could spend, I could spend, not you, Mr. Speaker, I could spend the next 5 minutes talking about who to blame. But there isn't much point, because we're where we are. But the one group of people that we can't blame are the people of this country, who, in the referendum, voted to leave, thought they were going to be listened to, told by everyone, including the former Prime Minister, that their vote mattered, their vote was going to be implemented, whatever that decision. And since that day, Mr. Speaker, many people in this House have, through very clever ways, using lawyers. We saw tonight, today, one of the honourable members saying she'd even had a very senior lawyer helping her outside to put her motion. These are people who never wanted us to leave and have done every single bit they could in this House. Now, we are in a situation today where all these, I think the public looking in will say, what a nonsense. It's just a lot of waffle. You're just putting loads of different things that are going through. In the end, only the government can make this happen. And the Prime Minister, of course, could still get her withdrawal agreements through if she was to recognise that she, as a Conservative Unionist Prime Minister, could ever have come up with something like the backstop. And that backstop has to be changed. And I understand that absolutely fundamentally. But the one thing today that we cannot see happen is the people of this United Kingdom being told now, you were too stupid to vote the right way, you were racist to vote the right way, you were ignorant to vote the right way, and now we want you to vote again. Mr. Speaker, we want you to vote again in a second referendum, because this time we think you might actually have changed your mind. And I am incredibly disappointed that my party, a Labour Party, who saw the majority of its constituencies voting to leave, are actually whipping Labour members today to vote for a second referendum. I am not giving away to the honourable member. That is just outrageous, and I think those Labour supporters and Labour voters who came back to Labour, Mr. Speaker, and voted Labour, having dallied with UKIP for a while and then believed that Labour actually meant what they said, they are going to see that as a huge betrayal.
My honourable friend, give
I, of course, will give way to my honourable friend.
I'm grateful, and I agree with the thrust of her arguments here. Does she agree with me that the argument that's been put forward today in the Chamber, that we should give people a second vote because they've changed their mind, would lead to a never-ending? Because people could change their mind every year, but all the polling evidence as presented by John Curtis is simply that they haven't changed their mind, and the people promoting a second referendum are about 98% Remainers.
The honourable member is quite right. I mean, we would have to have general elections practically every month, Mr. Speaker, if people who change their minds literally the day after they've voted, perhaps they've changed their minds. So we cannot go down that line. I want to read out what somebody sent me, and I do have a very big Remain constituency, absolutely. But I made it very clear, and made it very clear for 30 years. I'll have been in this place in June, and I've made it very clear from day one that I wanted us to get out of the EU, and everyone has known my views. So I have no apology to make for campaigning to leave the European Union. But one of my constituents did say to me, I thought the manifesto of the Labour Party and the manifesto of the Conservative Party, the two main parties, Mr Speaker, said we will implement the result of the referendum. There's nothing difficult about the word leave. It's very simple, and we have made it difficult here deliberately, people in this House. And he said to me, can we, the electorate, now expect that anything promised in a manifesto is to be honoured, that it should be written into law, that if you promise a course of action, you must follow through and make it happen? Why do party leaders order three-line whips so that what they promised in the manifesto can be reneged on? Mr Speaker, I think we are in a very dangerous situation in this House, where we are trying to thwart the will of the people. Democracy cannot be compromised with. Outside, there is huge anger. We may not see it here in London, and particularly amongst some of the areas of London where there is a very Remain vote. But outside, Mr Speaker, there is huge anger, and it's growing. And we have backed ourselves into a hole where the only way out now is for us to either leave with a WTO agreement, or to find a way that the withdrawal agreement can actually be changed so that we can accept it, and that means there has to be a change to the backstop. I make no apology for saying that I find practically all of these amendments tonight, the word compromise is. I don't think we should be compromising with the electorate, and that's what this process here today is. And we haven't even got, Mr Speaker, I don't make a criticism of you, but it's very unfortunate that we don't actually have Amendment E, which is the one amendment that we could have all, if we believed in the referendum, have gone through with. And anyone who votes to revoke tonight is actually saying we do not accept the result of the referendum. We never did, and we never will. So I hope that will be turned down.
Thank you. Order, order. I have now to announce the results of the deferred divisions held earlier today. I shall do so with the greatest possible dispatch. The question relating to relationships and sex education requires a majority of members of the House and a majority of members representing constituencies in England if it is to be agreed to. The totals for members of the House were as follows. The ayes were 538, the noes were 21. The totals for members representing constituencies in England were as follows. The ayes were 482, the noes were 14, so the ayes have it. In respect of the question relating to animal welfare, the ayes were 322, the noes were 15, so the ayes have it. In respect of the question relating, colleagues, to rural development, the ayes were 316, the noes were 239, so the ayes have it. And in respect of the question relating to rural development, brackets, I merely remind the House of what it knows itself, rules and decisions, close brackets, the ayes were 316, the noes were 240, so the ayes have it. Mr Kevin Hollinrake.
Okay. And it's an honour to follow the Honourable Lady for Vauxhall. And she makes some very important points about manifesto promises and living up to those promises. There are some other promises we need to live up to as well. The Prime Minister, I've heard time and time again from colleagues in this House or speaking on the media, when they talk, they criticise the Prime Minister for setting out her red lines and not budging from their red lines. But for me, those red lines simply represent the promises that were made prior to the referendum. It certainly wasn't just a binary option about staying or leaving. The question about what leaving meant is absolutely critical to this debate, because the promises that Vote Leave set out, as she was a member, I think, of the Vote Leave campaign. Sorry, I apologise, she shakes her head. But the Vote Leave, which was the primary advocate for leaving, quite clearly set out those promises, been to control our borders, control our laws, control our money, whilst having a free trade agreement. It was quite clear in the Vote Leave manifesto. I've read it several times, Mr Speaker, and the words were, there is a free trade area that stretches from Iceland to the borders of Russia, and we will be part of it. Those were the promises that were made. Now, the Prime Minister, I believe, has come back to this House with a deal that does meet the promises that were made. That's what her deal does. And there is not a single amendment in this order paper, a single motion in this order paper, that lives up to those promises. All the rest incorporate compromises but move outside those red lines. She's come back with the Goldilocks deal, not too hard, not too soft, but still people won't accept this deal. And I think we will look back. Certain members in this House will look back, potentially, if we don't approve the Prime Minister's deal in the days and weeks to come, hopefully days, may look back and think that was our opportunity that is gone. And that's the deal we should support, the Prime Minister's deal. Because having a small business background, Mr. Speaker, I do not think it is right that we should think of taking a risk, an uncalculated risk, with the lives and livelihoods of small business people that we know could be affected by a no-deal exit. So we definitely need to leave with a deal. So how do we leave with a deal if we don't support the Prime Minister's deal? It means we have to move at least one of those red lines. And I've got to say, from my perspective, despite the fact it would breach the manifesto promises, I would move the red line on the single market. Because I think that most of the challenges, and there will be challenges, certainly particularly between Northern Ireland and Ireland, are solved by membership of the single market. 80% of the border challenges are about the single market. Barnier said it himself. Customs checks need not happen at the border. We can do without the customs union, but we need the single market for regulatory standards, particularly on foods. A humble cottage pie sat in a supermarket shelf in Northern Ireland has passed over that border typically 7 times. Without the regulatory checks, if you had regulatory checks, it would have to happen, those checks would have to happen every single time according to EU rules. And they make the rules, and we've been part of that for 46 years. We cannot simply say now, we don't want to be part of those, we don't agree with your rules, despite the fact that we've been happy, or relatively happy, to sit within those rules for 46 years. So there are 2 motions that I will be supporting this evening. One is Amendment D, which is brought forward by a number of colleagues here, my old friend Grantham and Aberravon and many other colleagues have been big advocates of Common Market 2.0. It's a free trade agreement. I have concerns about it, about the customs union, about the longevity of the customs union, our ability to exit that customs union. Subsection C in the amendment says we will need to agree with the European Union our exit from the customs union. And I can't see what incentive they would have to let us leave. I've got to say we would also, I think, if we approve that, have to agree lots of things with the opposition. I haven't got an issue with that at all, working cross-party on this, but I do fear that the Labour front bench, as we take this legislation forward over the next months and years, if we approve this, will ask a higher and higher price of us in terms of taking that legislation through, because there is a political divide between the front bench opposite and the front bench here. The other proposal I will happily accept is motion H. It's an excellent way forward. It's bold, it's decisive. I'll be supporting that this evening.
Thank you. Chuka Ramuna. Thank you, Mr. Speaker. 5 quick points, or thereabouts, in 5 minutes. First, it is an absolute utter disgrace that it has come to this, that it is the backbenches of this House forcing the government to follow a process to reach a decision. The Prime Minister should have been the one sponsoring and initiating this process. It's called leadership. But the reason time and time again she has failed to do so is because she always fails to face down the ideological zealots in her own party. Now, she has suggested that if what comes out of this process, and I hope we get a majority behind something, is at variance with what she has proposed, she may simply ignore Parliament. But this is a parliamentary democracy. The campaigns to leave the European Union were fought in the name of parliamentary sovereignty. And is she seriously saying that she can maintain any credibility or authority in her negotiations with the EU Council if she seeks to set her face against the will as expressed by the House through this process? On the substance of these motions, I will be supporting the People's Vote amendment laid by the Right Honourable Member for Derby South, motion M, and I commend her speech, which was excellent and explained far better than I could why we should all support that motion. But I will perhaps just explain personally why I am doing so. As a House, we had a duty in the last Parliament to try and square the circle between the promises that were made in that 2016 referendum and what was deliverable. And that's why I voted against my heart to invoke Article 50 2 years ago. But with every week that has passed, we see that not only did the campaigns to leave the European Union lie, they have broken their promises, and the Electoral Commission have confirmed that they cheated too. Now, I listened carefully to the speeches of the members for Brigg and the members for Vauxhall talking about the importance of delivering upon the result of that referendum. But the problem this Parliament has been grappling with is that it is impossible to deliver on those mythical, fantastic promises that were made back then. And in the face of that disaster, and in the face of the catastrophe that we have seen unfold through these negotiations, the last resort is always to invoke the will of the people. But the simple fact is, ever since that referendum was held, all the signs are that proceeding with this flawed Brexit is far from what this country wants. After the 2016 vote, you would have thought support for what had been voted for would have gone up. But in almost every single poll, we see that support for it has fallen. And let's not forget that that is a poll that was held 3 years ago, and 37% of registered electors voted for it. The most recent poll of the British people was held in 2017, when the Conservative hard Brexit was put to the British people and the party of government lost its majority. If that were not the case, we wouldn't be having this protracted process right now. But above all, I say this to those who talk about the will of the people. Democracy is not static. It is a dynamic thing. We did not, in this country, choose to have a system where you have one general election, a one-party state, and you never go back to the people for a view on things, as our country and the world changes and adapts. And I just want to finish on this point, actually, because they haven't been mentioned in this debate so far. It is the younger generations in this country. And I heard the contribution of my neighbour in Vauxhall. The younger people in our area, in our borough, which is one of the youngest in the country, will not ever forgive this Parliament if it seeks to impose this disaster on them. More than 2 million of them have become entitled to vote since that 2016 poll, and we know that an overwhelming majority of them want to stay on this process, and an overwhelming majority of them want to keep the current deal on the privileges that older generations in this country have enjoyed for years. And that is why, if in the end we are faced at being at a cliff edge, with all the catastrophe we have seen spelt out in Cabinet documents, we know what this is going to mean for people's jobs and livelihoods. If we are on the cliff edge, we haven't got that people's vote, then of course we must do what is in motion L and revoke Article 50, because no one in this House has a mandate to destroy people's jobs and livelihoods. And we know it will do that because the Cabinet has produced its own briefing papers to tell us that's a fact. That is what's at stake here. That is what we have to think about when we make this decision. It's not about us so much as it is about future generations, and it's important we do right by them.
John Stevenson.
Thank you, Mr. Speaker. For many months, we have had broadly the same debate on the same subject, with many of the same speakers saying exactly the same things. And what precisely have we achieved? It really is now time for Parliament to find a way forward so that the country and we can return to the daily issues that really matter to people. Our constituents up and down the country, let's be honest, are fed up and frustrated, and arguably so are many members of Parliament. We, as a Parliament, really need to step up and make some real positive decisions. I therefore welcome today's debate, something which arguably we should have done probably a couple of years ago and got it out of the way. But my starting point is very simple. This country did vote to leave the EU. Therefore, I firmly believe that we must leave the EU institutions. What was unclear from the referendum, though, was the nature of our future relationship with the EU. And as we have discovered, this means many different things to different people and has to some extent created the problems and the difficulties which we are now in. There is no clear direction. This sadly has, in my view, also been down to a serious lack of leadership by the government and unwillingness to bring people together and to reach some sort of compromise. But quite clearly, we cannot go on as we are. We do need some clear direction. That is now a requirement for this country. Hopefully, and I say hopefully, we may achieve that during the course of today. We will have to find out what people in this House are willing to accept by this evening, and maybe something will start to emerge. But to some extent, Parliament has already indicated that it does not want a no-deal scenario, nor does it want a second referendum. And so far, there is no sign that the PM's deal will actually achieve a majority in this House. I have supported that deal twice, and I will do so again. And interestingly enough, had it passed, and I say this to many of my colleagues on my own side, had it passed, we would have actually been leaving the EU this Friday. So from their own perspective, I do actually question what their motives were.
Where are the ERG?
So what should we do? I look back and think my mother has always remarked that back in the 1970s, the general view was that the UK wanted to be part of an economic bloc, but not part of a political union. And I would suggest that nearly 50 years on, when I have these similar discussions with my mother, her view is still exactly the same. We should be part of an economic bloc, but not part of the political union. And I suspect that that is actually the view and the attitude and the outlook of the vast majority of the people of the United Kingdom, and is certainly mine. I am very comfortable with the fact that our country will be leaving the EU institutions. However, I do also believe that it is in our economic and political interests to be part of a close economic arrangement. And for our purposes today, that would be the model of EFTA-EEA, Common Market 2.0 approach, one that takes us out of the EU but keeps us part of the economic market that is Europe. And I would like to have gone into the detail of EFTA-EEA and the Common Market 2.0, but I think that has been well argued by the Honourable Member for Aberavon and the Honourable Member for Grantham and Stamford, and more recently my Honourable friend from Thirsk and Malton. So therefore, Mr Speaker, we have today an opportunity to actually indicate to the Government what would command the support of this House. And that will only apply clearly if the PM's deal does not succeed, but I hope that we can come to some sort of consensus and some sort of way forward. However, I would say this. Leaving the EU is central. Being part of a large economic market is vital, and therefore the obvious solution is an EFTA-EEA arrangement, one that I will be supporting later today, and one that I would encourage other members to support as well.
Thank you very much indeed. Tom Brake.
Speaker, can I start by saying how pleased I am that we've got this far, because in spite of government's attempts to derail this. But can I also say how unhappy and sad I am that we are now on day 1007 since the 23rd of June 2016, and it is now really that we are having the first attempt at this sort of dialogue. And I'm pleased that, in fact, the tone of the debate, broadly speaking, has been positive, with people setting out their views on the different options that are before us. One option that I must speak strongly against is option B, no deal, put forward by the member for Basildon Billericay, because I do think that anyone who advocates no deal is not participating in I think he used the phrase, rational discourse. And I don't think anyone who is advocating no deal could possibly have spoken to business recently, the police, the NHS, UK citizens in the EU, or indeed EU citizens in the UK, because the implications for all of those groups of no deal. So I hope no deal will get soundly defeated today. In relation to option D, now, whilst I think in some ways Common Market 2.0 it would be the best perhaps of the options that are available, at the same time it's possibly one of the worst, because it leaves us rule takers, not rule makers, and would enable those who are antagonistic towards the European Union to carry on their campaign on the basis that we are having to sign up to a large part of the EU's agenda, including making financial contributions, but without actually having any say in the goings-on. So I think in many ways that is probably a halfway house before another push at some point in the future for us to leave the European Union. So I hope that will not be passed today. There are a number of other motions or amendments before us which I'm afraid would fall into the category of unicorns or wishful thinking. The idea that things can be renegotiated at very short notice, new protocols can be found, new arrangements which haven't been found in the last 2.5 years, I think are simply it is wishful thinking to think that that can be achieved in the time that might be available for this. Of course, anything that we do does actually require the European Union to agree to an extension. There are some that are not unicorns, such as the customs union proposal, but I think are far too unambitious in terms of the arrangement we're seeking with the European Union. Really, just the two that I'd like to focus on in the last couple of minutes, of course, is the Amendment L, and I'm very pleased that the member for Edinburgh South brought that forward with cross-party support, underlining that revoke remains a possibility for the United Kingdom and should be a possibility up to the very last moment. We need to have an ability to block a no-deal scenario, and clearly that is what revoke is there for, and I'm very pleased that a joint sort of cross-party effort involved in the court case that went to the European Court secured confirmation that the UK can revoke Article 50 at any point up to the point immediately prior to our departure. On Amendment M, like other members have commented, I think the member for Derby South, her oratory, I hope, will have convinced many people in this chamber, not just those who already signed up to the idea of a confirmatory public vote, but perhaps many others, to come in behind that, because it is very clear, as many members have said this afternoon, and I'm sure others will before the debate is over, the terms of our leaving the European Union, the terms or the explanation that was given 1,000 days ago about what was going to be on offer is clearly not what is going to be deliverable. And, of course, if we do, as a House, decide to proceed with some of the motions here, or some of the amendments here today, clearly those are not ones that are the ones that were voted on 2.5 years ago. Certainly they're not the ones that the Prime Minister says is representative of Brexit, and that's why I think it would absolutely have to go back to a confirmatory public vote, and with the level of cross-party support on that, I hope that it is something that when we get to the next stage we will be able to proceed with.
Immensely grateful. Thank you. George Freeman.
Mr. Speaker, could I start by thanking sincerely my honourable friend, the member for Dorset West, and honourable members for Normanton, Grantham, Aberarvon and other constituencies cross-party who've worked to make this afternoon possible. I believe, Mr. Speaker, that they and all of us participating in this debate are doing democracy a favour, doing this House a favour. Although they won't admit it, I think doing the government a favour and doing the British people who want us to find a sensible Brexit solution a favour. Let me be very clear, Mr. Speaker. I was a Remain minister in the last government, but since the referendum result, I've been very clear that we have to honour and respect that referendum result, both nationally in my duty as a member of this House and locally in my responsibility and duty to the people of Mid-Norfolk, who voted 62% to leave, whereas the country voted 52%. But I have also been consistently clear, Mr. Speaker, that we also have to respect the concerns of the 48% who didn't want to leave, the legitimate interests of those citizens who couldn't vote in that election, particularly the young, whose future we are shaping and who will have to live with the consequences of our actions, and also the legitimate grievances of the 52% who voted to leave. And one of the great disappointments of the last 2.5 years is the almost shattering silence of those who brilliantly harnessed those grievances to deliver Brexit but haven't spoken about how we tackle those grievances, the feeling of blue-collar job insecurity, the lack of proper infrastructure locally, the house dumping, the sense that big government, big debt is working against the localities of this country. And that agenda of renewal has to be right at the heart of delivering Brexit. Mr. Speaker, we were told today that this debate, this hunt for indicative votes was a constitutional outrage, a Remainer conspiracy and tying the government's hands. All three completely false. Firstly, since when is it a constitutional outrage for this House to control its own business? It has always controlled its own business. And for those who say, but the government of the day controls the business of the House, yes, it does so because its backbenchers normally automatically grant it the power so to do. But the sovereignty over our time has always been, since the Civil War, with this House. And to hear the honourable member for Somerset North East pray in aid of medieval and Tudor laws against the sovereignty of this House, which I thought he was the greatest champion for, defending an executive that prefers not to listen, was one of the most extraordinary moments of today. Secondly, a Remainer conspiracy. Well, some conspiracy and some set of Remainers, because all of us working with the honourable member for Dorset West are supporting the Brexit withdrawal bill. All of us. We're not trying to defy Brexit, we're trying to find a way to get it through. And thirdly, tying the government's hands. What nonsense. It's an indicative vote to help the front bench to see where, if there is, God forbid, the need for a plan B or some further concession, where it might be to carry this bill through the House if, as I hope they don't, some of my hardline Brexit colleagues who would prefer a no deal to a deal continue to hold the government to ransom. Let us reach out across the House and find a Brexit that the whole country can support. Tonight, Mr. Speaker, I will be voting for those motions D and H for EFTA, and I'll be voting against the second referendum. In due course, if this shambles goes on and on and on, ultimately the British people will decide, probably in a general election. This House has got to lift every stone, every rock, to find a Brexit deal that can get through. The arguments for EFTA have been beautifully put by others this afternoon. I want to make simply 2 points. The vast majority of my Leave voters in Norfolk said, Mr. Freeman, I voted to be in, or I want to be in, a common market, not a political union. They were stunned when they heard that the Brexit vote was somehow going to be an extraction from all of the single market, from all of the trade benefits of being in Europe. And that's why I think EFTA is such a powerful solution. 2 points. Yes, it requires free movement, but it's free movement of workers, not citizens. And I would argue that it goes with two key reforms. Welfare reform, to make clear that people who come here to work shouldn't automatically receive the universal benefits that Clement Attlee put in place for those who'd fallen on the beaches and paid into our country. They can earn that right. And secondly, a massive programme of blue-collar skills investment to support those fearing economic insecurity. But mostly, Mr. Speaker, I think EFTA has something that no other solution has. It's a settlement of this question. We'd be joining a bloc in Europe which, as we join, we would change the dynamics of Europe. A bloc that's been going for 40 years. It's tried, tested, proven. Business can rely on it. And I commend it as Plan B should the government's deal not go through.
Paul Farrelly.
Thank you, Mr. Speaker. I didn't vote for the legislation for the referendum, nor to trigger Article 50, regardless of the consequences which are now all too plain to see. I made my views clear during the 2017 election, and despite most people's expectations, I was re-elected. So throughout this, I've been consistent and honest, as indeed as the Right Honourable and Learned Member for Rushcliffe. And it was during the last vote, sadly, on the Prime Minister's withdrawal agreement, it was the first time that he and I were in different lobbies. Not because we don't believe that leaving the European Union is a terrible mistake for our country, but because the Prime Minister so successfully ticked the clock down, he was just being pragmatic. Pass her agreement, then live and fight for the future another day. And I respect that decision. And today, I'll also be pragmatic, because otherwise this intransigent, deeply flawed Prime Minister may very well get a no-deal way just so that she can wag her finger at the rest of us and say, I told you so. I think we also owe it today to come to a clear decision to the three ministers who honourably resigned this week to help give us this opportunity, and to the honourable and right honourable members who have done such sterling work in the national, not personal interest. The right honourable and learned member for Beaconsfield has been truly outstanding, as has the irrepressible member for Broxton. Mr. Mr. Speaker, in my local area of North Staffordshire, I now seem to be a lone island of Remain in a shifting sea of Leave as far as members of this House are concerned. And I certainly dread the thought of a second referendum. Powerful, loud and deep-pocketed voices would try and drown out debate with cries of betrayal. But I think we have to be brave. In the interests of our country, we should not shy away from giving the people, including youngsters from 16, a final say in their future. So I do believe that if the House gives a firm steer today, the government should not only listen, but also put the matter to a people's vote with an option to remain. And should it do so, I'll campaign, as we did in Newcastle under Lyme in 2016, for a Remain result. Remain and reform, if necessary, from within. Remain and heed the lessons of history. To keep our place along one-time foes, but for the last 75 years, our partners in peace and prosperity on an often troubled small continent in a rapidly changing world. Mr. Speaker, in 2016 in Newcastle, we fought the referendum as hard as any general election. Sadly, that wasn't evident in all parts of our country. And true, in Newcastle, people voted 60-40 to leave, but not for what happens next. In next-door Stoke, it was 70-30. So actually the difference does show that if you make the argument, you make a difference, particularly when the result, so nationally, 52-48, was so narrow. And what, of course, was missing on the ground in that referendum was the engagement of the Conservative Party. Having introduced the referendum, the party of government took no position in the interests of the party, not of our country. And this is the way the Prime Minister has behaved ever since. But she gained no majority for her approach in the last election, and she's got no majority in the House now for her so-called deal. She stumbles on, and she truly is the stumbling block. Mr. Speaker, when we vote later, I do hope that we will vote to revoke, and I would, or to give us a leeway to revoke, and I urge colleagues not to abstain over motion L. But if not, then I hope that we vote for something pragmatic for a future that keeps us close to our partners in Europe. And to conclude, Mr. Speaker, when we do vote, I will pay great heed to the lead that's been given by true statespeople, like the Right Honourable load of members for Rushcliffe and Beaconsfield, and for West Dorset, Grantham and Stamford, and my friends here on this side for Pontefract and Castleford, Leeds Central, Holborn and St Pancras, and many others. And I hope the Prime Minister will do as well, because it was quite simply wrong for her to do what she did last week in that extraordinary broadcast to the country, to do our Parliament down when it is full of really good people who are a real credit to our democracy.
I'm extremely grateful to the honourable gentleman, Mr. Robert Halfon.
Mr. Speaker, I passionately believe that we have to follow the referendum result of 2016, even though I voted Remain. I voted for Article 50, I voted to keep no deal on the table, I voted against a second referendum, and I voted against a long delay to our exit date. My voting record in Parliament reflects the will of the British people, because I feel that anything else would lead to huge mistrust in our political system. Now, I do also believe that Parliament and politicians are becoming toxic. The 17 million people who voted to leave think that the establishment is against them, too busy playing party politics, determined to stop Brexit. So I would not do anything, and I mean anything, that I believe would undermine the decision of the people who voted to leave. I want a strong Brexit, I want a workers' Brexit, and I want a Brexit that unifies our country. And how do we achieve this? We achieve it through Common Market 2.0, through membership of the European Free Trade Area. We'd be out of the political union of the EU, out of the CFP, out of the Community Agricultural Policy, out of Home Affairs and EU taxation. We'd be out of the jurisdiction of the European Court of Justice. But as EFTA members, we'd have access to the single market, safeguarding our businesses and our jobs. And as has been pointed out by my honourable friend for Camborne, it's worth remembering that it was the British who founded EFTA in 1959. Harold Macmillan signed the Stockholm Convention. The Chancellor, Derek Heathcote Amory, said at the time, we want to be able to share in the prosperity that a great single trading union would bring with it. Now, our joining EFTA would be welcomed by member states, be welcomed by the Icelandic Foreign Minister, welcomed by the Norwegian Prime Minister, and it's been reported that the EFTA Court President has said that EFTA membership would solve the problem of the Irish backstop. And on freedom of movement, we would take back control, because the EEA agreement provides us, Article 112, Article 113, with important safeguards, allowing Britain to unilaterally take appropriate measures in the event of serious economic, societal or environmental difficulties, or on grounds of public policy, security and health in the case of workers. And it's wrong to think that we would be rule takers. My honourable friend for Grantham, he highlighted that Norway and Iceland alone have derogated from 400 EU acts between them. He also highlighted how Norway have declined to implement the Postal Service Directive. So it is wrong to say that we are rule takers. We are. As membership of EFTA, we'd be part of the EFTA Court, which is a guidance court. It's not an authoritative court in the same way that the European Court of Justice is.
That's right.
And the customs arrangement on our side of the House would be temporary. It would be a temporary arrangement until we were able to solve the issue of the frictionless border, and then we would have EFTA membership, full EFTA membership, and be able to do trade deals as other EFTA members have done. Now, the Common Market 2.0 is also a Eurosceptic Brexit. Many Eurosceptics over the past few years have supported the Norway option. Even UKIP did a tweet supporting the Norway option. Dan Hannan supported EFTA in the past. Douglas Carswell supported EFTA in the past. And Margaret Thatcher, my honourable friend, preempted me, Margaret Thatcher herself said in 2003, writing in her book, how supportive she was of EFTA. And let me quote her, Mr. Speaker. These countries now enjoy free trade with the European Union. They also enjoy the unhindered access guaranteed by the operation of the European single market, but they remain outside the customs union, the CAP, the CFP, the common foreign and security policy, and the rest of the legal bureaucratic tangle of EU institutions. And if it's good enough for the right honourable lady, it's good enough for me. So joining EFTA, we do take back control. It's a workers' Brexit because we keep workers' rights and the protections such as annual leave, equal pay and maternity. It's a take-back control Brexit because we're out of the political union of the EU. And we safeguard our jobs and our economy. But above all, it's a uniting Brexit. It keeps us together, Remainers and Leavers, brings us together and keeps us in an alliance of democracies.
Well said. Thank you. Order. After I have heard, and the House has heard from the Honourable Gentleman Member for Sedgefield, I'm afraid it will be necessary to reduce the time limit on backbench speeches to 3 minutes in an attempt to accommodate as many colleagues as possible. Mr. Bill Wilson.
Thank you, Mr. Speaker. I rise in support of Motion M in the name of the Right Honourable Friend for the Member of the Derby South, which calls for a confirmatory vote by the British people on any Brexit deal. I would like to begin by saying why I have come to the conclusion that this should be put back to the people. I completely respect those colleagues who have a different viewpoint to me, but this is a position that I passionately hold with great sincerity, and I know those who disagree with me also hold their views in the same way. But I believe in my heart of hearts that the British people have the right to the final say on this country's future direction. We already have the Prime Minister's withdrawal agreement, but today the possibility of deciding on other options to negotiate with the EU, and perhaps what will become another withdrawal agreement or deal. It is clear from the range of motions tabled, Mr. Speaker, that Brexit takes many forms. But about 3 years since the EU referendum, we now know what Brexit will look like if the Prime Minister's deal gets through. My question is, how does it compare with what was promised in the referendum? Is it what the people voted for back then? The answer to both questions is we'll never know unless we ask them. My experience is the concept of Brexit is just that, a concept, an idea, a viewpoint, a general principle such as leave means leave. And as those who adhere to the concept of leave means leave try to give it depth or any kind of coherence, it falls apart into different schools of thought. For some, there are those who do actually believe leave means leave, so they just want to leave. There are those
who've given it a bit more thought about the concept and belong to the Brexit school that teaches how to leave the EU on World Trade Organisation rules. There is the school that teaches how to do the Norway Plus option. There are schools adhering to the customs union and a closest possible relationship with the single market. There are so many different schools which teach how to do Brexit. To their adherents, they are all legitimate Brexits. They have one thing in common. They want to deliver Brexit, but none of them are Brexit. There is only one Brexit on offer. It's the Brexit deal negotiated by the government with the EU. It now defines Brexit. It is Brexit. However, if after this process today the House agrees on a different option and it is negotiated with the EU, then that becomes Brexit. But the question still remains, how does it compare with the promises made in 2016? The people have the right to decide. Some say that another public vote will be... No, I'm not going to give way. These people are desperate to speak and there's not enough time. Some say that another public vote will be divisive. I believe implementing any deal without a final say by the British people is divisive and will be for years to come as people realise that Brexit does not end on the day we may leave the EU, but only begins on that day.
I'm very grateful for the honourable gentleman for giving way. 7% of my voters in Barnsley voted to leave. They would like their point of view put into action. Could I ask the honourable gentleman, is this amendment really about staying in the European Union and not putting it back to the people?
Basically, as you know, myself and my honourable friend from Hove have been working on a compromise which is basically giving it back to the people to decide whether the Brexit on offer is the way they want to go, because it wasn't there in 2016 and they have the right to compare the Brexit facts with the promises made back then. I believe it will be divisive because they will not have had a say on whether they want, for example, to pay £39 billion to the EU. They won't have been asked if they want to remain in a customs union or accept freedom of movement or be like Norway. They will not have a say on any of the proposals which could come to fruition. It is not a criticism of colleagues in this House who will put forward such proposals today, but how do we know this is what the people voted for or will consent to unless we ask them? It continues to lie heavily with me that on the several occasions I have asked the Prime Minister in this House whether a deal is better than the one we have now. She cannot answer. Maybe the people will disagree with me and agree with the Prime Minister, but I think it's time we find out. If we look at the Brexit facts and compare them favourably, if we look at the Brexit facts and they compare favourably with what was promised almost 3 years ago, so the Brexit deal passes, then fine. Let's say the deal implemented. Under our proposal, the deal will be given passage through this House with the proviso it goes to the people in a confirmatory ballot. If it is agreed to, it is implemented, and that puts the end to any idea of a third referendum or a fourth referendum. In fact, there is a strong argument for the process we are undertaking now should have taken place before the referendum in 2016, with the facts before the people instead of promises that will never materialise. Some say that what we are promising is undemocratic because the people have already had their say. Yes, they have. But what they didn't have was a say on the current Brexit deal, or in fact, any Brexit deal. And they should. When I speak to some and suggest the electorate should be given the final say on what the deal should be, they react as if the only people who will be allowed to vote are those that voted Remain. People should have the right to change their minds. Not just from leave to remain, but from remain to leave. I do not believe MPs in this House today, elected for, in theory, 5-year terms, should have the final say on an issue that will affect our electors and their families and their descendants for years to come. If that is what happens, it does not, in my view, reflect well on what the establishment, however it is appointed or elected, should be doing. Mr. Speaker, the final say should not be given to us in this House exclusively. The final say belongs to the people. Brexit started with the people, it should end with the people.
James Cartledge.
Thank you very much. Thank you very much, Mr. Speaker. I'm very much used to the time changing just as I come on to speak. I campaigned to remain, but I promised to my constituents I would accept the result of the referendum that I voted into law along with my colleagues. And in my view, the best deal to do that, undoubtedly, is that negotiated by the Prime Minister in all the difficult squaring of circles it has had to go through. If we're not going to have that deal, and I sincerely hope we do, then we have to accept, given no deal has been defeated twice in this place, that it must be a deal that flexes one of the red lines, the single market and the customs union. I explained on Monday why I think that the issue of free movement should not be as big a concern, because our immigration numbers will be the same, they'll just come from much further afield. But the key issue is on trade. If you go down the F to EA route, you are outside the customs union, but you keep the EU free trade deal, which is the single market. And we have to ask ourselves, if we were outside the EU but in the customs union, there'd be a profound problem. What would happen when we wanted to do a trade deal with a country that the EU did not wish to or was unable to conclude one with? This is fundamental. Imagine if it were a key economic bloc like China. If we wanted to negotiate a trade deal with the Chinese, we'd have to wait for the EU to conclude its trade deal, which I think will take much longer and be far more complicated. The Swiss, who are a fine EFTA country, who are in the single market but outside the customs union, negotiated as long ago as 2013 an excellent trade deal with the Chinese, which has given them billions of pounds of trade in industrial goods and very strong access in services. And I think this is the key point. There are many good reasons why we as a country could negotiate a trade deal with China that the EU couldn't. And it's because we have a profound offer in services that is very different to the overall EU mix. And I think, personally, we have to say to our people, what are the benefits of leaving? What are the opportunities? And one of them must be to live up to our great history and heritage as the home of capitalism and free trade, and go back to trading around the world, but with a close relationship with the European single market to fall back on. It works brilliantly for Switzerland, it works brilliantly for Norway. And in essence, it means leaving the political union and staying in the economic one. It is a very good deal. It's not as good as the Prime Minister's for all the reasons I've said in previous speeches. But at this moment in time, we have to decide whether we really want to deliver Brexit or not. And if we are going to, and it's not through the deal, which I hope we'll vote on Friday, there must be a compromise. And the best one is that which plays to our strengths, and our strength as a great free trade nation.
Anna Soubry.
Thank you very much, Mr. Speaker. It's a great pleasure to follow the honourable gentleman for South Suffolk. And, Mr. Speaker, what a great debate we've had. I make it very clear I shall be voting for the motions M and L for all the excellent reasons that the proposers of both those motions have made very clear to the House. And, Mr. Speaker, what a good debate we've had. And isn't it been so revealing and so comforting and so good to see and hear how many honourable members, notably on the benches opposite, have changed their minds. And, Mr. Speaker, not only have they changed their minds, they are tonight going to change the way that they voted in the past. Just look, Mr. Speaker, I don't know if you've had the benefit at looking at the great names that have been added to this motion D. I see the honourable member for Grantham and Stamford, the right honourable member for Loughborough, the honourable member for Harlow, Brigg and Goole, East Renfrewshire, Mid-Norfolk, Mid-Sussex, Wantage, Dorset West. I could go on and on. All honourable members who will be supporting Common Market 2, Single Market and the Customs Union, something that many of us over the last 2 years on many occasions have risen and spoken and argued in favour for, who on many occasions have voted for at considerable personal and political cost, but we made the case, and other honourable members, notably sitting opposite, time and time again, argued against it, voted against it. But joy of choice tonight, Mr. Speaker, finally they see the merits of that solution to this great Brexit dilemma, and indeed, as I say, they are going to change their votes. And tonight, Mr. Speaker, we hear there is every chance that the Prime Minister's deal may indeed get through. So this could end up, as we lawyers call it, as an otiose exercise, because we now learn that honourable and right honourable members opposite, who on previous occasions have voted against the Prime Minister's deal, not once, Mr. Speaker, but twice, are now going to do, guess what? Not only are they changing their minds, they too will have and enjoy the privilege of changing their vote to support the Prime Minister. What a profound irony. And some would say a disgrace, verging on hypocrisy. Honourable and right honourable members expect and will enjoy the right to change their minds and vote, but not allow the people of this country the same right. That is why I shall be supporting the motion that stands to allow whatever we agree and whatever we decide on to go back to the British people. They are entitled also to change their mind, to change their vote, especially when they see that whatever way you cut it, Brexit will make our country worse off. And I finally say that if it turns out to be the majority don't want Brexit, it won't be on my conscience.
Bill. Thank you, Mr. Speaker. It's a pleasure to follow the Right Honourable Member for Broxtowe, although I was disappointed that in her speech she didn't mention how many times she thought the electorate could change their mind. Does she therefore think there should be 2 or 3, or for this time is short, or 4?
The honourable gentleman this. We have a referendum with whatever deal we settle on it. Remain as the option. If people vote for the Prime Minister's deal or whatever, that's it. End of. And if they vote Remain, end of. That's it. We stay in the EU.
Not the case she made. She made the case that people should be able to change their mind repeatedly, and that would imply she would support any number of referenda. But I rise this evening, Mr. Speaker, to speak, in fact, against motions D in the name of the Honourable Member for Grantham on Common Market 2.0 and a similar motion H in the name of the Member for Cambourne and Redruth on membership of the European Economic Area. Mr. Speaker, there are 2 or 3 reasons why I strongly oppose those motions. Firstly, both of them entail signing up to full single market rules. The House of Commons Library published a paper only yesterday which on page 19 said EEA membership involves a range of obligations, including implementation of European Union rules on the single market, with no decision-making role other than being consulted. And I think for a great British institution like the City of London, or indeed our entire industrial economy, merely being consulted over the rules that govern them simply is not good enough. Secondly, Mr. Speaker, there comes the question of financial contributions, which provided a controversial part of the referendum campaign. And another House of Commons paper published on the 21st of December found that Norway pays per capita contributions that are around about half the level we currently do. So one would assume about £5 billion per year. So that promise made to the British people about saving money would not be delivered in either Common Market 2.0 or as members of the European Economic Area. And then we come to the question of free movement, because membership of the single market entails free movement, full free movement, another issue that was contentious during the recent referendum campaign. Now, some members have made reference to various breaks or safeguards which are present in the European Economic Area agreement. Specifically, Article 112 says that any such safeguards must be restricted in their scope and duration. And Article 114 goes on to say that if a state, like the UK, were to use those safeguards, then other member states could take rebalancing measures against them, meaning that some of the benefits of single market membership could be withdrawn. And no country other than Liechtenstein, in very limited circumstances, has ever taken advantage of those provisions. Well, Switzerland is currently engaged in a running battle with the European Union. It's been unable to implement the provisions of its own 2014 referendum on free movement, I say in response to my honourable friend from South Suffolk, who made a comment from a sedentary position. And, Mr. Speaker, in the 54 seconds remaining, let me briefly turn to the question of trade deals, which affects only motion D and not motion H. Under the proposal being made by my right honourable friend from Grantham, during the period of customs union membership, and this would apply probably to the Labour Party's official proposal as well, we would be bound by all of the trade agreements done by the European Union. We would be compelled to follow them without the right of veto we currently enjoy, and we would be prevented from doing any free trade deals of our own, which would be greatly to our disadvantage. It would exclude countries like India, China and the USA. So for those reasons, Mr. Speaker, I will be opposing motions D and H in the forthcoming division.
Owl.
Thank you very much, Mr. Speaker. As others have said, this debate should have happened a long, long time ago. And unfortunately, in the meantime, positions have become more entrenched and the country has become more divided. But I really hope that today that healing process can begin. And I just want to say at the outset that each one of us has thought very deeply for a long time. These are difficult issues and they are balanced judgments, and we've all come at them from a very good place, at a place of good intent, and we should respect where each other has arrived at, even though some of us have arrived at different places. And I think what we also have to remember is that nothing about this debate is perfect. There is no easy solution here. There is no panacea. Every single thing before us has upsides and has downsides, and I'm not going to pretend any differently about what I want to support this evening. So we need some honesty in the debate, and we need some balance too, because the only thing that there is an absolute about is that compromise is absolutely necessary, and we must have that in everything we do. My other criteria about looking at the things before us today is what is actually doable and what is achievable, because I think for too long in this debate we've been chasing unicorns around that unicorn forest. And so, although I have arrived at a view that on that balance of upsides and downsides, Common Market 2.0 for me offers that balance that I can live with, I will be voting for other things this evening, because I think today is about keeping as many options on the table, or in the forest, or whatever metaphor you want, as possible, and not narrowing those down. So just in brief, the upsides of Common Market 2.0 for me are that they are about leaving the EU. It's the economically the best possible option and way of doing that. The single market is the key element here, not the customs union, the key element, and we can do it quickly as well. But of course there are downsides, issues still around freedom of movement and whether we are a rule taker. But as ever with this debate, there are shades of grey. It's not all just black and white. I just want to finish. I'll very quickly give way.
Can I thank my honourable friend for giving way, and I just want to place on record my thanks to her and the honourable member for Aberavon, who, while many in this place have retrenched to process issues, talking about procedures in this House, the two of them have actually taken the bull by the horns and looked at issues that can resolve this situation practically. And while I have some concerns about what she is proposing, she at least has proposed something that is substantive, and I thank her for that.
Thank you very much for that. And I think, as my mum always says, those who do now wrong, do they? So you always get criticised for having a position rather than not. But, as I say, I respect many people across this House who have worked in cross-party teams to try and do that. So just finally, on the issue of the second referendum, for me this is a separate question. We have to find something that we can put to the public if that's what this House decides. We still need to determine what the best Brexit looks like that we would, if the House wanted to, put that back to the people. We can't have Remain versus Remain on the ballot paper, as I know some would want, and I don't think we can have Remain versus Leave that is undefined. So regardless of what people's views are about a second referendum, I would just implore all sides of the House, we do need to agree what Brexit might look like in the eventuality even of a second referendum. Thank you.
Thank you. Giles Watling.
Thank you, Mr. Speaker. Brevity. I sincerely hope that we'll have some clarity at the end of this process and move us closer to the Brexit that I was sent here from Clacton to deliver. From my travels across my constituency, I know that the vast majority of my constituents just want this whole agonising process brought to a conclusion with a Brexit. Yet, because of the constraints applied by this House, the deal on the table is the best way to deliver that Brexit, despite my serious concerns about the backstop and the continuing legal jurisdiction of the ECJ. I now feel we have to vote for it and head off the possibility of no Brexit at all. The political scenery has changed dramatically, and this House has become more assertive by taking no deal off the table. And there is also the emerging threat of an extremely soft or painfully slow Brexit. Moreover, and this is becoming apparent now as the House begins to assert itself, the Brexit deal that we have now on offer is as good as it's ever going to be. There is no, and never will be, a perfect deal. There is only a pragmatic outcome. And by failing to move beyond this point at all, by failing to compromise and start on the road to Brexit, we are failing to satisfy anyone who voted to leave. We're also failing to satisfy those who voted to remain, and that includes me. But my position fell at the result of the referendum. Now, in the light of the instruction that I got from the people in Clacton to deliver Brexit, I would ask my colleagues if they want to be the ones that make Brexit worse, or even lose it entirely, when they could be the ones to deliver a good form of Brexit after all this pain and division, a Brexit that delivers on the promises. No doubt some will remain stubborn and push hopelessly for an unattainable no deal, but they fail to recognise, no matter how much they may wish it, there is not a majority for no deal in this House, and there hasn't been since the 2017 election. And if colleagues reject that point and doggedly reiterate the Prime Minister's line that no deal is better than a bad deal, that doesn't change the fact that no deal is now flogging a dead horse. So a deal is all we can possibly have. And yes, no deal is still the legal default, but we find ourselves in the really weird position. I'll give way.
An extension. I'm very grateful. Does he share my concern about M and the second referendum? And what would he do with my constituency, which has voted 60-40 out? Does he understand their concern that a second referendum would be the end of democracy?
I thank my honourable friend for his intervention, and I agree with him totally. I think a second referendum would be even more divisive than the position we already find ourselves in. And we do find ourselves in the weird position, although no deal is a legal default, it's no longer possible. Events have, therefore, overtaken dogma and stubbornness, and that's why I will support the deal in future votes in a spirit of pragmatism and because of my desire to deliver Brexit for my constituents. And I will vote to support no deal today, again, for my constituents. But to those colleagues who are still voting for no deal in the vain hope of reaching that outcome, I would say the following. This House will not allow it. It's time to get serious about the deal in its current form, because all the other options are far worse than the ones we have on offer now. Therefore, in these votes, and I won't go through them all, I'm looking for pragmatic and realistic options, and I want to get this deal over the line, finally, for the good of this country in the future. Thank you.
It is a pleasure to follow the honourable gentleman for Clacton. He will not be surprised that I profoundly disagree with his viewpoint. But I think it is good that finally the House has had the chance to debate the full range of options before our country. I will vote with most enthusiasm tonight for the amendment tabled by my right honourable friend for Derby South. I voted to respect the outcome of the referendum in 2016 and trigger Article 50. But what has become clear over the last 2.5 years is so much more about the detail of what the real impact of Brexit would mean for our constituents, and also just how many of the promises by those who campaigned for vote leave have been demonstrably seen not to be true. I was proud to be one of the 1 million who marched in London on Saturday. And I do think it shouldn't be only the 650 of us here in the UK that get to have the final say on which Brexit option is decided. Given that Brexit has such huge implications for our country, it is surely only right that once a Brexit deal has been finalised, that people should have the final say. I will vote to strengthen the protection against a no-deal Brexit for our country. The Amendment L proposed by the honourable lady for the honourable member from the Scottish Nationalist Party. But I do think we have, as a House of Commons, to try to help the Prime Minister and the government to move on from the deal that she has been peddling so unsuccessfully for so long. And for me, the dilemma before this House is essentially how close or how distant a relationship do we want to have with the European Union. Every independent economist suggests that the more distant our relationship with the European in the future, the greater the adverse economic impact will be. So for me, that means that we should opt for the softest Brexit possible, staying in the customs union and staying in the single market. And given that the vast majority of jobs, both for my constituents and others, depend on the services sector, every independent economist that I have seen suggests there will be a huge impact for our country if we leave the single market in terms of the loss of services business. And for that reason alone, I think we should be staying in the single market. Trade remains the last great unicorn yet to be fully taken down. I do not believe there will be better trade deals on offer after Brexit. I think we have got good trade deals as a result of membership of the European Union, and I look forward to supporting Amendment M.
Thank you very much, Mr. Speaker. What we're doing this evening is what we should have done a long, long time ago at the outset of this process. Something of the magnitude of Brexit has never been attempted anywhere else in the world before. We should have put down the foundations before laying the bricks. That said, my favourite course is to support the withdrawal agreement the government has negotiated, and if there is another vote on it, I shall support it again. It delivers Brexit in an orderly, non-disruptive way, and it provides the framework for revitalising the Lowestoft and East Anglian fishing industry. In considering the various alternatives that have been put forward, I am mindful of the need to respect the 2016 referendum, and I shall therefore not be voting for a second referendum or a revocation of Article 50. I have listened to impassioned and persuasive arguments of why we should do so, but I do sense that if we go down this road, we will leave a lot of people all around the country very puzzled, very bewildered, and I'm afraid angry. As a second option to the withdrawal agreement, I believe that we should consider motion H put forward by my honourable friend, the member for Camborne and Redruth, where this involves the UK remaining a member of the European Economic Area and returning to the European Free Trade Association, which we invented in 1959 and which involves no customs union and no backstop. This delivers on the referendum result, as the European Communities Act of 1972 would be repealed on time, without an extension, and we would legally leave the EU. It also has the advantage, from my perspective, that we would leave the common fisheries policy sooner than and would be able to implement the emerging policy that is emerging. With regard to leaving without a deal, Mr. Speaker, I have in the last week canvassed local businesses, trade associations and representatives on their cut positions. These include businesses from the haulage, oil and gas, packaging, leisure, farming and food processing sectors, as well as health providers and utility companies. All are concerned about the impact on their businesses of leaving the EU on WTO terms, and by implication, the potential negative knock-on impact both to those who work for them and those to whom they provide goods and services. Mr. Speaker, in conclusion, the current logjam has been going on for far, far too long. From my perspective, we need to remove the uncertainty as quickly as possible and get on with delivering Brexit in an orderly way.
Daniel Zeichner.
Thank you, Mr. Speaker. It's a pleasure to follow the member for Lowestoft, my good friend. It's extraordinary, isn't it? We are here today, and I, like others, would welcome the constructive tone that many have struck in this debate today. But it's March the 27th. We've known for so long that the end date was March the 29th. To start this kind of debate, which should have started so much earlier today, is, I'm afraid, a mark of failure for the whole process. I'm not one of those who can say that I've changed my mind through this process. I represent one of the most Remain constituencies in the country. I'm a passionate Remainer myself. And I found that difficult at times because I recognise that for many of my colleagues it's a much more difficult position to be in. But I just caution colleagues slightly about the policy discussion that we're having today. Because while we may well be able to move to what looks like a rational compromise, I've wondered throughout whether that's really where many members of the public are. And if I need any proof of that, I have to say that when I floated the idea some 6 months ago in this chamber of revocation, I think it felt like a bit of an outlier position, quite frankly. But if I needed any confirmation of that, it's the extraordinary strength of the petition that's been running in the last few weeks. I'm a member of the Petitions Committee, and I would say I thought it's unfortunate that aspersions were suggested on the veracity of the petition earlier today. The staff worked very hard. Frankly, if there were Russian bots crawling all over parts of one of the campaigns in the referendum campaign, I think we can send a strong message. Russian bots are not going to be running over the parliamentary petitions website because we're very, very careful. So whatever one feels about it, the strength of feeling. In my constituency, 27,000 people, 27,000, almost a third of the electorate have taken the trouble to make that point. So I would say for them, remain means remain, frankly, and I fear that some of the compromise positions will not satisfy people elsewhere. So that leaves me to conclude, having looked at some of the intermediate options, and I can see the merits of them from a policy perspective, we have people who feel passionately about this issue on both sides. How do you resolve that problem in a democracy? I think there is only one answer, quite frankly, and I thought the most powerful contribution this afternoon came from my right honourable friend, the member for Derby South, to make that plea, to reconcile our differences by doing it in the way that we do best in this country, which is to have a sensible discussion where people actually know the facts now. And goodness, we all know much more about all this than we did 2 or 3 years ago. I don't think we're afraid of asking the people if they want a final say. Give it to them and they'll tell us what they think.
Dr. Paul Williams.
Mr. Speaker, every one of us in this place has a firm duty to our constituents. We have a duty to protect their security and their livelihoods. We also have a duty to make the best decisions for our country, and we have a duty to approach this whole process in good faith and with an open mind. This is a House deeply divided, but, and it's important to say this, no matter our view, we're acting, all of us, in a way that we believe best serves our constituents and our country. When I look at the options before the House this evening, Mr. Speaker, it's obvious that there are no perfect solutions. Everything we do from now on will involve compromise. The public, like this House, is deeply divided. But in a democracy, Mr. Speaker, where there's division, where there are trade-offs to be made, we don't shut down the conversation. That's never been what our country does. The healthiest way to repair any kind of relationship where both sides have to stay together is to carry on talking. And there's nothing threatening to democracy about testing the public's opinion. A healthy and vibrant democracy is supposed to be loud. It's supposed to discuss, to debate, and yes, to vote. The only threat to democracy is if we allow fear and intimidation to stop this debate. This must never happen. Mr. Speaker, no member of this House should be scared of doing the right thing today. That's the job we were all elected to do. I sometimes get messages calling me a traitor, a backstabber, an enemy of the people, and colleagues across the House receive much more vitriol than me. I know there's frustration out there, but our job as MPs is to look at the evidence, to make a rational, balanced, objective assessment. My assessment is that Brexit is far more complicated than anyone expected, and we now have a duty to bring the public back into our discussions as we reach this vital, difficult stage in the process. They're entitled in a healthy democracy to give their informed consent to any deal agreed by Parliament. This is a moment where the House must rise to meet the challenge in front of us, the task of uniting our divided country. So far, we've not managed that, and this evening we have the opportunity to do our country proud, to do what we know is right, and to give the public the chance to help us fix this. And that's why I'll be supporting the Amendment M in the name of the member for Derby South.
Cadbury.
Well, it's a pleasure to follow my honourable friend from Stockton South. I campaigned to remain not because I thought the EU was perfect, but I inherently believe that it's better in a world dominated by a few large blocs now in the 21st century to be a member of the club of our nearest neighbours, the largest and therefore the most powerful trading bloc in the world. And through our membership, we're influencing from within, sharing the costs, trading in goods and services without friction, keeping peace on our continent, and having the clout to negotiate. I'm old enough to remember, even though I was too young to vote, what being British was like before the UK joined the common market. Visas to go on holiday across the Channel and currency restrictions. British construction workers having to travel for work in Germany to support the German construction boom. Right now, as of this week, we get full access to EU markets, supporting world-class manufacturing jobs in Britain, and we get the right to travel, work, live and love in 27 other EU countries, a right that we and millions of people, particularly those under 18 in 2016, will lose. We're already seeing the impact of a whole range of businesses such in my constituency, including the growing creative sector, being impacted on uncertainty and Brexit. And as night follows day, so before too long we'll see cuts in tax revenues, leading to yet more cuts to public services, whichever party is in government. The referendum was advisory, a simple yes or no, with little information and many lies. I voted against triggering Article 50 because I felt we should have sorted the nature of leaving the EU before triggering the two-year clock, and not, as we're doing this week and next, scrabbling around to avoid crashing out. And let's not forget the economic and reputational consequences of triggering Article 50 has had on this country. Now, many people challenge me on that manifesto phrase, respecting the results of the referendum. Well, I do respect the reasons why most people who voted leave did so, because of the lies that the authors of which distanced themselves from immediately afterwards. Mr. Speaker, I will be voting for motion M in the name of the member for Derby South, the right honourable friend from Derby South, for the simple reason that any deal passed by this House, be it the Labour position, Norway, a customs union, or the PM's deal, needs to be fully and publicly ratified by the people. Not another advisory vote, as was the case in 2016, but this time a binding vote. And as my honourable friend from Sedgefield said, people should have the chance to change their mind from leave to remain, or indeed from remain to leave. And Mr. Speaker, although my constituency did vote to remain, I would probably have the same position even if my constituency was a leave voter area, because of my duty to my country.
Vera Hobhouse.
In 2016, 17.4 million people voted to leave the EU. Today, after almost 3 years, we still have at least 6 different Brexit versions in front of us. None of them were on the ballot paper for the people to vote for in 2016. Each defender of their Brexit option makes some claim it represents the will of the people. This is why we need to test the will of the people in 2019, to test the will to give the people a specific Brexit option versus the option to stay in the EU. I am personally pretty agnostic to what is a better or worse Brexit option. All I want to see as an outcome of today's exercise is that whatever Brexit option we decide on here is put back to the people. The people might reconfirm their wish to leave the EU. But in 2019, everybody who wants to leave the EU will know exactly what they are voting for, rather than a long wish list of hopes, aspirations and undeliverable promises. Yes, referenda are difficult, but they are democratic. And we should not be threatened by those who tell us they will riot in the streets if there is another referendum. On Saturday, between 1 and 2 million people marched peacefully in the streets of London, young and old, from all backgrounds, different political parties and none. Do they not count? Are they not the real British people, determined but polite? Does Parliament only listen to people when they throw stones or send us death threats? Put it to the people was a peaceful ask from the biggest march so far this century. Let us hold the 2019 people's vote. Whatever Brexit solution finds a consensus in this Parliament must go back to the people. The people must finish what the people have started. Thank you.
Thank you.
Order. Well, I was looking for a particular member who beetled out of the chamber at an inopportune moment. If he'd been in the chamber at an opportune moment, I might have invited him to address the House. But I think he's missed his opportunity. Order. Order. In accordance with the order of the House of today, we will shortly proceed, colleagues, to vote on the motions which I have selected. Voting forms are available from the Vote Office and in the division lobbies. The forms list the title and letter of the selected motions. The text of the motions is on the order paper. Members with surnames from A to K should hand their forms in, as I indicated at the outset, in the I lobby at the relevant desk for their surname, and members with surnames from L to Z should hand in their forms in the No lobby at the relevant desk. The division bells will be rung 2 minutes before the House resumes. I declare the voting period open, that voting period of 30 minutes from 7 o'clock, and I suspend the House accordingly for that period. Order. Order. Order! Order. The voting period has now finished. Lock the doors! Thank you. Order. I must now call the Minister to move motion number 4 on exiting the European Union. Minister Robin Walker.
Not moved, Mr. Speaker. I beg to move that the draft European Union Withdrawal Act 2018 Exit Day Amendment Regulations 2019, which were laid before this House on the 25th of March, be approved. First, may I express my gratitude to the Joint Committee for Statutory Instruments on their report today. I do, of course, regret the necessity of having to bring forward this instrument and would prefer that we were leaving the EU with a deal at the end of this week. I have voted on 2 occasions for that outcome, but I know that the House has not. The Chancellor of the Duchy of Lancaster made clear in the debate on the 14th of March that the Government would accept the will of the House and seek an extension if that is what Parliament voted for. Parliament then voted by 412 to 202 to approve a motion to seek to extend Article 50. An extension has therefore been agreed with the EU, and the Government is now committed to implementing it in domestic law. As the House... I will give way.
Well, my honourable friend, allow me. Well, really? The operative paragraph of the explanatory notes that accompany the SI say the following. That if the House of Commons approves the withdrawal agreement by 11 p.m. on the 29th of March 2019, the so-called relevant time, if it does it by then, right, then if the House does not give such approval by the relevant time, the treaties will instead cease to apply at the earlier date of 11 p.m. on the 12th of April 2019.
Great. Very good.
So, thank you, that's very kind. I'll do my best, Ed. Thanks, mate.
You're doing well.
Great. I'll carry on then. So, the Government were meant to lay a commencement order in order to allow us to leave, which they, as I understand, they never laid. I don't think they were ever going to. But does this SI now have the effect that the commencement order would have had? So, in other words, if we approve the SI and we have not approved the meaningful vote, would we then leave at 11 p.m. on the 11th of April without the need for a separate commencement order? I think the Minister understands the question.
I do think I understand my honourable friend's question. I think the answer is that a commencement order would have to be laid before the point at which we left, whatever that leaving date was. And so I don't think it is necessarily directly relevant to the debate on this SI, because this SI does not set the date at which we leave the European Union. This SI reflects the date that is agreed in international law. And as the House will be aware, I will come back in a moment, if I can just make a little progress. As the House will be aware, the decision adopted by the European Council, agreed to by the UK, provides for 2 possible durations, as my honourable friend has just pointed out. Should the House approve the negotiated withdrawal agreement this week, the extension would last until the 22nd of May. If the House did not approve the withdrawal agreement, the extension will last until the 12th of April. I said I'd give way to my honourable friend.
What would be the effect if this House rejected the SI tonight? Because we're told constantly that international law always trumps domestic law. So what would be the effect? And in fact, is there any point in either voting for this motion or against this motion? Because it really has no effect at all. International law will always trump what we do, and parliamentary democracy in that sense is inferior to international law. Is that correct?
Minister.
My honourable friend makes an important point, but I think there is a profound effect in rejecting this SI, which I will come to later in my speech, because I think it is important that if we were to reject this SI, it would leave the UK statute book in a mess. I don't think that is, therefore, a good course of action. I'm happy to give way to the honourable gentleman once.
I thank the Minister for giving way. He said a moment ago if the House were to pass the withdrawal agreement by this week. We've obviously heard Mr Speaker's ruling earlier on, and there are rumours abounding that the Government intend to introduce the withdrawal and implementation bill on Friday. Could the Minister confirm whether that is correct, and whether it would have any provisions to alter Section 13 of the EU Withdrawal Act, of course intimately tied up with this SI?
Minister.
It would be a matter for the leader of the House to announce business and not for me. I mean, what I will say is I heard, and I'm sure the whole government heard, the Speaker's ruling. We take careful note of what the Speaker says, and of course we will act with due respect to that. But I do hope that this House has the opportunity to consider the only withdrawal agreement that has been negotiated and agreed to by the EU. Now, these regulations cater for an extension in either scenario. I will make a bit of progress by redefining exit day to ensure the date and time specified in that definition is 11 p.m. on the 22nd of May or 11 p.m. on the 12th of April, depending on whether the House approves the withdrawal agreement. In either of these two extension scenarios, we will not be required to participate in European parliamentary elections. This is a vitally important instrument with simple but crucial purpose. It will make sure our domestic statute book reflects the extension of Article 50 that was agreed with the EU on Friday the 22nd of March. Wait to my right, honourable friend.
To the Minister. Could you just explain to the House why it was that I think the UK government wanted the 30th of June, but it was scaled back to the 12th of April? Could you just explain why the EU thought it was much better to have a short period, which I, as someone who doesn't want a period at all, obviously find myself on their side rather than the government?
Minister! The honourable friend may well welcome the chance of that shorter period, but I think the answer is that was the decision reached by the Council and agreed by the Council and the UK. Put simply, the instrument doesn't set the date of our departure. Let me finish this point and I will give way. Put simply, the instrument doesn't set the date of our departure, which has already been agreed. It reflects that in domestic law. While the instrument itself is straightforward, its effect will apply across the domestic statute book, so it is important that I set out the details of what it will do, and this comes to my right honourable friend's points. I've explained this to my ministerial counterparts in the Scottish Government and the Welsh Assembly, setting out why the UK Government is taking forward this instrument, but perhaps before I come to that, I can take my honourable friend.
I'm grateful to my honourable friend for giving way. Can I just refer to the question of my right honourable friend a moment ago, because he didn't ask our honourable friend to restate the position. He asked why the European Council went for the earlier date rather than the 30th of June. Why did it do that?
Well, my understanding is that that was their view of when we would have to give notice that we would be holding European elections if we were staying in for longer, and that is why they set that date as the date by which we would have to have made our mind up as to whether we're leaving. But that is for them to determine. I am not a spokesman for the European Council. Currently, major changes to our major domestic statute book reflecting our exit from the European Union are due to take effect on exit day, which is defined in the EU Withdrawal Act 2018 as 11 p.m. on 29th of March. Despite the extension terms that have been agreed at international level, these changes apply across a huge number of policy areas, from emissions trading to Europol, and all of these changes are designed to ensure that our statute book works when we leave the European Union. All of these changes are due to take place on exit day, and this definition has effect across the whole UK statute book. Now that an extension to Article 50 has been agreed in EU and international law, we need to amend this date to reflect the new point at which the EU treaties cease to apply. Give way to the Honourable Lady.
I thank the Minister for giving way. And has he learned any lessons about putting exact times and dates on the statute book in primary legislation, just so that his Prime Minister can blackmail her own party?
Minister!
I think the Honourable Lady makes a political point which is not particularly appropriate for a debate on technical legislation. But this instrument has been laid under the EU Withdrawal Act to do just what I said. Section 20, subsection 4 of the Act contains a power to amend exit day through a statutory instrument. Give way to my honourable friend.
I'm grateful to my honourable friend for giving way. He mentioned that the European Council had agreed an extension. There was, of course, a resolution of this House to seek to agree an extension, which I would suggest amounts to an authority to negotiate. Has he been advised that amounted also to an authority to conclude an extension, and did he get legal advice on that point?
Well, Minister. My right honourable friend, who I know is a keen legal eagle as well as an experienced minister in this department, but of course the government is confident of its legal position in the decisions that it has taken. The power was specifically included in the EU Withdrawal Act because parliamentarians envisaged a situation in which extension could be required. As the then Parliamentary Under-Secretary said in the debate, this government has had discussions with backbenchers and we are grateful that they tabled their amendments. They provide the government with the technical ability to amend the date, but only if the UK and the EU unanimously decide to change the date that the treaties cease to apply, as set out in Article 50. Give way to my...
I'd like to ask the Minister, with respect to the meeting this afternoon of the Joint Committee on Statutory Instruments, could he report to the House what the outcome of that was, and whether in fact they consider the question of varies, as is within their standing orders? Could you please give me an answer to that?
Minister. I didn't catch the whole of my right honourable and learned friend's question, but I am confident that the Joint Committee of Statutory Instruments has had a chance to look at this, and as I said, I welcomed at the beginning of my remarks their report. I want to be clear with the House that the power in the EU Withdrawal Act can only be used to redefine exit day to the new day and times that the treaties will cease to apply in the UK. To specify any other day would not be a legal use of that power. It is absolutely, in one moment I will, it is absolutely critical that the House approves this instrument for the simple reason that the extension of Article 50 has been agreed and is therefore legally binding in international law. I understand that there have been some members who are of the view that we are still set to leave the EU on the 29th of March, but that is not legally the case. Owing to the agreement between the UK and the EU to extend Article 50, the UK will remain a member state of the EU until at least 11 p.m. on the 12th of April as a matter of international law. If this instrument were not to pass, therefore, it wouldn't change that fact, but it would lead to confusion across our statute book from the 29th of March. I give way to my honourable friend.
Thank you, Mr. Speaker. On that very point, I've got this wonderful machine that says we're now 2 days, 4 hours, 17 minutes and 12 seconds away. I actually believe from coming out of the EU. This is a pretty good machine, actually. The truth of the matter, Minister, is it not that if we reject this SI tonight, and I hope we do by a big margin, we will have come out in domestic law and we'll be in breach of an international treaty for about 2 weeks. Isn't that the truth? And that's why you need to get this SI through.
Minister. I simply do not share my honourable friend's understanding or view of the matter. I respect his point of view, but I'm afraid I think in terms of the legal facts he is not right. A large volume of EU exit legislation preparing the statute book for the moment EU law ceases to apply is due to enter into force automatically on exit day. Without this instrument being in place, there would be a clash in our domestic law whereby contradictory provisions would apply, both EU rules and the new UK rules simultaneously, and in some cases, new UK rules would replace EU rules prematurely. We estimate that tens of thousands of amendments to our domestic legislation will be made in the light of EU exit. These include changes which relate to the sharing of information, reporting requirements placed on businesses and public institutions, and the role of the European Commission in issuing licences and certificates. For example, let us take the amendments relating to the rights of lawyers to practice in the UK. If these regulations come into force on 29th of March, EU lawyers who are not registered European lawyers immediately before exit day are at risk of committing a criminal offence if they continue to provide particular legal services in the UK. Other examples include UK operators being unable to comply with EU emissions trading scheme and having to surrender their emissions allowances early, and the risk that firms stop trading to avoid legal breaches given their uncertainty about when new customs, excise and VAT regimes would kick in. There are examples from across the statute book, but what is clear is that without this instrument there would be significant confusion and uncertainty for businesses and individuals on the 29th of March. As I have said, happy to give way to my honourable friend.
I'm very grateful. He is making the strongest possible case that the importance of this statutory instrument is to make sure that our reputation across the world for being a country that is reliable to deal with and whose obligations in international law are the same as our domestic legislation remain intact.
My honourable friend, right, he and I have always agreed we need to do this process properly, and that is what this SI is all about. Happy to give way to the honourable lady.
Thank you. Very grateful indeed. Thank you, Mr. Speaker. I'm very grateful indeed to the Minister. Isn't the reality of the situation such that while we affectionately refer to the withdrawal deal as the Prime Minister's Brexit deal, as the Prime Minister deal. The reality is, it has been signed by 27 other EU member states. It is signed, it is not going to be unsigned. The deal is done. There is only one deal, and that is the Prime Minister's deal. An extension that we need tonight is simply to give us a very short extension, but we absolutely have to get behind this Brexit deal, get it through, get the implementation period, and move on. It's not going to be reopened by the other 27.
As I often find, I wholeheartedly agree with the Honourable Lady. It isn't the sole point of this SI, of course, because this SI allows for two specific scenarios. Happy to give way.
Grateful. Can my honourable friend explain why his junior minister and the member for Spelthorne told this House on Friday at column 1377 that the Article 50 period will only be extended if the House votes for a statutory instrument to give effect to such an extension? And he confirmed that the government would have to lay a statutory instrument and the House would have to debate and vote on it. It now seems as though that was totally inaccurate.
Well, I didn't see what my honourable friend said in that debate, but I am very grateful to the honourable gentleman for promoting me so that I have junior ministers underneath me. The question before us today is not a matter of whether the extension of Article 50 happens. The issue before us today is a separate question. Does the domestic statute book reflect this extension, without which there could be a confusing and unclear statute book with clashing provisions? If we are to resolve that clash, it is essential that the instrument being debated today is made before 11 p.m. on the 29th of March, so that it can come into force ahead of that time. This will align exit day in UK law, I will in one moment, with the new day and time on which the EU treaties cease to apply to the United Kingdom in both EU and international law. Very happy to give way to my right honourable friend.
I'm grateful to my honourable friend. Can I just put it to him that it is exactly the way that this executive decision was approved by a minister without proper reference to Parliament, bringing back to this House not just international law, but law that is binding in our own law and binding on this Parliament. This is exactly this kind of decision-making and law-making that people voted against in the referendum.
Absolutely. I'd say to my right honourable friend, I think he makes an important point, actually, and I think it's a point on which many of us could agree that this process reflects some of the issues that caused people to vote the way that they did. But I would also say to him that this House did vote for an extension, and it was in respecting the vote of this House that the government sought to negotiate one. But I am acutely aware of the huge amount of work undertaken by members across this House to scrutinise...
point of order, Sir Christopher Chope.
Mr. Speaker, the Minister made light of my intervention, in which I drew express attention of the House to what had been told to this House on Friday during the course of an urgent question by a Minister of the Crown from my honourable friend's department. If what was said then is wrong, then when are we going to get an official correction and apology from the government? Because certainly those of us who were in the House on Friday were gravely misled by what was said.
Well, I'm very grateful to the honourable gentleman for his point of order. Obviously, I well remember the exchanges, and I'm aware of the particular interaction to which the honourable gentleman is referring. The normal principle applies. Every member is responsible for the veracity of what he or she says in this chamber. If a member inadvertently errs, it is incumbent upon that member to correct the record. The Minister perfectly reasonably said that he hadn't seen what was said, but I mean, it's not beyond the wit and sagacity of the honourable member for Christchurch to arrange for a copy of the extract from the official report to wing its way to the dispatch box during the course of this consideration, and the Minister might then be in a particular further to respond to the honourable gentleman. Minister. Do beg the Minister's pardon. Point of order, Angela Eagle.
Thank you, Mr. Speaker. Could you advise me whether what members opposite are actually objecting to is the use of the royal prerogative and the logic which allows us to sign up to international treaties using that power? And the logic of what they're actually arguing is that we should get rid of the Queen.
I simply say to the right honourable lady, it's not for me to offer an exegesis. It's not for me to offer an exegesis of what individuals might think about our constitutional arrangements, including the use or otherwise of the royal prerogative. But the Right Honourable Lady has made her own force in her own way, with some panache, and it will be studied on the record. Oh, very well. Point of order, Mr. Mark Francois.
Very quickly, Mr. Speaker, there are some people in this House who do want to get rid of Her Majesty, but they're not on this side, they're on theirs.
Yes, can we... I'm extraordinarily grateful, I'm sure, to the Right Honourable Gentleman, but I wonder if we now might return to the relatively narrow ambit of the statutory instrument. Minister Robin Walker.
Speaker, I shall be brief. I am acutely aware of the huge amount of work undertaken by members across this House to scrutinise the near 550 statutory instruments brought forward to prepare for exit and provide legal certainty. If this instrument were not to pass, that work would be undermined by the legal uncertainty created. If, on the other hand, we pass today's instrument, then the only thing that would change across all of those SIs is the moment at which they come into force, aligning with the time of our exit so that they work properly. I remain hopeful that this House will support the Prime Minister's deal and that we will leave the EU on the 22nd of May with a short technical extension to ensure we can pass the necessary implementing legislation. This instrument is, however, without prejudice to whether that is the case. I hope this House can therefore agree on the necessity of this instrument and approve it so that it can come into force and avoid serious confusion and uncertainty for businesses and individuals. Mr. Speaker, I beg to move.
Order. The question is motion number 4 as on the order paper. Mr. Matthew Pennycook.
Thank you, Mr. Speaker. I rise on behalf of the opposition to support the motion. As the Minister has made clear, the statutory instrument before us is a necessary one and it should be entirely uncontroversial. As the House knows, in response to the Prime Minister's letter of the 20th of March to the President of the European Council, the Council agreed to an extension of the Article 50 process until the 22nd of May, provided the withdrawal agreement is approved by the House this week. The Council further agreed that if the withdrawal agreement is not approved this week, an extension until the 12th of April would take place to allow for the UK to, and I quote, indicate a way forward for their consideration, something that we hope the preceding debate and votes will contribute to. On the 22nd of March, the UK's permanent representative to the EU, Sir Tim Barrow, wrote to the President of the Council to confirm agreement of the proposed extension arrangement under Article 50, subsection 3 of the Treaty on European Union. As such, Mr. Speaker, the extension of the Article 50 process till at least 12th of April will now happen as a matter of international law, and as the Minister said, it is legally binding in international law. This statutory instrument merely aligns exit day, as it is defined for the purposes of the EU Withdrawal Act, to the new dates that have been agreed. And it is entirely correct that it comes after agreement on extension was reached between the two parties. Indeed, the EU Withdrawal Act itself makes clear that this sequencing, that is to say that any new agreement between the parties as to when the treaties cease to apply to the UK, must precede any change to exit day for the purposes of the Act. And that is what is precisely required by the legislation. That is because Section 20, subsection 4 of the Act, provides that a Minister of the Crown may, by regulations, amend the definition of exit day to, and I quote, ensure that the day and time specified in the definition are the day and time that the treaties are to cease to apply to the United Kingdom. The operative word, Mr. Speaker, being are, not the day and time the Government would be hoping the EU Council would agree to. As such, logically, the Act makes clear that the Government could not propose a statutory instrument that would stipulate a date or dates for exit day different to the date on which, as was agreed at the time, the treaties would cease to apply. In short, the power to redefine exit day as set out in the 2018 Act passed by this House only last year only arises if the date has already been changed. Those who... Happy to give way.
Thank you, Mr. Does the Shadow Minister agree with me that it refers to a date? Therefore, wouldn't it be more logical for this statutory instrument to have the 12th of April down, and if that date needs to be changed, it should be changed subsequently? I don't understand how we can have two dates in a statutory instrument.
I thank the honourable gentleman for raising that point, and he's raised it before in recent days. I think you can do it either way is the short answer. There's the difference of legal opinion as to which creates the least amount of confusion and potential for legal challenge. But the Government has decided to do it this way, and we support the SI as a means to do so. In short, Mr. Speaker, I want to get back to the fact that those who take issue with the sequencing, or the mere fact that this statutory instrument is before us at all today, do so because they are opposed in principle to an extension to the Brexit process beyond Friday the 29th of March, either because presumably they're relaxed about leaving with a deal or positively wish for such an outcome. Happy to give way.
I'm grateful for the opposition's support. Isn't the bottom line that we are extending Article 50 via this SI tonight to avoid the damaging no-deal exit that my constituents in Winchester, and I'm sure his constituents, do not want to see? And this House has expressly said on several occasions now, and I predict will again this evening, it does not want to see.
Thank the honourable gentleman for that intervention. I agree with him to the extent that we have to do everything possible to avoid a disastrous no-deal exit. This SI does not do that. The extension agreed by the Council in the UK does that. This SI ensures that our domestic legislation aligns with what's already been agreed and doesn't create legal confusion. It's certainly the case, Mr. Speaker, that no one, including those who have no problem with an extension, expected that this government would fail so miserably that an extension of any kind would be required. But it was always a possibility, Mr. Speaker. That is precisely why the EU withdrawal bill, at least in its original form, was drafted to provide for circumstances in which a withdrawal agreement came into force later than the 29th of March following an extension. As the government itself put it at the time in its delegated powers memorandum, and I quote, "Exit day will be dependent on the withdrawal negotiations with the EU." As my right honourable friend, the member for Wallasey, has already commented upon, it was the government's decision to play politics with the issue of exit day for the purposes of our domestic legislation, constraining the flexibility provided for in the original drafting of the bill by putting a fixed date and exit time on the face of it in a vain attempt to curry favour with the hardliners on their own benches. That means we require a statutory instrument in the form that is before us. That said, it remains the case that it is simply not reasonable to question the legitimacy of the government's actions in agreeing to an extension to the Article 50 process, or the fact that this regulation has sequentially followed that agreement.
I want to correct him on his account of recent history. In fact, the government agreed to put the date in voluntarily and then were blackmailed by the Remain faction in our party to put flexibility into the date. That's actually what happened.
I think he'd agree with me the original draft of the bill did not include it. The reasons that the government put it in and the actions of the right honourable gentleman, the member for West Dorset, and again helpfully coming to the rescue, I leave to him and his view of what happened at the time. It follows, Mr. Speaker, that if this House voted against this statutory instrument, it cannot prevent an extension of the Article 50 process taking place until at least one of the two proposed dates. In short, Mr. Speaker, and much to my delight, there is nothing that honourable and right honourable members opposite can do today to force the UK out of the EU in 2 days' time. All that would be achieved by voting against this regulation would be immense legal confusion, with two parallel sets of regulations in place, those deriving specifically and directly from EU law and those made under the 2018 Act, which would diverge from it. As the Minister opposite put it, our statute book would be in a complete mess. And that is why, Mr. Speaker, this statutory instrument should self-evidently be supported, and why we will be doing so on this side of the House when we divide on it.
Thank you. Sir William Cash.
Thank you very much, Mr. Speaker. The first point I'd like to raise is regarding the ministerial code and the actions of the Prime Minister. It is quite clear under the ministerial code, and I'm glad to see the Attorney General is sitting here on the front bench, that the law officers must be consulted in good time before the government is committed to critical decisions involving legal considerations. Now, even if I was prepared to concede, which I'm not, that it follows that the law officers don't necessarily have to divulge their opinions, though actually he's been obliged to do so by a resolution of the House on the 4th of December in the past. The question is, as a matter of fact, which the Prime Minister today and 2 days ago has resolutely refused to answer me, did the Prime Minister consult the law officers as a matter of fact? I asked her and she refused twice. The inference is that she did not. Is this not misleading the House? That is a question which worries me intensely. Mr. Speaker, having dealt with that issue, which I regard as very serious, I also have to say that I take the strongest possible objection, as do many other distinguished lawyers, QCs and former judges, to the action that has been taken by the government in purporting to enter into a binding agreement in international law which purportedly alters the UK's exit date from the European Union in advance of the votes by each House on the draft regulations, which would create an alteration to exit day in the European Union Withdrawal Act 2018. It has been suggested, Mr. Speaker, that the Act requires that the draft regulations can only be submitted to each House for an affirmative resolution once the date of exit has been altered at international level. This is simply not correct. The provision for approval by affirmative resolution is a freestanding provision in Schedule 7, paragraph 14, under which a draft instrument is to be submitted to the House. It was incumbent on the government, Mr. Speaker, to respect the normal practice of allowing Parliament to approve any legislative changes before entering into a binding international obligation. Mr. Speaker, I was the Shadow Attorney General during the Iraq debacle, and I have to say, Mr. Speaker, that on that occasion it became apparent that there should have been consultation with Parliament on a matter of the gravest national importance. And the reality is, if I may say, obliged or created the circumstances in which the then Attorney General submitted his opinion to the House. We had a similar situation with regard to the issue of the bombing of Syria more recently. So the idea that Parliament is not required to approve any legislative changes before entering into a binding international obligation is well established recently in precedent. The course taken seeks to present Parliament with a fait accompli, in which Parliament is pressured to approve the draft regulations because failure to do so would cause disconformity, it is alleged by the Minister just now, between the UK's international obligations and domestic law. Under our constitutional law, Mr. Speaker, the power of the United Kingdom Government to conclude binding agreements with states and other international actors, such as the European Union, exists under the royal prerogative. It is a basic principle of our constitutional law that the royal prerogative may only be exercised consistently with the intention of Parliament. Any purported exercise of that power, of the royal prerogative, that is inconsistent with the intention of Parliament, is unlawful and of no effect in our internal legal order. I am troubled, and this is why I asked in an intervention, as to what the outcome was of the Joint Committee on Statutory Instruments today, and I made the reference to the question of whether or not there was proper consideration of the question of whether or not it was intra vires or ultra vires. I do not know the answer to that question, but it's because I haven't been given the information. And I asked the Minister to check whether that was the case. Did they consider the question of vires in relation to the issues before that committee today? Now, the intention of Parliament, Mr. Speaker, is to be found solely in Acts of Parliament. It is not shown by resolutions of the House of Commons, unless an Act of Parliament itself says otherwise, such resolutions in practice do not have effect. Under the principles of public international law, a state is entitled to invoke the fact that its apparent consent to be bound by an international agreement has been expressed in violation of a provision of its internal law, if the violation is manifest, defined as it happens in the words, quotes, objectively evident. and concerns a rule of internal law of fundamental importance, and I refer here to Article 46 of the Vienna Convention. These criteria are clearly satisfied, so that on the face of it there is a manifest violation of our internal constitutional law. It is completely and totally unlawful, and it is absolutely abominable that we should be faced with having to vote on the specious grounds of a so-called uniformity, which the Minister has put forward. I don't blame him personally, because, quite frankly, I forgive him. I ask him to forgive me for suggesting that he's taking advice from other persons who are purporting to be learned in the law. But I'm afraid they are entirely wrong. That is the point. And Lord Panic himself, only yesterday, raised these very questions himself. And Lord Panic, of course, is a most distinguished lawyer. In fact, he was the lawyer for the plaintiff, Gina Miller, in the case which required the Act of Parliament, the Notification of Withdrawal Act. Lord Panic knows what he's doing. In fact, I go so far as to say I actually instructed him with others in relation to the Rees-Mogg case back in 1993. So I know a little bit about the brilliance of Lord Panic. Lord Panic says the legal concerns which some lawyers have expressed is that the power to specify the day and time when the treaties have ceased to apply is not satisfied by identifying two possibilities. It is not possible, if this SI is enacted, to identify exit day simply by reading it. He draws attention to this point. But I think it is worth considering the fact that Lord Panic is not to be taken for granted, and indeed, for that matter, the Lord Panic has raised serious doubts about this matter, Mr. Speaker. I'll certainly give way.
But I think the House will be relieved to know that it is to be spared a dilation on the matter of Lord Panic's involvement in the Rees-Mogg case, of which sparing I think I can comfortably be reassured by the honourable gentleman. Very good.
Completely, because I don't need to dilate on that question whatsoever. I am simply making the point as a point of reference. Now, Mr. Speaker, with respect to the draft regulations, they contain unlawful sub-delegation. The draft of course, I give way.
I thank my honourable friend for giving way. If what he says turns out, in fact, to be the case, what is the consequence if the government did make this decision and it turns out to be the decision was taken unlawfully or out with the scope of this place?
They're not the regulations are not binding and they're invalid in law. It's as simple as that. The draft regulation, and it's a serious matter, because this is. Let us get back to the question from the point of view of the people listening to this debate outside Parliament. This is not just a question, Mr. Speaker, about a question of process. It is about the fact that as we speak, as I speak at this moment in time, under the provisions of the Withdrawal Act, we are intending to repeal the European Community Act 1972 on exit day, which is the 29th of March. That is the law of the land, subject only to this rather esoteric question about the commencement order, which can be resolved in 30 seconds by a minister coming to the table and saying, I now say that this commencement order is now in force. It's as simple as that. It doesn't require anything more than that. So we are talking about something which goes to the heart of the referendum decision itself, the democratic decision of the British people, which was that they wanted to leave the European Union and that was to be on the 20th. And by the way, just one moment, if I may. The House of Commons voted by 499 to around 120 for the Notification of Withdrawal Act. The House of Commons voted for the Referendum Act and gave to the British people, contrary to the rubbish that I hear all over certain parts of the House, that somehow or other Remainers in Parliament have a right to be able to take back that decision from the people. It was given to them, and they decided by 17.4 million that that was their decision. This Parliament has no right to take that decision back from them. Yes.
I'm very grateful to my honourable friend, the member for Stone, for giving way, and I never knew that we were going to have such a treat this evening, and so it's a great pleasure, Mr. Speaker, to have the opportunity to ask my honourable friend a question. It so happens that I've got a copy of the European Union Withdrawal Act with me, and it does say in Schedule 7, paragraph 14. Actually, Mr. Speaker, it was completely by chance, because I had no idea that my honourable friend was going to dilate on this matter. But then I heard the member for Brent North saying, first of all, the word deviation, as if this were some sort of BBC panel show, and second, I heard him from a sedentary position saying, I have no idea what my honourable friend from the member for Stone is talking about. It turns out that Schedule 7, paragraph 14 says, very clearly, a statutory instrument containing regulations under Section 24, which, for the benefit of the member for Brent North, is the section of this Act by which exit day is changed, so it's hardly a deviation, may not be made, unless a draft of the instrument has been laid before and approved by a resolution of each House of Parliament. So it occurs to me, Mr. Speaker, and I invite my honourable friend to agree with me, that he's doing an enormous service to this House.
I'm extremely indebted to my very good and very close friend, and I simply say this, that I'm so glad that he's made that point, because I am simply trying to do what I've always tried to do, which is to get past all the fog and ask the central question, which bears on the issue of the sovereignty of this House in relation to that referendum act which gave the right to the British people, and the 2008 Act to which he refers is the moment in time when we made that decision in this House, and even the member for Rushcliffe voted for the third reading of that Act. So this was a decision that was taken by this Parliament. So forget the fact that these indicative votes which are going on at the moment, which I regard as a parliamentary bag of licorice all sorts, is going through a process at the moment of some kind of obfuscation of the fundamental issues, because the draft regulations published yesterday, or a few days ago, are not in accordance with the 2001-8 Act, since they do not change exit day to a particular date. Instead, they purport to change exit day to two different dates, which is the point Lord Pannick referred to, depending on whether the House does or does not pass a resolution which satisfies the European Council decision. The words does not satisfy the European Council decision, Mr. Speaker. I have raised this repeatedly. We have been supplicating the EU. We have given in to the EU. My European Scrutiny Committee last March made a very good report, and we pointed out that we should not accept the terms of reference that had been dictated to us by the European Union. That's where it all went wrong. And it then went wrong when the Withdrawal Act was overtaken by the Chequers Agreement on a pre-planned operation inside Number 10, driven by the Prime Minister and her advisers, the effect of which was to undermine the repeal of the 1972 Act. And I say pre-planned because, actually, we passed the Act on the 26th of June by royal assent, and within 10 days, the Chequers proposals had come forward, which morphed into the withdrawal agreement and Article 4, the effect of which is to make us subjugated to the rule-making of the European Union. That is what went on, and it was done deliberately, and it was going on while we were actually passing the Withdrawal Act itself. It was a monstrous, I would describe it as a deceit on the British people. And I would go further and say that in respect of the course taken by the government of seeking to preempt the affirmative resolution, this has definitely contaminated the lawfulness of its actions and has, at a minimum, created serious doubts about the legal situation. And I would draw attention, for those who would be interested, in the views of the retired Lord Justice of Appeal, Sir Richard Akins, who is entirely clear on this question. So I simply say, I wrote a letter to the Prime Minister yesterday. I have not yet had a reply. She has not, in fact, answered my question about the Ministerial Code, which I've asked for twice. And as far as I am concerned, Mr. Speaker, this statutory instrument should be voted down, and I invite the Attorney-General to explain whether as a matter of fact, irrespective of whether he's prepared to disclose his advice, which I think he should publish, whether or not, in fact, the Prime Minister did consult him as required under the Ministerial Code.
Indeed. The honourable gentleman has concluded his oration. Thank you. Thank you. Tommy Shepherd.
Thank you, Mr. Speaker. So it seems we are not to leave the European Union on the 29th of March after all. Let me begin by offering my commiserations to the honourable member from Rayleigh and Wickford and his associates in the European Research Group. I appreciate this must be a difficult time. I fear that commemorative memorabilia may need to be scrapped, the champagne orders may need to be cancelled. Indeed, the bunting will have to be put back in the attic as Freedom Day celebrations are cancelled throughout the land. But it seems to me, Mr. Speaker, that the inconvenience and disappointment of the hard right faction in this Parliament is a small price to pay in order to see if we can save the country from catastrophe. Now, Mr. Speaker, the gravity of this situation means that it is not a moment for schadenfreude, so I shall refrain from seeking any pleasure in the disappointment of others. But I do think that we need to point out in this debate that the fact that we are discussing this statutory instrument here tonight can only be seen as nothing other than the abject humiliation of the British government in this process. Not only because, on more than 100 occasions, they have foolishly come to that dispatch box and reassured us that we would be leaving the European Union on the 29th of March, but also because, that having proven impossible, they now come and offer us a timetable that is not of their design, but one that is imposed upon them. If that isn't humiliation, I don't know what is. But, Mr. Speaker, as so many have said in recent debates on this matter, they have only themselves to blame. The fact that this is here before us tonight seeking an extension to the process is entirely a consequence of the way in which the process has been conducted by this government. From the word go, they were not interested in anyone's opinion but their own. The dialogue about how to implement the 2016 referendum result was constrained only to the voices within the minority Conservative government and their allies in the DUP, who I see are absent from our proceedings tonight. And that, Mr. Speaker, is shocking. It is shocking because what they should have done was to try and reach some sort of national consensus on how to proceed in this most divided of countries. But that is what they did, and of course in the middle of it they called a general election, and the Prime Minister asked the British people for a mandate to support the manner in which she was discharging the referendum result. And the British people refused to give it to her. Now, you would have thought that at that point, that would be the time to change tack, take stock and perhaps readjust. But no, they simply circled the wagons closer, bunkered down and spent the last 2 years negotiating with the European Union without reference to or a mandate from this Parliament. That is why we are in the situation that we are today. Now, I think what happens next, Mr. Speaker, is the real question. If we have the delay granted that the statutory instrument suggests, what are we going to do with the time that is afforded to us? And to my mind, that entirely depends on whether the government wishes to go forward with this Parliament in good faith or in bad faith. A bad faith way of going forward would be to regard the debates that we have had today and that we may well have in the future, to regard them as some sort of inconvenient sideshow, an irritation to be dispensed with before they come back yet again with a failed agreement, unaltered, to put before this House. That would be bad faith, and I think we saw some of it earlier on today, when the government actually tried to prevent us having the debates that we had this afternoon in the first place. And it wasn't a good look, Mr. Speaker. And actually, it is interesting that the Parliament rejected the government's position today by an even bigger majority than we did on Monday. And I would caution the government to have some humility now in the way in which it proceeds. A good faith way of proceeding would be to try and reach out and agree a new political consensus with other voices in this Parliament and in this country, in particular other political parties and the devolved administrations within the United Kingdom. That would be good faith. Now, it's a little surreal, Mr. Speaker, because we are discussing what to do with the timetable before we actually know the outcome of the votes that we have had earlier on. So I don't know yet what the mood of the Parliament is and the various options put before it. But I am concerned that when the government has talked about how it will respond to those decisions and those debates, it has suggested that it couldn't possibly contemplate supporting anything which it regarded as undeliverable. Now, I think we can all accept, Mr. Speaker, that everything has practical consequences, and we have to come up with proposals that are practical and that can be implemented. But I rather fear that the use of the word undeliverable in this context is simply meant to mean anything which conflicts with the draft withdrawal agreement they have with the European Union. And if that is the case, then that is another conceit to try and deny the will of this Parliament. Because the whole purpose of this exercise is that, having voted down the draft withdrawal agreement by such large majorities, we are genuinely engaged in a process to see if there is a route to a majority by some other means. And it stands... I will happily give way.
I thank the honourable member for giving way. Does the honourable member agree with me that the one thing that is genuinely undeliverable would be a no-deal Brexit, because we do not have the mechanisms, the trading mechanisms, that would make it possible to deliver a no-deal Brexit and retain the stability of the country?
I think that is self-evidently true. But what is deliverable is to go back to the European Union, remove the red lines and say we seek a new set of discussions with a new objective in mind. And my belief is that the European Union would respond warmly to any such approach in that nature. But I have to say that to those who are concerned now that we are caught into a process where the European Union itself is placing constraints on what we can or cannot do, our salvation is in our own hands. Because all we need to do is to revoke the notice that we served under Article 50 of the Act, pause the situation, and then we can take control of the process ourselves, without constraint or qualification or conditions being set by the European Union or anyone else. And it would seem to me that that is a sensible move that the government ought to consider. It was, of course, an unpardonable folly to serve Article 50 in the first place without having the first clue about the direction that it was going to lead to, which is why I and my colleagues at the time voted against it. Now, Mr. Speaker, doing that will take time, and unfortunately what we have before us tonight can only be regarded as an interim measure, because it doesn't get rid of the cliff edge, it just pushes it a few weeks into the future. I'm sure that we will have to come back to debate further statutory instruments and indeed further legislation which will allow us properly to change direction and negotiate better to form a better agreement with the European Union. But that will take time, Mr. Speaker, and it is not going to be done by the 22nd of May, which is why we might as well get used to the situation now and become acclimatised to it, that in order to get a better outcome, we need a long and significant delay in order to achieve that. And that, of course, means that we do need to prepare and get ready to fight European elections on the 23rd of May 2019. And I have to say, Mr. Speaker, I am becoming alarmed at the fact that, and it seems to be the people who wish to deny the people of the United Kingdom any say on how negotiations have turned out, they are also seemingly terrified of the prospect of facing the electorate on the 23rd of May and asking them who they want to represent them in the European Union. I don't even understand how the government negotiated an agreement which provided us, for this country, to be not represented at all in the power structures of the European Union while a transitional period of up to 2 years was taking place. That is ridiculous. We may stay, we may leave the European Union, but for as long as we are there, people in the United Kingdom have an equal right to be represented in those structures, as do people in any of the other 27 member states. So I say we should acclimatise ourselves now to the idea of fighting these elections, and I say also it would be a good thing. I know it will be an embarrassment for some people who thought we'd get it all done and dusted by now, but it's proving to take a little longer than people thought. And that means that as we are taking whatever time is required, we should be represented. I would predict two things if we would have had these elections on the 23rd of May. The first is that the turnout would be considerably greater than the 35% who voted in 2014. And the second would be, and I will hope to be judged in this, that the main losers in those elections will be the UK Independence Party, who fluked the result last time. Now, whether or not people respond to those elections will depend on how this Parliament approaches them. If we are seen to be dragged kicking and screaming to those ballot boxes, it will not be a good look. But if we embrace the opportunity for people in this country to have their democratic say, we may, in fact, be able to change the narrative completely on how this matter is being addressed. We may be able to get rid of much of the ill-tempered debate that has taken place and begin the process of political healing in this country. So, Mr. Speaker, that's why we will not offer any objection to this statutory instrument here tonight, but I say it is only one small step along a much longer road that we now need to take.
Sir John Redwood.
Mr. Speaker, the mood outside this House is overwhelming that we should get on with it. And the nation heard the Prime Minister and Government promise on countless occasions that we would be leaving on the 29th of March 2019 with or without a deal. It's quite true, the Prime Minister always said she really wanted a deal and she expected to get a deal, but she never ruled out leaving without a deal, and she was right not to do so. Indeed, for many months, she used to say, no deal is better than a bad deal, and left open the possibility that what was on offer was so bad that it would be better just to leave. Now, I'm not someone who thinks we just leave. I think we leave with a series of deals, and I'm very pleased that the government has put in place the essential deals we need in order to leave. Of course, we needed an aviation deal and a haulage deal and a government procurement deal and all the rest of it. And those things have been sorted out, I'm told, over the long 2 years, 8 months that have elapsed since the original vote. And I'm very pleased that the government, in parallel, with constantly telling us it was going to get an agreement that we would like, carried on with so-called no-deal planning, which, as I said, is many-deal planning. It's having a series of lesser deals to make sure that things work smoothly so that we were in a good position, so that we had options. I wish to develop my argument a little. So the government put us in that position, and I think what we haven't heard from the Minister, but more importantly from the Prime Minister who is responsible for this, what the case is for this delay that we are now being asked to approve in United Kingdom legislation. Because it seems to be mainly geared to the idea that this House will accept the withdrawal agreement after we should have left rather than before we were going to leave. But we now learn that the actual deal offered was not allowing the government up until May or early June to put the thing through. The EU was very tough on the government and said you actually have to get the withdrawal agreement through before the official leaving date of the 29th of March under the previous understanding, leaving the government now only a couple of days to do that. And the question must be to the government, why has it taken so long to get this agreement into a shape which the House would pass? And why have they been so dilatory about presenting or representing this agreement, or even better, why didn't they renegotiate it to get it into a form where it might be worth considering again? Because there is, as the Speaker has rightly posed to the government, the issue of is there any point in constantly bringing the same thing back time and time again when the answer is negative? And the government has not really set out today, in the context of wishing a delay, why suddenly it would be different now that they've left it for so long, and why did they leave it so long?
if it was so time critical. They've had plenty of months from the original Chequers disaster when they first adumbrated this policy and had mass resignations from the government and the Conservative Party, through to today, when many more resignations later, there is still a considerable reluctance by sections of the governing party to vote for the withdrawal agreement. So I fear I'm not free to support this proposal this evening, because I think there hasn't been a good case for delay, and I don't think they've made the case with the public as to why we have to be let down when there was such a very clear promise embedded into the law, into the Withdrawal Act, which this Parliament passed. And I would recommend to the government that they think again about how they wish to use the time they are trying to buy. I also have a lot of sympathy with my honourable friend from Stone over the crowning irony of the position the government has placed us in, where they are claiming superior European law to do something that the Leave majority in this country does not want them to do, but they're not so sure of their legal ground that they want this House to actually endorse it, because they know otherwise there might be legal difficulties. But to do it on the very piece of legislation which is taking back control is just almost unbelievable. This House has rightly decided to back the vote of the British people and by a solemn statute say we are taking back control, and from the day that comes into effect, all laws and matters relating to government and public business will be settled in this House of Commons and not by the EU. And we're now told that the Prime Minister can have a conversation in an evening meeting around a council meeting in Brussels. She can be pushed off her request and given something completely different from her request, and we're told that trumps anything the UK Parliament does. Well, if you wanted to sum up why 17.4 million people voted the way you did, you couldn't do better than take that example. Yeah. We do not want this House sidelined or presumed upon. This House should decide when we leave the European Union, and it shouldn't have been settled in that way.
Sir Bernard Jack. I do beg the honourable lady's pardon. Angela Eagle and then other colleagues. Angela Eagle. Fewer than 29 minutes to go. Angela Eagle.
Thank you, Mr. Speaker. We've seen today elements of the Conservative Party in high dudgeon, or dudgeon, a dudgeon, or maybe they should be in the high dudgeon, but in high dudgeon about the fact that the Minister has brought a statutory instrument before us today to take away the cliff edge that they were relying on plunging this country over in order to get the kind of clean break, catastrophe Brexit that many of them secretly want. And I never thought in this House that I'd sit here and see considerable members of a government party, the party opposite, planning on that basis to cause such damage to our economic prospects and the prospects for prosperity for all of my constituents and everybody else's constituents. It's a period of history that I hoped I would never see. Now, the Prime Minister is entirely responsible for getting all of us into the mess that we've seen develop over the last few months, as she's repeatedly, after putting a definite leaving date onto the face of the original Withdrawal Act, put off the vote and put off the vote on her withdrawal agreement because she wanted, I believe, to face this House with an unpalatable choice between her deal, which many on all sides of the House have serious problems with, and the catastrophe of no deal. Now, in a modern, mature Parliament, I believe that that kind of process and that kind of choice should never be allowed to face us. And whether we voted leave or remain, whichever side of the argument we were on in 2016, we should not have been put in that position. And it was the date on the face of what is now the Withdrawal Act that allowed the Prime Minister to have the leverage that she somehow thought would work to her advantage. She's now been forced to resort to the leverage that we hear happened at the 1922 committee tonight, where she basically said, "Back me so you can then sack me," and gave another date, the 22nd of May, for when she would announce her departure. So now we have, whilst the country's future is still in the air and not decided, the horrible, self-regarding spectacle of the next runners and riders in the Conservative Party to take to see who will inherit the poisoned chalice that the Tory psychodrama of Brexit has injected into the body politic in this country. So I believe that the Minister's SI today is an inevitable consequence of creating a false cliff edge which was put there for blackmail purposes, but which, because there still remain many, many sensible, responsible people on both sides of this House, we have expressed the wish that we will not allow the country to plunge over. And I just want to take this opportunity to say that the Minister is correct to bring the SI, and the Minister is also correct to surmise that this Parliament will not allow the choice to be the catastrophe Brexit of leaving with no deal, and we will not allow this Prime Minister or any future Prime Minister to blackmail this country with those appalling and disrespectful, dangerous tactics. So I support the Minister's SI tonight. I hope that in due course we will be able to perhaps have a much longer delay, start this process again and do it properly with some of the kind of respect that we've seen develop in the indicative votes debate that we've had today, and the cross-party responsible debate that we've seen begin to develop, which we all know should have happened in this country when the Prime Minister crossed the threshold of Downing Street 2 years ago. She's got the process exactly the wrong way round. There's been permanent damage done to our economy, our prospects, our prosperity, and more than anything else, our reputation in the world, because this Prime Minister has got this so disastrously wrong. And I hope that whoever is her successor, they will not take this place as a place that can be blackmailed like she has, and that they will not play Russian roulette with the prosperity and the future of this country. Anyone who decides that that is a reasonable way to behave does not deserve the honour of being our Prime Minister.
Sir Bernard Jenkins.
Mr. Speaker, I thought the Right Honourable Lady gave the game away when, amid all her hyperbole and rhetoric, she betrayed her desire for a much longer delay. That is what the Remain majority in this House really want. And I was rather shocked to hear the Honourable Member for Greenwich and Woolwich say that this measure should be entirely uncontroversial. He might not have been listening, but certainly millions of our voters have been listening, and they were expecting to leave the EU on the 29th of March. And this debate for them comes as a very great disappointment, because this order cancels exit day for the 29th of March. And the way the Council decision was agreed is exactly why people voted to leave the EU, as my Right Honourable friend for Wokingham set out. History will mark this day as the moment that this House decided to start to turn against the decision to leave the EU and against the mandate upon which most MPs in this House were elected. So far, oh yeah, there are exceptions. I'm talking about the 85% of MPs votes that were cast for pro-Brexit parties. And so far, the EU's withdrawal agreement has been rejected for good reason, not least because it is so far from taking back control. One point I agree with the Honourable Member for Edinburgh East over our laws, borders and trade. And in fact, if this goes through, that next time the Minister brings an order to this House to implement an EU directive or a decision or a regulation, there will probably have been no Minister sitting at the table in Brussels to agree that decision or even to be there to be outvoted. It will just be handed down through the withdrawal agreement. Now, Mr. Speaker, I've never considered myself a populist or a man of the people. But it is only those like me who will vote against this decision to cancel leaving the EU on the 29th of March who are truly representing what the British people decided in the referendum. We are the real majority in this House, which are so sorely underrepresented by members of this House. I'm going to press on. But this House is now embarked on an unprincipled. This House is now embarked upon an unprincipled constitutional experiment. PACAC, the committee I chair, recently heard from a retired Lord Chief Justice that nothing like this experiment has occurred since the recasting of the role of Parliament since 1688. That is just how radical this experiment is. And I very much recognise the sincerity of many honourable and right honourable members who are involved with that experiment, but they have resorted to the most questionable constitutional methods which leave no government or anyone else accountable for what is being decided. Who will the voters now hold to account for the outcome of the Brexit question? Moreover, this process has been supported by those either embarking upon embellishing the discredited withdrawal agreement with even greater restrictions on our right of national democratic self-determination, or seeking to disrupt or stop Brexit altogether, in defiance of the election promises upon which most of us were elected. I regret, therefore, to conclude on these matters, and including on this order, this House of Commons is left with questionable democratic legitimacy. I give way to my right honourable friend.
I absolutely endorse what my honourable friend has said, and to remind those members, including those on our own side, that they voted consistently for the Acts of Parliament to give effect to all the enactments, including the Withdrawal Act, and that to pursue these objectives is effectively to reverse their decisions on absolutely specious and unacceptable grounds.
I agree with my honourable friend, and I will vote against this order. Let me say just something briefly about the mess that we are now in. I can fairly claim to be one of the minority in this House who are authors of the voters' referendum decision, and I'm proud of that. Most of us who voted leave have stuck with what we believe one way or the other. We are not authors of what the Remain majority in this House, with the government, have made of Brexit, nor of what they continue to inflict upon our sad and disillusioned voters.
Thank you. Kirsty Blackman.
Thank you very much, Mr. Speaker. I can't promise that I'll speak without hesitation, repetition or deviation. I probably won't limit myself to a minute, but I'll do my best on all of those counts. To begin with, I'd like to start by saying that having an extension to the exit day is a good thing. Yeah. For a number of reasons, but the extension that has been asked for and the extension that we are discussing tonight is not the extension that we should be faced with. I want to look back at how we've got into this mess. Now, a number of people have mentioned the fact that people are expecting us to leave on the 29th of March. That is the expected date. When people voted in the June 2016 referendum, not one person mentioned the 29th of March 2019 as exit day, nor did they mention the 12th of April 2019 or the 22nd of May 2019. They voted on a proposition whether they should remain in or leave the EU. That was the proposition. No discussion was had about the actual exit date. The other thing is, while we're on this subject, nobody during that EU referendum expected that Theresa May would be Prime Minister. Sorry, the Prime Minister would be the Prime Minister. They did not expect that the deal that was presented before Parliament would be the deal, because this is not what was discussed during the course of the EU referendum. For anybody to say that this is the settled will of the UK people is absolutely wrong. I give way.
Speaker, can I just remind the Honourable Lady that David Cameron said that if the referendum resulted us leaving, he would trigger Article 50 the day after. He did come, but he didn't do that. He actually resigned.
One of the things about Article 50 is that it is a 2-year period with a possibility of extensions. Tabling Article 50 does not mean that you leave exactly 2 years after Article 50 is put in. There is a negotiation period. And anybody with any ounce of sense would, for a start, not trigger Article 50 until they were in a position where they could negotiate something that Parliament would agree with and that the people would agree with, but also would negotiate extensions on the basis of waiting until they are ready to leave before they actually leave.
The lady for giving way. I must say, Mr. Speaker, I'm not aware of David Cameron ever having said that he would trigger Article 50 the day after. The honourable gentleman shouts from a sedentary position. I just said I'm not aware of it. I'm certainly aware that the Leader of the Opposition said that. Yes. But can I ask the honourable lady, I'm sure she paid a lot of attention to the Leave campaign. Does she remember the Leave campaign making it very clear to the British people that we would not be leaving the European Union before a deal on our future relationship had been secured? And indeed, that absolutely has not been done by this government.
The Right Honourable Lady is, as ever, absolutely correct in this regard. It is the case that people were promised a number of unicorns. It is the case that a number of people on those benches still believe that those unicorns exist and are wandering around waiting for them to emerge in vain. The problem is that those unicorns do not exist. They never existed. They were promises that were made to the people of these islands that could never, ever have been met. I want to discuss the red lines that have been presented along this way. One of the biggest issues that we have with this whole situation is the red lines that have been drawn up and have been adhered to with some kind of iron grip. So there was red lines that were put forward that created the Chequers Agreement. The Chequers Agreement, if anybody sensible had been in the Prime Minister's shoes, they would have said the most important thing for our economy is to have a deal that protects services, because that is 80% of the UK economy. But what the Prime Minister did instead was she said, the most important thing for me is cracking down on freedom of movement. So I will do everything that I can in any proposition that I put forward to ensure that freedom of movement is cracked down on, rather than the economy is protected. So that was a ridiculous red line to begin with. The reason that we're in this situation over exit day, and it would be great if the ministers on the front bench could make this clear if there is any summing up at the end of this, the reason that we're in this issue over the exit date is because of the Prime Minister's ridiculous red line about the EU elections. It is absolutely ridiculous that it should be laid down that we refuse to take part in the EU elections. We are ready and willing and able to take part in these EU elections, and I think we would do rather well in those elections, in fact. And I agree with my honourable friend from Edinburgh East that actually UKIP would see a number of votes reduced and a number of seats reduced. And I was a bit shocked to see the member from Vauxhall earlier suggesting that the Labour Party should be courting those UKIP votes and trying to get those people who used to vote UKIP and now vote Labour to stay on board, because frankly there's a lot of those votes that I would rather not have if I was given that option. Now, I want to talk about the government's lack of preparedness in this. The Secretary of State for Scotland this morning suggested that the Scottish Government had not embraced Brexit and was not therefore prepared for the Prime Minister's deal to happen in the event of Brexit. But the UK Government is also not prepared for Brexit. That's why they're having to ask for an extension, even if the Prime Minister's deal had been approved or was approved this week. They're still not prepared for that Brexit to happen. Mr. Speaker, I sit on the European Statutory Instruments Sifting Committee. The Statutory Instruments Sifting Committee did not meet this Tuesday because there were no proposed negatives for it to discuss. It's not proposed to sit next Tuesday because there are no proposed negatives for it to discuss. I've been asking, does this mean that there are no proposed negatives left? But apparently what it means is that we're not getting a recess, and that in fact this committee will sit the week after and will discuss the proposed negatives during that week. The UK Government has failed at every opportunity to prepare adequately. It has set absolutely unreasonable red lines. What it should be doing now is going to the EU and saying, we need to have a longer extension so that we can adequately prepare. We are happy to take part in the EU elections as a result. And my preferred position is that we should have a people's vote. So there is a clear option given to the people. They can choose between the option of remaining in the EU or whatever deal this House thinks that it would like to put to them.
Yes. I thank the honourable friend for giving way. She's making an excellent speech and summing up brilliantly just the exact guddle that this Conservative government has got itself into. And is it not the case that it's the worst kind of loser that blames its opposition or its opponent for its own mess? And this government is not only completely screwing up the Brexit negotiations and the whole of the UK, but it is asleep at the wheel in government and cannot even replace its disability minister, offending and not properly representing people with disabilities across the UK. It is utterly shameful.
My honourable friend is absolutely correct. This is a complete and total mess. Not just over things like not being able to replace a disability minister. I understand that the Prime Minister has lost 28 ministers. The previous 3 Prime Ministers have reached about a combined total of losing 28 ministers during their time. The last issue that I want to raise, Mr. Speaker, is the issue of the fact that EU settled status is not sorted out. People's jobs, people's livelihoods and people's living standards, people's lives are being put at risk by the decisions and the lack of preparedness by this government. But we will be supporting this SI, we will be supporting the extension, but it should be a longer one.
Thank you. Mark Francois.
Thank you, Mr. Speaker. I'll try and be brief so that my friend Wantage can get in too. I'll have a go. Sorry.
One also wishes to contribute, so I know that he'll exercise enormous self-denying ordinance. Mark Francois.
Thank you, Mr. Speaker. We're debating tonight whether or not to extend Article 50. The thing I'd like to touch on very briefly is whether the EU would ever countenance a further extension. And I say this because from 2007 to 2010, when we were on those benches, I was the party's Shadow Europe Minister. I did the Lisbon Treaty working with William Hague, and that was my epiphany. 14 days in this place, couldn't change a single punctuation mark. That's when I realised we had to leave. But in those 3 years, I hope the Minister will accept, I spent a lot of time visiting the institutions of the European Union because that was my job. And I came to realise that for many people in the EU, particularly, though not exclusively in the Commission, what is often referred to as the European project has the status almost of a religious act of faith. People passionately believe in it, and it transcends almost all other considerations, and it must be promoted almost at all costs and protected almost at all costs. Very many people in the EU were utterly shocked when the UK voted to leave, absolutely stunned, because what we had done in their world was an act of heresy. It was apostasy to leave. And many people believed we should be punished, not least pour encourage les autres. But what they're even more worried about, is the UK taking part in European elections, which would bring 73 UK MEPs into the Parliament, many of whom would be likely to be Eurosceptic, though not all, which would completely upset the calculations that they have made, as it were, to reconfigure the new Parliament in order to keep out what they call the populists from Eastern Europe and, for instance, the Lega Nord from Italy. That is why they wouldn't accept the extension to the 30th of June. They insisted either on the 22nd of May or the 12th of April, which is the drop-dead date for when we'd have to begin European election preparation in the United Kingdom. So my argument, Mr. Speaker, very simply is this. I believe for the EU, protecting the integrity of the Parliament, which under the co-decision procedure under Lisbon has much greater power now relative to the other institutions, would be even more important to those who really believe in the project than trying to keep the United Kingdom in the EU, though many would like that. And therefore, if I'm right, they would not countenance any further extension beyond the dates that have been given, because it would muck up the European Parliament, and from Macron's point of view, that would spoil his plans to federalise the European Union. So my argument, Mr. Speaker, is we shouldn't be worried about a very long extension, because I believe, though I cannot prove it in the House tonight, they'll never grant it. They don't want, under any circumstances, to go beyond the 12th of April, because it means European elections that they simply cannot stomach, because there'd be 35 to 40 Eurosceptic British MEPs that completely rip up their plan for the Parliament. So I believe, yeah, I'm going to finish. I believe on that, I'm going to give one. And I believe on that basis, Mr. Speaker, the threat of a long extension has always been a false one, and if we get to the 12th of April, we can leave. Because I believe that those who believe in the project would not allow the extension. And finally, the government spent £9 million sending a document to every household in this country before the referendum saying this is a once-in-a-generation decision, this is your decision, and we will implement what you decide. If the people in this House overturn that decision, the people will be extremely angry. Don't say you weren't warned.
Is the Right Honourable Gentleman giving way, or has he completed his speech? He's finished. Yeah, well, very good of him to guide me. But in fact, I was going to call Mr. Double and then Mr. Basie. But no, both of you. Oh, but you can divide it between you.
Speaker. Thank you, Mr. Speaker. There have been many very good speeches made this evening about the validity of this instrument that we are being asked to vote on tonight. But what I want to talk about very briefly is what I believe what is taking place here tonight looks like to the British people, particularly the 17.4 million people who voted to leave the EU. Because many of the British people have put their trust in this place when we have told them that we will be leaving the EU on the 29th of March in just 2 days' time. And tonight, passing this statutory instrument to delay that date, I believe is a break of trust with the British people who have trusted us, taken us at our word when we said we would be leaving at the end of this month. And I believe that there are many people who are concerned that Brexit is being stolen by the establishment of this place, and the passing of this instrument tonight is another step towards that taking place. But the other thing I want to say, Mr. Speaker, is that many people will feel this is wrong for the very reason that has been made many times, that we've been told that we don't have a choice tonight, that the EU have already made this decision for us, that the date we're going to leave is going to be delayed, and it's irrelevant what we do tonight because the decision has already been made, and therefore we should just pass it through. If we wanted an example of why many of the 17.4 million people voted to leave, that is it. It is that this House, any pretence that this House has sovereignty over our own rules. We can't even decide for ourselves the date we're going to leave. We've been told by the EU. We couldn't even get the date that we wanted, that they negotiated away. And therefore, tonight, Mr. Speaker, I will be keeping trust with the word we gave the British people when we said we'd be leaving on the 29th of March, and I will not be supporting the statutory instrument tonight.
Edward Vasey.
Well, Mr. Speaker, everyone on this side of the House has spoken against the statutory instrument. I've just got time to say I fully support it, and I cede my place to the honourable member.
Mr. Speaker, this government has had half the time it took to fight the Second World War. It has had 2/3 of the time it took to fight the First World War. it has had the entire length of the Kennedy administration, in which the groundwork was laid for a successful moonshot. The idea that we need more time is nonsense. They have had plenty of time, they have not used it well enough, and we should just leave.
Mr. Weststreeting.
Thank you, Mr. Speaker. I would just thank you, Mr. Speaker. I just further to that excellent speech, I would just point out that it took 7 years to organise a 2-week sporting event in the London Olympics. So I think extracting ourselves from the most sophisticated and political economic alliance in the history of the world probably does take a bit longer.
Thank you. Order. Under the standing order, I must now put the question. The question is motion number 4, as on the order paper. As many as are that opinion say aye. Aye. Of the contrary, no. Aye. Division! Clear the lobby. Order. Order. The question is motion number 4, as on the order paper. As many as are there opinion say aye. Aye. Of the contrary, no. Tell us for the ayes, Mike Freer and Joe Churchill. Tell us for the noes, Mr. Peter Bone and Mr. Philip Hollowbone. Order! Order!
The ayes to the right, 441. The noes to the left, 105.
The ayes to the right, 441. The noes to the left, 105. So the ayes have it. The ayes have it. Unlock. Order. I will now suspend the House until the outcome of votes on motions. Let me advise the House. Let me advise the House that it was very much the hope of our extremely dedicated professional staff that they would be able to provide the results of the indicative votes to be announced immediately after the result of this division, but that has not proved possible. I don't expect the suspension to be very long, but I will suspend the House until the outcome of votes on motions relating to the United Kingdom's withdrawal from and future relationship with the European Union are available. The division's bell will be rung 2 minutes before the House resumes. Order! Order! Order. Order. I can now announce the result of today's recorded votes on motions relating to the United Kingdom's withdrawal from and future relationship with the European Union. In respect of Mr Barron's motion B, brackets no deal, the ayes were 160, the noes were 400, so the noes have it. In respect of Mr Nicholas Bowles' motion D, Common Market 2.0, the ayes were 188, the noes were 283, so the noes have it. In respect of George Eustace's motion H, EFTA and EEA, the ayes were 65, the noes were 377, so the noes have it. In respect of Mr Kenneth Clarke's motion J, Customs Union, the ayes were 264, the noes were 272, so the noes have it. In respect of the Leader of the Opposition's motion K, Labour's alternative plan, the ayes were 237, the noes were 307, so the noes have it. In respect of Joanna Cherry's motion L, revocation to avoid no deal, the ayes were 184, the noes were 293, so the noes have it. In respect of Dame Margaret Beckett's motion M, confirmatory public vote, the ayes were 268, the noes were 295, so the noes have it. In respect of Mr Marcus Fish's motion O, contingent preferential arrangements, the ayes were 139, the noes were 422, so the noes have it. I'm finishing my statement. I don't require any help from the government chief whip. The list showing how honourable... He'll learn, so he should listen, he'll learn. The list showing how honourable and right honourable members voted will be published in the usual way on the Commons Vote app and website and in Hansard. Point of order, Sir Oliver Letwin.
Yeah. Thank you, Mr Speaker. Mr Speaker, it's very disappointing. It is, of course, a very great disappointment that the House has not chosen to find a majority for any proposition. However, those of us who put this proposal forward as a way of proceeding predicted that we would not this evening reach a majority, and indeed, for that very reason, put forward a Business of the House motion designed to allow the House to reconsider these matters on Monday.
No, that's ridiculous. No. Ridiculous.
No, perhaps colleagues would do the right honourable gentleman the courtesy. Yes, I say to the right honourable gentleman, the member for Derbyshire Dales, I'm not asking him, I'm telling him that the right honourable gentleman will be done the courtesy of being heard. That is the beginning and the end of the matter. Sir Oliver Letwin.
Yeah. Thank you, Mr Speaker. And if on Monday the House is able to reach a majority view, I think that would be in the interests of our constituents and of the country.
Waste of time. Ridiculous waste of time. Crazy.
But I personally continue to harbour the hope that my honourable and right honourable colleagues will see fit to vote in favour of a government motion between now and close of play on Friday, which would obviate the necessity for a further set of votes on Monday.
Thank you. Yes, the Secretary of State for exiting the European Union. Point of order, Mr.
Further to the point of order from the member for West Dorset, the House has today considered a wide variety of options as a way forward, and it demonstrates that there are no easy options here. There is no simple way forward. The deal the government has negotiated is a compromise, both with the EU and with members across this House. That is the nature of complex negotiations. The results of the process this House has gone through today strengthens our view that the deal the government has negotiated is the best option. Furthermore, Mr. Speaker,
must be heard. The Secretary of State.
Furthermore, Mr. Speaker, although this was not a significant feature of today's debate, any deal must include a withdrawal agreement. It is the government's firm wish to get the withdrawal agreement approved by this House, and I urge all members, no matter the view on what the future relationship should be, if you believe in delivering on the referendum result by leaving the EU with a deal, then it's necessary to back the withdrawal agreement. If we do not do that, then there are no guarantees about where this process will end. It is for that reason that I call on all members from across this House, in the national interest, to back the Prime Minister's deal.
A point of order, Mr. Ian Blackford.
Thank you very much, Mr. Speaker. I mean, this is a very serious moment for all of us, and we have to reflect that this House of Commons has tried to find a way through the Brexit crisis over the last few months, and we have failed. And we need to reflect on the fact that when the government talks about bringing their deal back, that on 2 occasions the government got 202 and 242 votes. That deal should be dead, and indeed the People's Vote got 268 votes tonight. I know we didn't win, but we got more votes for the People's Vote than the government did for its proposition. Mr. Speaker, I think it is becoming increasingly clear that this House cannot find a way forward. This government, this Prime Minister, has failed to provide leadership. The only thing we should now be doing is going back to the people of the United Kingdom in a general election to end this impasse.
I'm grateful to the right honourable gentleman. Point of order, Sir Patrick McLaughlin.
Thank you very much, Mr. Speaker. Can you confirm that if we follow on from your ruling earlier on today, none of these other questions can be put again?
The particular process that has been set in train as a consequence of the business of the House motion is a discrete process. It is the first time it has been conducted. It was approved by the House, and therefore my understanding... No, I'm not debating the issue with the right honourable gentleman. He has more or less courteously raised the point of order with me, and I am responding to it. I'm not going to conduct a debate with the right honourable gentleman. My understanding of the situation does not entirely cohere with his, and I have explained that I think that the motion passed by the House expressed support for a 2-stage process, and I will, for the time being, leave it there. And I'm extraordinarily grateful to him. No, as I've just said, I'm not debating it with him. Point of order, Anna Soubry. Point of order, Anna Soubry. Point of order, Anna Soubry.
Mr. Speaker, as somebody who has been called by the Speaker.
Order, let me just explain. Order. Let me just explain one thing in this place. The Right Honourable Gentleman is a very senior member of this House, and he is a former Chief Whip. He is not the Speaker of this House, and it's not for the Right Honourable Gentleman to presume the order in which matters are considered, and I trust that he won't suppose that it is for him to do so. Let me say very gently to the Right Honourable Gentleman, I treat him with respect. I'm not intimidated by the Right Honourable Gentleman, and I'm absolutely sure he wouldn't seek to intimidate me. I am taking a point of order from the Right Honourable Lady, and frankly, that's the situation. Point of order, Anna Soubry.
Mr. Speaker, the country is watching this. And I gently say to the honourable gentleman, I can shout as loudly as anybody, but let's try to remind ourselves what we've decided to do. Nothing. And some of us have been involved in the debates and the discussions about the procedure from the outset. It's very well people coming at the end of all of this. Let us remind ourselves this was a I can patronise as well. This was a two-stage process. So today was our attempt to see if there was anything we could settle on, but to look where the biggest votes may be. The Prime Minister's deal secured 242 votes. The amendment motion J, supporting a customs union, got 264 votes. And beating all of them was the People's Vote with 268. May I suggest, Mr. Speaker... May I... You don't need to shout it out. May I suggest...
like any other honourable or right honourable member, to be heard. And she will be. Anna Soubry.
Thank you, Mr. Speaker. So may I suggest we now proceed to the agreed procedure that the House adopted, that having settled on those matters where there were the biggest votes, we now go forward to Monday to see if we can find a compromise so that we look to how we are going to give this country the leadership and the certainty it needs and deserves. And finally, Mr. Speaker, if honourable members didn't try and shout me down, I might have finished 2 minutes ago. So may I suggest that we continue with our agreed procedure, because if we do settle on a deal, it's becoming increasingly obvious that then that deal needs to go back to the British people, and that's what we need to do. See if we can arrange that on Monday.
Well, I note what the Right Honourable Lady has said, and as a matter of fact, the business of the House motion having been passed, the process is established. And the process, and I say this for the benefit of colleagues, but also for the benefit of those attending our proceedings who are not members of the House, the process is that a second day, Monday, has been provided for. I'm not investing that point with any spin one way or the other. It's not for the chair to do. I am simply reporting to the House the factual position. That is the reality of the matter. It's no good somebody saying rubbish. That is the reality of the matter, because it is that for which the House of Commons voted. A point of order, Mr. Mark Francois.
Thank you very much, Mr. Speaker. Mr. Speaker, after many hours of debate and an extremely complex procedure, the House of Commons has decided sweet Felicity Arkwright. I think the public will look on these proceedings in utter amazement. They will be completely bemused by what has gone on. This attempt to seize the order paper has failed. The second referendum has been defeated. The revocation of Article 50 was smashed. And surely the last thing we want to do, Mr. Speaker, in the eyes of the public, is on Monday go through this farce all over again.
The truth of I say this for the benefit who've not heard this interaction before. Having known the... Yes, it's important. Having known the... Yes, he has and I have, but others haven't. He and I have known each other, I say it in a very good-natured spirit to the right honourable gentleman. He and I have known each other for 35 and a half years. And knowing him as well as I do, I know he's more interested in what he has to say to me than in anything that I have to say to him. But the simple fact of the matter is that a process has been decided upon. It may well be that it does not suit the palate of the right honourable gentleman. We will have to see what is said tomorrow and by other colleagues. But I repeat, I don't think he really wants much of a response from me. I respect the right honourable gentleman greatly, as he knows. I've heard what he said, the House has heard what he said, and I now want to hear what the right honourable... Oh, just wait a moment. Patience. I don't mean any unkindness to honourable members, but actually I think at this point I will hear from a former leader of the House of enormous experience and who had a motion before us today. Point of order, Dame Margaret Beckett.
Thank you, Mr. Speaker. I'd be grateful if you could just correct or confirm my recollection. I don't know what anybody else expected, but I did not necessarily expect any motion to carry a majority today. Certainly not the one that I proposed, which, if I recall, has probably had almost the identical results of the one that it had the last time it was moved in this House. My understanding of the procedure instigated by the honourable gentleman for West Dorset was that we would first let 1,000 flowers bloom and see where we went, and that would expose some things which had perhaps little support, and that then we would seek to proceed to see whether ranking things in an order of importance made a difference. And I have to say to the Secretary of State, I thought it was somewhat extraordinary for him to come to the dispatch box and say this proves that the only thing to do is to go ahead with the Prime Minister's motion, which got less votes than many of those that have been before us tonight. Exactly. So perhaps you'll tell me, sir, whether my recollection, which seems to differ from that of some colleagues, is reasonably accurate?
Yes. And it is not for the Chair to adjudicate on the merits of the arguments, and I have not sought to do so. What I did seek to do, which I thought it was proper for the Speaker to do, was to facilitate the House by selecting a wide range of motions expressing different points of view and allowing those different, and in some cases contrasting, propositions to be tested. I would just very gently make the observation, again with a view to the intelligibility of our proceedings to a wider audience, that these matters have been debated over a lengthy period. Indeed, since the publication of the withdrawal agreement, a little over 4 months ago, I have chaired every single debate and every minute of every single debate and I think exchange in the Chamber on the matter. It is simply a statement of fact to say that in that 4-month and a bit period, the House has not reached a conclusion. So if the right honourable lady is asking me, I'm utterly astonished that today no agreement has been reached. I confess I'm not utterly astonished that after one day's debate no agreement has been reached. But that's the factual position. And I know the right honourable gentleman attaches very considerable importance to his next intervention, and I look forward to it with bated breath, beads of sweat upon my brow and eager anticipation. But not before I've heard that from the Right Honourable Gentleman Member for New Forest East. Point of order, Dr Julian Lewis.
Mr Speaker, is there any way within the rules of order that I can point out to what might be a bemused wider world that people were not having to choose between these different 8 options? They were able to vote for or against each and every one of them, and they voted against all of them. If I were an unofficial backbench Prime Minister, I would resign at this point, not seek to repeat such an exercise in abject failure.
Well, as it happens, I've known the Right Honourable Gentleman Member for New Forest East for precisely the same length of time, virtually to the day, that I've known the Right Honourable Gentleman, the Member for Rayleigh and Wickford. And the mental acuity of the Right Honourable Gentleman for New Forest East never ceases to strike me. However, I just very gently say, in relation to his proposition about being Prime Minister, backbench Prime Minister for the day, I'm not arguing with him, but I'm simply saying that in his case, the proposition is an academic one. The point, yes, I'm coming to. Yeah, oh, very well. I'll indulge the Right Honourable Gentleman. Point of order, Sir Patrick McLaughlin.
Well, thank you, Mr. Speaker, because you interpreted my earlier attempt of a point of order to argue with you. I was not attempting to argue with you. I was seeking to get a point of clarification. Because the clarification is this: I do find that these points of order that we've just had. I do find the most amazing thing is nothing has been said from the opposition front bench. But if we can just leave that to one side for 1 second, can you tell me how your ruling tonight and your response to my earlier point of order coincides with what you said about the government bringing back a meaningful vote? Because I think there was an inconsistency in your ruling, and I'd be quite interested to hear what the view was behind that.
I don't wish to disappoint the Right Honourable Gentleman, but I've made the point once, and I thought I made it clearly, and I think that, yes, I think I made it very clearly, and I think the Right Honourable Gentleman disagrees with it, but my position, the point that I was making, is this: the process for which the House opted was and is a discrete process, the first of its kind. Indeed, the novelty, to some people welcome, to others unwelcome, of the process was the subject of much comment earlier in our proceedings. I believe it is a process, and the House decided earlier that it should be pursued over a 2-day period. In those circumstances, with a specific balloting procedure set in train, I do not think that it falls into the category that the Right Honourable Gentleman has described. And if I may just also add to the Right Honourable Gentleman, I set out the position in respect of the same question in the same session on the 18th of March, and then on the 25th of March, that is to say on Monday of this week, in response to a question on her statement from the Right Honourable Gentleman Member for New Forest East, the Prime Minister signalled that she was well aware of the strictures that I had issued, and that if the government attempted to bring back its deal, it would ensure that, I think the words were, my requirements, the requirements that I had made, were met. So it was obviously in the Prime Minister's mind that there was a test that needed to be met, and I reiterated earlier this afternoon that test of change. And I don't honestly think it can usefully be argued further tonight. But no doubt there will be discussions in days to come, and we shall have to see what emerges. And I hope that that, at least in part, satisfies the Right Honourable Gentleman. He's not easily satisfied, but I hope it at least in part satisfies the Right Honourable Gentleman for tonight. The Attorney-General says it ought to. It ought to. And who am I to disagree on this matter with so learned and cerebral authority in the House as the Attorney-General? Point of order. I will come to colleagues. Point of order, Angela Eagle.
Thank you, Mr. Speaker. I note from looking at the results of today's round one of the indicative process that the Father of the House's motion on a customs union failed by a majority of 8, and the motion to have a confirmatory ballot failed by 27. And yet, the shadow Brexit secretary has argued that the government motion, which failed by 230 at its first attempt and by 149 at its second attempt, should somehow take precedence. Mr. Speaker, doesn't this strike you as rather... the Secretary of State, yes, of course.
Soon to be, shadow.
Sorry, I was just future gazing. Doesn't the Speaker, don't you, Mr. Speaker, think that this is rather an odd interpretation of the results that we've had so far?
Well, interpretations vary, and I think that's clear from the points of order. But the Right Honourable Lady has made her point with some force, and people will study it, I'm sure, in the official report, together with the observations of other honourable and right honourable members. And point of order, Sir Vincent Cable.
Further to this point of how to reconcile this evening's votes with your ruling earlier today, given that there were 2 votes today significantly in excess of what the government has achieved in its meaningful vote, significantly, would it not be appropriate now for the government to bring back its withdrawal agreement, amended to take account of the Leader of the House's changes, and also modified to allow for a confirmatory vote? And in that way we may reach some consensus.
Well, a variety of options is there for policy makers and parliamentarians and members of the executive, and the Right Honourable Gentleman has helpfully indicated what he thinks should be priorities in the important days which lie ahead. Point of order, Vicky Ford.
Mr. Speaker, thank you very much for taking my point of order. Last Monday, when you made it very clear that no identical vote should be put to the House twice, you also were very helpful in clarifying a point of order by myself that in deciding whether or not a vote was identical, you would take into consideration the conditions and circumstances in which members were having to make a decision on that vote. And since we last voted on the meaningful vote, there have been many other votes, including a number today. And many of my colleagues have indicated both privately and publicly that the conditions and circumstances therefore mean that they wish to change their minds. Not least the member for South East Cornwall, who's getting married on Saturday and has just told colleagues that she would like to support another vote on the withdrawal agreement. Given that time is pressing, Mr. Speaker, and a decision must be made before Cinderella appears on Friday night, please can we reconsider the conditions and circumstances around a meaningful vote?
I'm grateful to the Honourable Lady for a point of order. Some people may have changed their minds, others have not done so. The situation is as I've just described. I recognise the premium that the Honourable Lady attaches to the matter, but I don't have anything to add to or subtract from what I've already said, for the simple reason that I think that it has the advantage of being true and of continuing validity. Point of order, Kirsty Blackman.
Thank you much, Mr. Speaker. Mr. Speaker, notwithstanding the programme motion that says that we will be discussing this again on Monday and your earlier comments about the Prime Minister's deal and the possibility of bringing it back, have you got any intelligence about whether or not the House will be sitting on Friday? And if it is sitting on Friday, what will it be discussing?
The answer to that is at this stage I don't know. As the Honourable Lady will understand, that is not a matter first and foremost in my hands. It may be that colleagues will discover more tomorrow if they attend the business question. And again, I say for the purposes of the intelligibility of our proceedings, that after all is the weekly occasion on which we learn from the Leader of the House the intended business for the next parliamentary week, and I have a strong sense that colleagues will be in their places to listen to what the leader has to say and possibly to put questions to her. So enlightenment will come, not necessarily tonight, but in all likelihood tomorrow on that occasion or later in the day. A point of order, Mr. Kevin Foster.
Thank you, Mr. Speaker. I always listen with great interest to the rulings you give on procedure, and I very much listened with quite some interest to the ruling you gave earlier today. But on consulting page 332 of Erskine May, I'd be grateful for your views, in where it refers to Standing Order number 27, allowing the government to arrange its business in any order it thinks fit, and further goes to say, this far-reaching control can be further extended by the government, if the need arises, by inviting the House to agree to a motion suspending the relevant standing orders. I'd be grateful, on a point of order, you could clarify whether my interpretation of that, which would give an ability to bring a motion forward to bring another vote or to arrange the business, would be correct compared to your clearly earlier.
Gentlemen, I'm well familiar with Erskine May. The ownership by the House of its standing orders is a matter of established fact, which has been of long-standing significance. As to what happens in the period to come, we shall have to see. I'm extraordinarily obliged to the honourable gentleman, and I don't mean it in any spirit of discourtesy, but he hasn't told me something that I didn't know. And I'm deeply grateful to him, and I feel sure that he's pleased that he's made his point. Point of order, Kate Hoey.
Mr. Speaker, earlier today we voted in a business motion for the proceedings today and Monday. There was an amendment put down by my honourable friend, the member for Stoke Central, which would have allowed us to vote on section 2 of that motion, which was going to say we would not vote on Monday, that it was originally going to be one day of this special arrangement. You, Mr. Speaker, and I understand that you decided not to call that amendment. Given the problems now about Monday, would it not be sensible tomorrow to have a vote again on whether we actually want to continue with this on Monday?
Well, I'm grateful to the honourable lady. That is an innovative thought on her part. She said originally the position was going to be one day, and I don't mean this in any spirit of unkindness or discourtesy, but the answer is no. The original form of the motion specified 2 days, not 1 day, specified what the mover of it wanted rather than what she might have wanted. There was that alternative proposition. My own view was that the House would be keen to get on with the substantive debate on a vast miscellany of different motions, and that the House should be invited to decide the business of the House motion. The House decided the business of the House motion, and the business of the House motion specified 2 days. I absolutely understand that that doesn't please her, but that is the factual answer to the perfectly reasonable question that she has put to me. Point of order, Bob Blackman.
Thank you, Mr. Speaker. Clearly, the decisions taken tonight were to defeat all of the motions that you selected. But, of course, there were 8 other proposals which you chose not to put to the vote, which is absolutely your right, on which the House has not had a chance to reach a decision. Many of those proposals were signed by a number of members across party. Personally, I don't agree with most of them. However, we haven't tested the House's view on those. Could I therefore ask you, what is your intention about those that weren't chosen for debate? Can they now be considered on Monday for some form of testing the House's opinion?
My understanding of the intention of the architect of the process was that it was intended ideally to reach a conclusion in 1 day, but more likely to result in a shortlisting, and that therefore on the second day, with a narrower field of relatively popular, if not sufficiently popular propositions, it would be possible to reach a conclusion as between those remaining high contenders. So, off the top of my head, I wouldn't automatically have thought that it was the wish of the architects of the procedure, or most obviously the sensible course, to test those propositions that weren't selected in the first place. I'm happy to consider the point. I wouldn't have thought so. And I just say, and I know he's not criticising, he's asked his question in an extremely reasonable way, as he always does, but insofar as members might think, or others might say, well, what were those that weren't selected and why? The answer is I was making a judgment about the breadth of the issues, the numbers and range of support, and where there was duplication, as the honourable gentleman will attest there was, I was tending not, obviously, to choose two propositions on the same subject, but rather to arbitrate between competing claims. And it wouldn't seem to be obviously sensible simply to opt for the other of the two competing claims. I would have thought it was more sensible, if we have that second day, as the House has voted to do, to seek to make further progress from those that were tested today. That would be my instinct. I'm always open to representations from colleagues. Yes, very well. Point of order, Bob Blackman, and then I'll come.
I particularly refer to, the so-called Malthouse Compromise, which has signatures from at least 3 different parties, on which you didn't select for debate, so this procedure has not had the chance to actually test the House's opinion. Why could that not be brought back as a specific issue, given the range of support there is across political parties for it?
Well, I'm happy to consider the point. As I say, I thought that I chose a range of propositions that reflected the key issues in the debate and the key preferences for outturn. And I had some regard also, and I am speaking off the top of my head, of course, as colleagues can see, I had some regard also to a consideration which has always been adjudged to be important by members on both sides of the House and on both sides of the Brexit argument, namely the likely capacity to deliver an outcome. That was a factor in my mind, especially in view of pressure of time and the need to work with other partners. Point of order, Mike Gates.
Speaker, further to the earlier point of order from the member from New Forest East, he said that the temporary Prime Minister should resign. Have you had any intimation, given the 2 huge defeats for the Prime Minister, following her discussions with her parliamentary colleagues this afternoon, that the Prime Minister will be coming before the House in the next few days to announce her resignation?
Certainly received no such indication at all. I mean, the Prime Minister was here today, and the Prime Minister, to be fair, has been a most assiduous attender in the Chamber in making statements to the House and responding to questions, often for very appreciable periods of time. Obviously, she will be here next week. We fully anticipate and look forward to that for Prime Minister's questions. I've received no such notification, and obviously I'm aware of media reports, but I would not myself have been present at any meetings that took place earlier this afternoon for very obvious reasons. But the honourable gentleman has made his own points in his own way, with his customary style and puckish grin. Point of order, Nigel Huddleston.
Thank you, Mr. Speaker. You've commented previously that your determinations, your rulings in this place, depend on precedents and context and circumstances. Many of us believe that the context of a meaningful vote 3 have changed in the light of the votes this evening. Could you provide some guidance as to what would constitute context and circumstances changes in your mind, so that we can be assured whether or not a meaningful vote 3 is possible?
The honourable gentleman can readily extrapolate from things that I've said before on this matter. I made a very clear statement on the 18th of March, and I responded to a miscellany of questions on that occasion, possibly including an inquiry from the honourable gentleman. I don't recall for certain, but there might have been such. And on that occasion, I indicated that it seemed to me there was a matter not just of precise wording, but of thrust. What was the essential thrust of the proposition that was being put? Had it changed or had it not? I invoked evidence in support of the propriety of the second vote on March the 12th of the publication of documents consequent upon discussions that took place with the European Union. Those were examples, it seemed to me, of facts, of evidence, and of circumstances that were relevant. I note the opinion of the honourable gentleman that the situation has in some way now changed. He's perfectly entitled to that opinion. One has to look at the specifics. And if people come with specifics, then the specifics are considered. And as a wise and discerning fellow, and unfailingly fair-minded, I feel sure that the honourable gentleman will appreciate the wisdom of such an approach. Point of order.